Welcome to day 2. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for Budget Estimates 2026-27. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are in the room with us today. The Senate has referred to the committee the particulars of proposed expenditure for 2026-27 for the portfolios of Home Affairs and the Attorney-General and other related documents. These are budget estimates proceedings, and the outcomes to be heard during today's proceedings estimates are from the Attorney-General's portfolio. The committee has set Friday, 5 June 2026 as the date by which written questions or notice should be provided to the Secretariat. The committee has decided that answers to questions or notice should be returned to the Secretariat by 5 p.m. on Friday, 17 July 2026. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee that they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate has endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policies and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. Officers called upon for the first time to answer questions should state their full name and their position for the Hansard record, and witnesses should speak clearly into the microphone. The committee's proceedings today will begin with the Office of the Information Commissioner.
Thank you, Chair. Elizabeth Tidd, Australian Information Commissioner. I'd like to provide a brief opening statement, if that's acceptable, Chair.
Sure. I'll just check with the Minister first that he doesn't want to make an opening statement.
That's a very kind offer, but on this occasion I don't have an opening statement.
The committee's poorer for it, Minister. Thank you,
Thank you, Minister. I appreciate the opportunity to provide a brief opening statement to the committee on behalf of my colleagues, the Freedom of Information Commissioner Alice Lineker and the Privacy Commissioner Carly Kind. The OIC's remit is wide and our regulatory environment is dynamic, as demonstrated by our consistent and significant increase in community contacts, government and industry engagement and capability building, proactive initiatives and compliance and enforcement activities. Commissioners' responsibilities extend beyond statutory decision-making to systemic impacts as proactive data-driven regulators. To achieve this broad mandate, we have embedded the three-commissioner model and developed shared regulatory priorities. We continue to mature our processes and capabilities. However, our year-on-year improvements confirm that we are achieving improved outcomes for the community and our leadership is influencing regulators internationally. As at 31 March 2026, the first 3 quarters of the financial year, compared to the same time last year, privacy complaints increased by 73% and finalisations increased by 38%. 86% of privacy complaints were closed within 12 months, an increase from 76% in 24-25. The average age of privacy complaints on hand has reduced from 7.6 months to 5.5 months. Applications for review by the Information Commissioner increased by 46% compared to the same period last year. 82% of IC reviews are finalised within 12 months, an increase from 79% in Q2. The average time taken to finalise an IC review has reduced to 7.2 months in Q3 from 9.8 months in Q1. The number of FOI complaints received increased by 52% and our closure rate increased by 26% in 25-26. Our approach to the systemic regulatory challenges we face is maximised through collaboration and engagement. We recently led the development of a uniform icon for information access to be shared and promoted by all state and territory information commissioners. This uniform representation of information access can be applied by all government agencies to their websites. This will provide a recognisable, common entry point through which the community can engage with agencies. For agencies, our ambition is that friction points are lessened by a single point through which information can be proactively and responsively released. Our collaboration with regulators and integrity agencies, such as the Australian Public Service Commission, the ANAO and digital platform regulators, also informs our work program. We approach new and important initiatives, including the social media minimum age reform, through community and industry engagement. This engagement ensures our regulatory approaches are responsive to our dynamic regulatory environment and community expectations. The OIC will shortly release our Australian community attitudes to privacy surveys. The results confirm that our proactive work is responsive to harm in both information access and privacy. For example, in relation to the use of AI, Australians most frequently prioritise a right to human review at 81% and being told when AI is being used at 79%. These outcomes underscore our work in reporting upon and providing guidance to agencies as they meet their obligations to publicly disclose their use of ADM under the FOI Act and the complementarity of the forthcoming ADM transparency obligation under the Privacy Act reforms commencing in December 26. Our investment in capability uplift within the OIC through staff engagement, wellbeing and learning and development programs have delivered results for the OIC and the community. I acknowledge the fine work of the OIC staff and record our thanks for their ongoing commitment. We are actively advancing efforts to maximise the opportunities available to us under these statutory regimes to ensure they operate effectively for the community, industry and government. Thank you, Chair.
Thank you very much for that opening statement. We'll proceed to questions and begin with Senator Blythe.
Thank you very much, Chair, and thank you, Commissioner, for that opening statement. I will start by just referring to the current budget and taking you through portfolio budget paper 4. On page 43 in that, it shows that the OAIC's departmental appropriation is at $36.576 million for 26-27, which is down from $39.753 million in 25-26. Is that correct? An 8% reduction there?
Thank you, Senator. Yes, there has been a reduction. It's largely attributable to terminating measures, those terminating measures being work that we've acquitted through the social media minimum age and also through our litigation fund, which is available for us to draw upon for matters such as Bunnings that have now concluded. So the majority of that reduction is attributable to terminating measures. Okay. There are, in addition to those terminating measures, the proportion of savings that we are delivering through labour hire, contractor use and also travel. Excuse me, Chair.
Fantastic, thank you. Can I ask, with the OAIC's Monitoring Services Australia's progress in implementing the ANAO's recommendations regarding data management and risk practices?
I'm sorry, Chair, the ANAO's report into data management and risk practices?
Okay, yes.
Chair, that's not within my program at the moment,
Okay.
but it is something that we will engage with the ANO on, as we are engaging with them in relation to their general work program and reporting. At a corporate level, I can say that we have implemented or are in the process of implementing an approach to governance in relation to data usage and tech more broadly, and expanding our program of work at a corporate level to ensure that we're responsive to both the opportunities and challenges presented by AI.
Okay, thank you. Has the OAIC provided Services Australia with any additional guidance on public notification obligations in the event of a data breach?
Chair, I think the Privacy Commissioner will take that matter forward. However, we have been engaged with Services Australia in relation to their approaches to data breaches, responsive to the ANAO report in that regard. And Chair, if that was the report you were referring to in terms of data matching, yes, we are familiar with that report, and it is informing our work program. I'm sorry, I misunderstood you.
No,
thank
fantastic.
You, Senator.
No, thank you very much. So from July 1, 2026, more than 100,000 small businesses will be required to comply with the Privacy Act for the first time. What guidance and support has the OAIC provided to these businesses, and how confident is the OAIC that they will be ready?
Thank you, Senator. My colleague has really been influential in ensuring that appropriate guidance is available to support industries through both Tranche 1 and Tranche 2 as we work through the additional obligations that are imposed on those entities. And Senator, you're correct in saying up to 120,000 new entities to be covered. Those entities have been provided with direct engagement and guidance and ongoing updates of guidance to ensure that they are ready to comply with their additional obligations, particularly as they relate to the issues of privacy. And Senator, with your leave, I might turn to my colleague to see if she would like to offer anything else in this specific domain.
Please.
Thank you, Senator. Carly Kine, Privacy Commissioner. I'd just add to the Information Commissioner's commentary, which indeed correctly states we've done an extensive program of engagement with peak bodies and others in relation to the AML-CTF reforms, which, as you rightly say, will bring more than 120,000 new entities under the OAIC's regulatory remit. We published guidance in February 2026. We revised that guidance after we received engagement from the stakeholder community. And I'll just add, we also published in April 2026 a template privacy collection notice that entities can use, essentially kind of an off-the-shelf template that they can use to ensure they're in compliance with their obligations.
And you're confident that these businesses are going to be ready?
We're certainly providing all the support we can. We note that the obligations under the combination of the AML-CTF regime and the new Privacy Act obligations are responsive to the circumstances of the entities, and we have already indicated that we'll be taking into consideration the size of the compliance burden as against the size of the entities and their capabilities to comply.
Okay.
And we've provided guidance in that context, and we're certainly committed to supporting them to be in compliance.
So I guess that sort of leads into the next question in terms of any enforcement action for anyone who's not compliant. It sounds like you're going to look at that on a case-by-case and
absolutely,
and a grace period. Is that a good way to describe it?
Indeed, Senator. We would always think proportionately about how to use our regulatory powers, and we acknowledge that the circumstances in which entities are working to comply, and we'll certainly take that into consideration, as well as the size of the transition many of them will need to make in order to be in compliance.
Can I just ask, in terms of that, say, grace period, for want of a better description of it, how long do you think you will take that approach? Do you have a timeline?
Yeah,
because it is a large number of...
Indeed.
Yeah.
The Privacy Act is helpful in this regard in that it mentions often reasonable steps and the circumstances relevant to those reasonable steps. And we've indicated in guidance that the circumstances we'll consider include the size of the entity, the resources they have in order to draw on, in order to comply, the type of personal information they're handling and the volume of that personal information, and the size of the compliance obligation that they'll need to transition towards. We've not been explicit about applying a grace period per se, so much as said, well, in all the circumstances, consider what an entity is required to do and how much change they're going through. I would say that the larger an entity is and the more resources they have available to them, the more likely we would be to take enforcement action sooner after the obligations come into effect.
All right. Thank you for that. And I guess in terms of the resources, even for your office to have to take, and it sounds like there is going to be a large resource burden on your office to go through if we're looking at this case by case for a very large number of businesses that are ranging in sizes. How are you going in terms of being able to regulate an additional 120,000 plus new entities from July, given that the complaint volume is already very, very high?
Thank you, Senator. We are designing our regulatory approach proportionate to the issues that are raised and the harm that is either potential or has occurred, as indicated by my colleague. We're also informed by our budgetary parameters. However, in terms of privacy litigation and enforcement, we have access to discrete funding that has allowed us to draw upon that funding when we undertake that significant and costly enforcement action. So drawing upon those funds has allowed us to deal with matters that have been quite significant for us and are currently significant for us in terms of expenditure through litigation.
Can I ask how much that fund is that you have access to?
Our funding is in relation to those litigation funds derived from 3 different sources.
Okay.
One is our an internal funding, and the other 2 are equitable fundings, one for enforcement and one for litigation. They have varied because they have applied over a period of 3 years, and I'll just grab the precise figures for you. There was $6.1 million of contingent litigation funding over the period of 23-24 to be used for litigation in relation to data breach investigation matters. There was 2.6 for equitable privacy enforcement funding. Now, that was the Bunnings and Kmart. We, of course, retain the ability to draw upon that matter for, that quantum of money for matters that are still on foot, like Kmart. And there's also equitable privacy litigation funding, a total of $6.05 million, over $3 million in 25-26 and $3.05 million in 26-27. And that can be applied to any privacy litigation matter, either enforcement or defending our decisions that are taken. The estimated amount that remains uncommitted in the last month or so is about $5.5 million.
Okay.
Thank you, Senator.
Thank you,
Senator Shoebridge.
Thanks, Chair, and thanks all for your attendance. Can I first of all express my gratitude for the action on the property lovers bottom-feeding corporate structure that you've been undertaking, Commissioner Kind, and can you just give us an update on where that's up and also whether it's up to, and what about the principal involved, Ms. Grubisa? What's the status there?
So, thank you, Senator. As you'll recall, we issued 2 determinations in relation to property lovers and a related entity owned or controlled by Ms. Grubisa or her husband in 2024. And then last year, we had concerns that there was non-compliance with one of those determinations, which was with respect to property lovers. So we opened a new investigation to both monitor compliance with the determination and extend the investigation to another new entity which appeared to be under the control of the same people, fastproperty.ai. We conducted an extremely thorough investigation of those entities, much of which was focused on establishing the corporate structures that were related to them and which were very opaque. We were able to establish that Ms. Grabisa herself was involved in fastproperty.ai. However, the investigation revealed that the tools being used by property lovers and fastproperty.ai did not involve any personal information, and therefore the Privacy Act did not apply to those entities for those particular purposes. Acknowledging the concerns you have, Senator, and the concerns that the Australian people had, we thought it was important to publish a report on that investigation, which we did in May 2026. And we've also referred relevant practices uncovered during the investigation to other relevant regulators.
Yeah, and I suppose which regulators have you referred it to? And has it been a sort of hot handover showing all the detailed investigation you've been doing about corporate structure and poor behaviour as directors and office holders in corporations? Has that been a hot handover?
We've provided the full investigation report to the ACCC, and we've also met with their staff on numerous occasions to brief them on the investigation and our concerns that might be relevant to their remit.
All right. And
Sorry, Senator Superbridge, can I just interrupt you for a second? We just had media walk into the room, so I want to seek the permission of the committee.
standard resolution.
Yeah, thank you. And I remind media that permission can be revoked at any time, and the media must follow the direction of the Secretariat staff, and the usual rules apply. Thank you. Sorry, Senator Superbridge.
Thanks, Chair. And is there any current ongoing work involving property lovers, Dominique Grabisa in the office, or is that concluded for the moment?
Not at this stage, not at the OAIC.
We saw privacy complaints increase by 73%, finalisations increased by 38%. Obviously, that's a huge amount of effort to increase the finalisations by 38%, but the numbers aren't matching. What does that look like in terms of workflow and in terms of backlog?
Yes, you're right, Senator. The increase in numbers has not been matched by the increase in finalisation rates, despite the very hard work and good effort of the OAIC. And I would acknowledge that effort extends not only to case handling processes, but also more broadly across the organisation to how we're adjusting our regulatory posture through education, through enforcement, and through all available measures to ensure we're able to stem the incoming numbers. You're right that we're receiving somewhere in the ballpark of around 100 complaints a week currently. We've received 4,648 complaints this financial year to date, and we have 4,209 on hand. So that is, in your words, our backlog, our current backlog,
Yep.
of which about a third of those are over 12 months old.
Okay. And if you're looking at these numbers, do you see that backlog holding? Do you see it growing? What do you see?
I think the experience of recent months has been that despite all of the tools we've brought to bear upon the incoming numbers and our own backlog, we're not able to, at this stage, meet, part for part the exact incoming numbers. So it's likely that backlog will continue to grow as complaints continue to rise.
What do you see when you look at the broad array of complaints you're getting? What do you see is driving that rise? Is it people concerned about AI hoovering up their data? Is it people concerned about their kids' data? What's driving that rise in complaints?
Yeah, thanks, Senator. I have a few theories as to the increase, but I'd say there's no specific trend in the case numbers themselves, and we're certainly analysing the cases in that way. So we don't see any particular entity or any particular practice giving rise to huge bumps. I think there's higher levels of awareness and concern around privacy in the community. As Commissioner Tidd said, we have a forthcoming privacy attitude survey that will be published this week, which shows that 86% of people are more concerned about their privacy now than they were 5 years ago. So I think we're seeing that reflected in the complaints. I think privacy is in the public discourse more because of AI, and so people are again more attuned, but I wouldn't say that our incoming complaints reflect AI-related complaints per se. I think that's natural because AI is in many circumstances obfuscated from individuals, but I think the generalised concern is there. We still see a large amount of people, and probably an increasing number of people, wanting access to their personal information and not able to get that access, either because they're refused access, they're charged extortionate fees, or other reasons. And then other concerns relate to excessive collection of personal information, and then secondary uses and disclosures of personal information.
Yeah, and I mean, one of the big issues that's alive in privacy reform that this Parliament has still not grappled with is the issue of somebody having given consent maybe a decade ago, or maybe consent in certain circumstances, and then they find that their data has been used and repurposed for often commercial gains that were never in their contemplation when they gave the consent. Is that part of what people are saying?
I think that's right. I think that's captured by the concern around use and disclosure, that people feel that their data collected for one purpose, whether they gave consent or not, is then later repurposed for another reason, often because they're receiving targeted advertising from an unknown entity, for example, or that it's being passed on. We see a lot of concern around disclosure to other entities, particularly overseas entities.
Yeah. Now, your office has put out a statement about handling privacy complaints, a new approach for a new era. What does that actually mean for people approaching the office?
I think the objective there, Senator, was in one sense to manage the expectations of complainants who are facing lengthy waits to have their complaints resolved, and who are often surprised when we exercise our discretion not to take forward complaints for a range of reasons. So we wanted to provide more information as to what factors feed into that discretion. We also wanted to make clear that the reason we're focusing on enforcement and education initiatives is to address issues at a more systemic level rather than on a complaint-by-complaint basis.
But is that also just a recognition of the sheer number of complaints that are coming to you? And if you're looking at your team, how do you fairly arbitrage from this, fire hose of complaints? Is that part of why you're looking at moving towards more strategic work?
I think that is a strategic decision we've taken, absolutely, that we can have more effect and more proportionate effect at that strategic level. I'd also say, Senator, if I may, we are working really hard to increase our expectations on the regulated sector to deal with complaints in the first instance, as the Privacy Act requires them to do, and that's part of that strategy.
Did you make a budget request for additional funding for the office? Because it would appear you clearly need additional funding. That would be one solution, wouldn't it, to this mismatch between incoming work and actual capacity inside?
Senator, if I might take that issue, we're in constant engagement with AGD in relation to our budgetary situation, and also in relation to opportunities through the NPP process, the terminating funding process, to look at an uplift to our budget. It is pleasing that digital ID has become part of our ongoing budget through this particular budget cycle, but we will continue to engage, and we're particularly engaged in the issue of ensuring that respondents meet their requirements under APP1 to actually engage with complainants to resolve matters at first instance, because a number of these complaints are successfully being resolved through early dispute resolution schemes or through the respondent's contact.
But I mean, in December of this year, you're going to have a whole raft of new work, new entities covered by privacy legislation. Has there been a funding package given to deal with that surge of new work that's going to come in?
Parallel to the discussions around Tranche 2 will be discussions around the budget impact for the OIC and our regulatory remit.
It's happening in this financial year. I look at the budget, there's nothing in the budget for this coming financial year. You might be having discussions, but they haven't worked because there's no money in the budget.
Senator, I can assure you that the work will continue.
All right.
Thank you, Senator Shoebridge. Senator Black.
Thank you very much for that, Chair. In terms of the government's agreed in principle to remove small business exemption entirely, which would capture approximately 2.3 additional businesses. Has a date been set yet for that exemption?
I wasn't sure if that question was for...
I'm sorry, Senator. Would you mind repeating the question, Senator?
So the government has agreed in principle to remove the small business exemption entirely, which would capture approximately 2.3 million additional businesses. Has a date been set for this?
Senator, perhaps
Yeah, sure.
can assist with that.
Senator Sarah Chidgey, Deputy Secretary, Integrity and Security Group. So the government hasn't made a decision to remove that exemption.
Okay.
The government is continuing to consider and consult on those issues as part of work that continues on a second tranche of privacy reform.
Okay, so I'm assuming then is there consultation happening about making a decision on that?
The department's working on proposals with the intention to undertake targeted consultation, but no decision has been made about whether that would include any change to the small business exemption.
Okay. So working on proposals currently?
For the second tranche of privacy reform,
Yep.
There's been no decisions on small business specifically.
Can I ask the date for that second tranche? What's been set? So what's the timeline that you're working towards?
There's been no specific timing set for that at this point, but
Okay.
we're working towards targeted consultation.
Okay, thank you. In terms of, and I guess this is going to go back to the businesses, what's the estimated compliance cost for a typical small accounting firm or real estate agency to meet the new Privacy Act obligations? Do you have an approximate? So has the OAIC conducted or commissioned any analysis into the regulatory burden?
Senator, that in relation to anti-money laundering, that might be a question for colleagues or another department. In terms of our engagement with industry, that information is not currently before me.
Okay. Are you able to provide that on notice?
That would be, I would think, Senator, in a regulatory impact statement or assessment. And
Senator, in terms of anti-money laundering, counter-terrorism financing reform, that's the Department of Home Affairs.
And Senator, they did do a regulatory impact analysis that
In Privacy Act obligations?
I think across the AML-CTF reforms, which as part of it applied Privacy Act obligations. So there is
But there's
an analysis that encompassed all of those reforms.
Okay, but in terms of Privacy Act, so not talking about anti-money laundering, in terms of just what these new businesses and the grace period we were talking about, what's the burden? Have you done any modelling on a cost of the burden to these businesses?
Senator, that would not be a matter that we would undertake as a regulator. Okay. However, we do engage and seek to ensure that businesses are well equipped to meet their obligation. In terms of the financial impact, Senator, it's not something that we would be engaged in once the legislation obviously has been passed and the tranches of compliance are being rolled out.
Can I just ask then, from a business perspective, so I understand you go out and you're trying to equip them to be able to meet the new regulatory burdens that they have, but it doesn't come up in discussion what that's going to cost them?
Senator, that might be part of the dialogue that occurs as we engage with the entities subject to Tranche 1 and Tranche 2, but it is not a question that I have the answer to before me.
Okay.
Our focus would be ensuring that entities covered have the appropriate guidance to be able to meet their obligations under this legislation as seamlessly as possible.
So in that guidance, are there recommendations for additional staff, or so if a business doesn't necessarily have the capabilities to meet the regulatory requirements? So I'm just trying to understand in terms of if you're equipping them to meet the burdens that they've got to meet, are you advising them on the types of skills that they'll need in their personnel? Are you?
I think.
Yeah, sorry. Thank you, Senator. Indeed, much of our guidance contains information about what reasonable steps look like in the circumstances to comply with various acts of the various components of the Privacy Act, and we certainly do provide advice around properly training, skilling and equipping teams around Privacy Act obligations. We don't provide specific or bespoke advice to any particular entity, but rather focus on our guidance materials, which go towards how entities can comply with various components.
And there's no
of the Act.
cost aspect to that. So you're not able to say to a business, you know, basically at a minimum, your obligations may cost your business an additional X.
The obligations scale with the size of the business, the type of personal information they're handling, the various circumstances in which they sit. And so if you're a multi-million-dollar business, the expectation is that you're spending more on Privacy Act compliance, and that scales accordingly. So again, we don't provide bespoke advice to any particular business, but rather generalised guidance on what compliance looks like under the Act.
Okay, and you're not collecting that at all to be able to come back and provide advice? Because obviously businesses are doing it so tough at the moment, and by adding additional burdens, I would have thought the regulator would have been aware of, or at least be conscious of the impact that this could have to those businesses.
Indeed, we do receive information in our engagement with stakeholders across the community, and we certainly attempt to ensure that our guidance addresses any questions and concerns that they have.
Could I then ask you, in that correspondence that you're receiving back from the, you know, many small businesses that you're engaging with, so this 120,000, this group, and I'm assuming a lot of them have had feedback for you, can I ask for you to table that? I'm assuming you're collating it in some way, shape or form, where the cost burden of this has been raised.
Yeah. Sorry, Senator. I suppose to reiterate what our colleagues from the department said, this legislation was under the mandate of Home Affairs, and so the regulatory impact assessment and the consultation on the legislation was conducted by them. We're regulating the downstream impact of that.
I get that, but the businesses, you're liaising with them. So you've just said you're getting a whole range of feedback from the businesses you're liaising with. That's not coming from Home Affairs, that's coming from you.
Senator, if I might offer that we are also engaged with AUSTRAC as another regulator in this space, and we engage with them regularly in relation to ensuring that the system is implementable and ensuring that our guidance is responsive to the feedback from industry.
Yep.
That may involve the privacy dimension, which is just one dimension.
Fantastic. So can that be provided to the committee on notice then, that feedback?
Senator, we will make every attempt to look at what information is relevant to your question and provide it.
Fantastic. Thank you. And I guess just going back to, and Senator, you want to share the call? We can, because this will go into a different...
Okay, yeah, perfect time.
Go for it.
All right, thank you. Senator Polly.
Thank you, Chair. I have some questions in relation to the Children's Online Privacy Code. How will the Children's Online Privacy Code better protect the personal information of children?
Thank you, Senator Polly. The OAIC published the exposure draft of the Children's Online Code in March this year, and it's currently open for consultation until the 5th of June. The code will require APP entities bound by the code to adopt best practice approaches when it comes to the handling of children's personal information. And some of the key provisions in the exposure draft of the code include that the collection, use and disclosure of personal information must be consistent with the best interests of the child. Direct marketing to children will only be permissible with consent and when it's in the child's best interests, and when the personal information is collected directly from the child rather than from third parties like data brokers. We propose to introduce more rights and controls for children, including a right to request destruction of their personal information. We propose to require privacy notices and policies to be written in clear, accessible languages that is age appropriate. And there'll be stronger consent mechanisms, including telling a child when a parent consents on their behalf. And Senator Polly, I'm pleased to inform you that we've had really wonderful engagement with the code, including we've consulted with 337 young people and children and their parents about the code, and we continue to receive submissions and consultation responses.
Thank you for that. So what is anticipated will be covered by this scope and the code? If you can just talk us through a little bit more in detail so people can actually have a sense of what it's going to achieve.
So the threshold for application of the code is first the entity has to be already covered by the Privacy Act, so there won't be any new entities covered by this new legislation. The second thing is that it applies to services that are likely to be accessed by children. And we also propose that services that handle as a primary purpose the personal information of children will be covered by the code. The code applies at a service level, not at an entity level. Which we think is a really important mechanism to ensure that it has a discrete application only to the most concerning and important places that children go online. But generally speaking, the scope of the code is broader than, say, the social media age restriction scheme. So social media platforms will be covered, but also apps, streaming platforms, games, and any other websites where children are likely to be.
That's very good. Can you give us an update about the progress of drafting of the code, where you're at now?
Yes, so the exposure draft is out for consultation, and once that consultation closes on the 5th of June, we will revise the code according to the responses received during the consultation. We are also engaged in a regulatory impact assessment currently, and once both of those inputs have been considered, the code will be registered by the Attorney-General by December 2026.
Excellent. When you said you had consultation with 337 children and parents, what was the age of the children that you've been consulting with? Just a range of ages.
Thank you, Senator. This is the second round of consultation with children, young people and parents we've undertaken. The first was in 2025. Throughout both, we have designed consultation materials that are age appropriate for specific age groups, and those age groups included children as young as 8. So the youngest cohort of consulted children was 8 to 12, and then we had a 12 till 16 and a 16 and older cohorts as well. We undertook that consultation both directly, but we also worked with partner organisations who brought to us the input of children as well. And we also developed curriculum materials that were disseminated throughout schools in order to elicit the input of children, including through drawings and pictures as well as through written consultation responses.
And pretty thorough. What's the overall feedback in terms of, was there any difference between the children and the young adults and their parents?
There was certainly some divergence between children and their parents. For example, we looked at the children's perspectives on knowing when they're being subject to geolocation tracking, which of course is used sometimes by entities, but also sometimes by parents to monitor their children. So there was a bit of a divergence in views there. But broadly speaking, we saw that children and their parents both aligned. They objected to their personal information being shared without consent. Most children and their parents said that they wanted the right to be able to request the deletion of their personal information. Children and their parents were both quite strong on that. And generally speaking, want more control over personal information for children and their parents.
That's great. You have consultation up until the 5th of June, and then the process from there is to draft the code to have implemented by December, is that right?
That's right, to further amend the code. The code is in draft form now, and then that's right, it should be registered by December. I will say, Senator, that it's not evident that all provisions in the code will come into force immediately. We're likely to agree to some transition provisions to ensure that entities are able to comply with some of the more significant changes that will be in the code.
Excellent. Congratulations on your work.
Thank you, Senator Polley. Senator Shoebridge.
Thanks, Chair. Could I ask about what the status is for the backlog in in FOI reviews, Commissioner Tidd?
Thank you, Senator.
I see the data you put in your opening statement.
Yes.
And again, it's not dissimilar to what's happening in privacy. You've increased your output, but what's coming in has overwhelmed your efficiency increases, as I'm reading the numbers.
Certainly, Senator Shoebridge, there has the gap between the increase in our efficiency and incoming to date has delivered an increase in the backlog of FOI matters.
It's not just a small increase. Like it's a 46% increase in one financial year about information reviews. And either, I don't mind which of the two commissioners answered, either you, Commissioner Tidd, or you, Commissioner Lineker, like a 46% increase in reviews. Can we maybe get an understanding of what's driving that?
Senator, I'm happy to commence with that and turn to my colleague for further detail. We continue to receive a significant number of deemed refusals that require an investment in our case management expertise to work with agencies to deliver a decision.
This is agencies just failing to meet the statutory time frame and therefore pushing work down the funnel to you. Yeah. Home Affairs was a prime offender in this space. Are they still a prime offender?
There, Senator, the most significant number of deemed decisions that we receive and that are on hand come from the Department of Home Affairs. We're working significantly with the department to examine all options to help them to elevate their ability to manage the applications that are made to Home Affairs to ensure that there is a decision at first instance. Some of the approaches that my colleague might want to elaborate upon are ensuring that where there is engagement with the applicant to request an extension of time, that we are able to turn around those extensions of time within 24 hours to enable the department to incentivise that contact and enable that communication that should be occurring direct between the department and the applicant.
Well, it's not your job to run the FOI departments for Home Affairs, or to be an outsource for Home Affairs. They're meant to be meeting their own statutory timeframes. It must be very frustrating being the Home Affairs FOI help desk.
Senator, the experience we have with agencies allows us to elevate our overall engagement across the broader FOI agency cohort and to take those learnings and apply them through both our complaints mechanisms and our reviews. We are working in earnest, Senator, with Home Affairs to elevate their levels of compliance.
Do you have a breakdown of the 2,206 information review applications? How many were deemed refusals? How many were substantive applications?
Senator Alice Lineker, Freedom of Information Commissioner. So the broad breakdown is that 80% of the incoming IC review applications are for deemed decisions. So we've seen Home Affairs have a 34% increase in their deemed decisions coming to us for review over the last financial year. We've seen a general increase in deeming of 48%. So the financial year to date, we have received applications for review of 1,765 deemed decisions. So that is the majority of our increase.
Apart from Home Affairs, are there any other principal offenders in that list?
The three most significant offenders sit in the Home Affairs, National Disability Insurance Agency, Department of Veterans Affairs, and Services Australia and AFP are in that top bundle too. We've done a lot of work with Department of Veterans Affairs to look at administrative access. The majority of that increase arises from personal information requests. So administrative access schemes are the mechanism we ask agencies to engage in to allow individuals to receive their own information.
Putting deemed refusals to one side, what about the other cohort, the more substantive reviews that are coming? Are you seeing an increase in that, or is that static?
I think that we are looking at, so there is a broad increase across applications, 46% increase. I haven't got the breakdown in front of me of the cohort beyond the, outside of the deemed, but applications to agencies, primary applications, are steady, if not decreasing slightly quarter on quarter. So same time last year, there's a slight decrease at this point. So it is the deeming applications that are causing the pressure in our system.
All right. Perhaps you could just give that as much granular breakdown as you can about
Certainly,
that flow
Senator.
of work on notice.
Yes.
By department, numbers by department or agency if you've got them, and also the breakdown into deemed and substantive.
Absolutely, Senator.
Thank you. To move back to privacy, Commissioner Kind, have you had any complaints referred to you about the way in which VIQ Solutions has been dealing with transcript and deeply personal information that they receive through their contracts with the Federal Circuit and Family Court and the Federal Court?
Thank you, Senator. We have at least one individual complaint on hand related to VIQ Solutions, and we are also making preliminary inquiries with using our proactive investigations powers into that matter.
I mean, one of the issues that is very live at the moment is ensuring that whoever's in charge of the voluntary administration understands that privacy principles survive administration. Has there been that clear communication with the
We've now
administrators?
initiated contact with the administrator, and we're making inquiries in that regard.
What does making inquiries and initiated contact actually mean?
It means we're in contact with the administrator. We're making inquiries as to their understanding around compliance with the Privacy Act and their understanding with respect to any acts or omissions that may have contributed to the breach.
Yep. Are you looking at whether or not VIQ was feeding in transcripts, recordings into an AI model to train its AI model, and whether or not consent was obtained by VIQ from any of the litigants that are in the courts for that?
We're certainly at an early stage of our information gathering, Senator. That's not an issue that I'm aware has been raised with us to date. But at this early stage,
made a public statement in May of 2022 that its AI product First Draft was deployed, to quote them, in partnership with courts in Australia. I haven't heard the courts talk about their partnership to create an AI model with VIQ. I definitely haven't seen any evidence that any litigants had been given consent to being part of training VIQ's First Draft AI model. Is that part of your inquiries?
as I said, Senator, it wasn't something that I'd been previously aware of. As you know, we've engaged extensively on AI model training as an issue, and we know it's an issue that Australians care a lot about. So it's certainly something that I will take back to the team and will consider in the context of our preliminary inquiries.
I mean, I'm not minimising the sort of privacy and, personal anxiety people have when their creative works are fed into an AI. But the idea that your deeply personal family court proceedings and the transcript of the family court proceedings is being fed into an AI model without your consent, I mean, that's a pretty extraordinary... I would have thought prima facie that's a pretty gross breach of privacy laws. And if it's not, there's something broken with our privacy laws.
Indeed, Senator, your perspective on this issue aligns with that of the Australian public. In our forthcoming attitude survey, we asked specifically about AI model training, and we found that most people, over 90%, are not comfortable with their personal information being used in that way. So it is an issue for us, a regulatory priority for us.
I mean, would that be something that would trigger regulatory action from you on the presumption that it would be a breach of privacy principles to have your personal family court transcript fed into an AI model without your consent?
The Privacy Act requires secondary uses of personal information that are outside of the primary purpose for which that information was collected to meet certain thresholds. In some circumstances, that threshold is consent. In other circumstances, that threshold is reasonable expectations. And we are looking at AI model training in a number of different matters and how it interplays with those thresholds. It will change in context by context, including what exactly the AI model is doing, how the entity is deploying the model, whether they're deploying it as a form of product improvement or whether they're deploying it in some other circumstance will be a factor that we take into
Would it
consideration.
also look at where that data is sitting? If it's sitting in a cloud server outside of Australia, for which Australian regulatory reach doesn't extend, whether it's been deployed in other jurisdictions, would it look at that in terms of reasonable expectations?
I think there's two issues there. One is whether it's disclosed to another entity for the purpose of model training. We would look at that. And then the second issue is whether there's been a cross-border disclosure of personal data, and that we'd look at under APP 8, and that is indeed an issue that we're looking at in this particular matter.
And is some of your initial inquiries now looking at the repeated disclosures that appear now to be have a high degree of confidence in them, that VIQ Solutions was sending transcripts containing obviously huge amounts of private personal information offshore?
That is the primary focus of the preliminary inquiries at this stage.
And have those preliminary inquiries led you to any preliminary conclusions?
Not at this stage, Senator.
Has VIQ Solutions, has a voluntary administrator been cooperating?
To my understanding, I haven't heard of any non-cooperation at this stage.
Thank you. I waited till you got up.
Oh, thank you very kindly. That's very considerate of you. Okay. Thank you. That's all the questions we have for you this morning.
Thank you, Chair.
We're now in a position to release the OAIC. Thank you for your time this morning. And we will take a very short 1-minute suspension while we welcome our next witnesses. I now call officers from the Federal Circuit and Family Court of Australia. Mr Pringle, would you like to make an opening statement?
Just a few brief comments, Chair. Thank you. Firstly, I should note that I'm here with my Deputy Virginia Wilson, and part of the executive team as well is here on behalf of the Federal Circuit and Family Court of Australia, Divisions 1 and 2, Janet Carmichael, Hayley Foster, Greg Rowan and Brian Glendenning. First thing I'd like to say is just the courts are very acutely aware of the issues arising from the fuel shortage potential issues and the Middle East crisis, and have positioned themselves through some careful planning to be able to deal with those issues that flow from that crisis. That includes being ready to deal with a potential increase in filings in certain areas. We're certainly very aware of the fact that these issues are affecting regional Australia in particular, and we would like to just assure everybody that, as we were with COVID, we're in a position to deal with these issues quickly. The second thing I'd just like to mention is in regard to anti-Semitism. As I mentioned in my opening statement in February, the Chief Justice and others have set up a leadership group that is making sure that the court can position itself very effectively to deal with those matters as well, including education and training as needed. They're the preliminary matters, but otherwise I suspect, given evidence yesterday, that there'll be questions relating to VIQ, and perhaps when that comes on, I can clarify some matters as a preliminary then.
I'm sure senators would appreciate that. Thank you very much. We'll proceed to questions and begin with Senator Scarr.
Mr Pringle, it doesn't give me any delight to have to ask these questions I'm about to ask you. And it's in relation to former Registrar Anne Sturgis, who served in the family court system for 20 years as a registrar, and then, after what she says was trauma suffered as a result of bullying, gaslighting, intimidation, she had to leave her employment as a registrar of 20 years standing, made an application to Comcare, which she was successful in first instance in relation to that application. Your court then requested that the matter be reconsidered by Comcare. You hired an external firm at no doubt great cost to the taxpayer. You lost. Ms Sturgis was entirely successful in a claim through Comcare. She's had to apply to her superannuation company for a TPI. She was successful. I've read 4 folders of evidence, which horrifies me with respect to what is happening at the court. So I'd like to give you an opportunity first to respond to whether or not the court has treated Ms Anne Sturgis, who gave 20 years of her life as a registrar to this court and was left debilitated and broken, was treated fairly by the processes of your court.
Thank you, Senator. I appreciate you giving me the opportunity to respond on those matters. Clearly you've had a version of events presented to you, including some documentation. Regrettably, the scenario regarding Ms Sturgis is a very complex one. The way it has been characterised by you just now is not accurate in my view, and on behalf of the courts. Ms Sturgis was with the courts for a considerable period of time. You're right, it was probably in excess of 20 years. And no one questions that she was a very capable lawyer doing the things that she did. The circumstances towards the end of her employment, and I'm going to be very careful here because there are very sensitive issues, including medical-related issues that are at play.
I know, Mr Pringle, they're very sensitive.
And for those reasons...
Devastating.
Well, for those reasons, I think we all should be very careful about how much detail has gone into. But the characterisation that you've just outlined is not, in fact, the state of affairs. The court had the complexity of a number of allegations being made at the time, many of which were against her by junior staff. And we had the obligation to investigate those matters, including to ensure the protection and well-being of those junior staff. The minute we started to do that is when the problems arose, and then those Comcare processes and the like followed from there.
Okay, so you've challenged my outline of the facts and the state of affairs after I've gone through 4 pages, 4 folders of material. Was Ms Sturgis successful in her Comcare claim at the first instance?
Yes, she was.
Thank you. Was she successful after the Family and Federal Court, Circuit Court, challenged that success in the first instance in sort of reconsideration by Comcare? Was she successful?
Yes, she was, but there was background to that.
Was she successful or not, Mr.
Yes,
Pringle?
she was.
Yes, she was. And in determining that reconsideration, did the Comcare conclude that there had not been reasonable administrative action? Is that correct?
I'd have to check the exact findings. It was some time ago, Senator Scarr, but the overall characterisation that she was successful in that reconsideration process is correct.
Well, look, I'm happy to go through the reconsideration which was fought by your court. And this is, and I'm happy to give you this if you want, but I'm sure it'll you'll be aware of the content of it as I go through it. It'll enliven your memory, I suspect. So this is what the Comcare delegate said in terms of the reconsideration. So they needed to consider a number of issues. Whether Ms Sturgis provided appropriate notice of her condition, determined that they did. Whether you have sustained a condition or an aggravation of a condition, they determined she had. Whether the condition was significantly contributed to by your employment. And this is what they said. I find that your employment with the FCSA significantly contributed to your adjustment disorder and mixed anxiety and depressed mood. So that psychological injury, debilitating injury, that was found by Comcare after considering the extensive submission made by your court registrar with the benefit of external lawyers. And I'll ask you to take on notice how much the court has incurred in terms of external costs in relation to this matter. And then the court, Comcare, had to determine, in terms of the reconsideration you dragged Ms Sturgis through, with respect to her future ability to provide for her living needs and requirements, whether your condition resulted from reasonable administrative action taken in a reasonable manner in respect of your employment. That was particularly considered by Comcare, and Comcare came to the conclusion that I find your adjustment disorder with mixed anxiety and depressed mood did not result from reasonable administrative action in respect of your employment with the court.
That's right. Did not result.
So, Mr Pringle, you made an allegation against me as a senator of this place that I inappropriately set out the facts of this matter. How did I inappropriately set out the facts of this matter?
The injury did not result as a result of the reasonable administrative action. I should clarify that, and this is why I wanted to be cautious before, in fairness to Ms Sturgis, there were underlying issues that pre-existed this occurring.
Well, Mr Pringle, sorry,
can I just finish my answer,
well,
please?
Sorry, Chair,
Senator?
point of order. Mr Pringle said we need to be very careful with respect to talking about the history of Ms Sturgis. I believe he is correct, but the same principle needs to apply to him as he answers the question. So I just ask through you, Chair, that he takes great care as well not to use this forum in such a way as to have an impact upon Ms Sturgis.
Well,
I think that's fair. Yep.
Thank you. Senator, this is why I suggested it earlier. You have characterised the set of facts in a particular way that have come from a particular place. It is much more complex than that. The reality is there were pre-existing issues. There were concerns about the appropriate procedures being followed by a registrar. There were allegations being made against Ms Sturgis by junior staff. The court took what steps it had to take to start investigating that process, which is what led to the issues coming to the fore. Now, unless you want to spend a very considerable period of time today going through all of the allegations and cross-allegations that led to what was no doubt a very distressing circumstance for all concerned, then all I was saying before is that the characterisation as you put forward, and understandably so because you would have only got one version of events, is not in fact the way the circumstances unfolded at the time.
Sorry. Well, I'll come back with further questions on this, but Mr Pringle, can I say I've read your response to Ms Sturgis's claim to Comcare. I've read your court's lawyer's response, so it is not correct to say, and I would have thought you knew me better than that, the time I served on this committee. It's not true to say I only got one side of the story and I would have thought the facts. Let me ask this question. Doesn't it concern you, just looking at this from a helicopter point of view, you had a registrar who performed her functions for 20 years and then from the beginning of 2021 a number of events occurred. She had a number of interactions with particular members of staff, high-level management, and I'm not looking to go on the particulars of that. 12 months later, she's a broken person and she's had to go through Comcare and the court has fought her every step of the way. Don't you think that would highlight from a helicopter point of view that there's a matter where an independent investigation, independent of you and the Deputy Registrar, should be undertaken in relation to this matter? Has the court considered undertaking an independent investigation with respect to this matter?
No, Senator, because those matters were in fact the subject of independent processes in play. We also
told you the Comcare results.
Senator Scarr, please let Mr Pringle respond.
We are also very concerned to ensure the welfare of everybody, including Ms Sturgis, that was concerned here. I want to reiterate there were very junior staff members who had really serious concerns and their welfare is important here as well. I don't believe that, in fairness to everybody concerned, I would have to go into some of the very serious issues that were flowing at the time, that it's appropriate for me to do that in this forum for the benefit and the personal circumstances of not just Ms Sturgis but the other individuals involved.
Thank you, Mr Pringle.
Chair,
Minister.
I can see Senator Scarr's very agitated about this issue, and my experience of Senator Scarr is that he doesn't normally get agitated about issues. There does seem to be some concern about publicly airing some of the issues that may have been involved in this case. I was going to make a suggestion, and it's entirely up to Senator Scarr, but would it be appropriate for there to be a discussion privately, not necessarily now, but in the very near future, between the witness and Senator Scarr, where some of these issues could be aired outside of the public domain for everybody's benefit?
I'd be happy to do that. Chair.
It's a kind offer, and thank you, Minister. You are right. You know me well, and you discern correctly the level of deep concern I have with respect to this matter. Whether or not that meeting should be with the registrar or perhaps someone within the Attorney General's department might be a question we could discuss offline.
Yeah, I think we can have a conversation about that, absolutely.
But I do have some other questions on this matter which
Thank you. And Senator, I'm happy to have that proposed meeting or with anybody else you wish. There are matters that can be clarified. Can I say also we have some 180 registrars in the court, much of which you had to do with, I believe, Senator, and we pride ourselves on treating our registrars very well, including through education, support and wellbeing. So I'm happy to give you also the further information that deals with those elements. This was a very difficult and complex matter.
Thank you, Mr Pringle, and I think we are right to be cautious in having a conversation about this matter. Senator Shoebridge.
Thanks, Chair. Well, I might just ask one question of clarification. There's evidence of a federal court proceeding in relation to the investigation that the prior Chief Executive Officer commenced, asserting that the investigation was unlawful because it was seeking to interfere with the registrar's independent delegated judicial powers. What happened to those proceedings?
I'm not aware of the proceedings that you're referring to, Senator. Ms Sturgis alleged that there was inappropriate interference with her judicial office. The court's position, and in fact the other judicial officers at the time, including management, were asserting that they were just taking reasonable administrative steps to inquire as to why certain conduct took place. I'm not aware of any proceeding that has flowed from that.
Perhaps you can take it on notice. QUD 267/2023, Sturgis and the Commonwealth.
Thank
in the
you.
Federal Court of Australia?
Yes, I do now understand, but I'll need to take that on notice. I
Have they
believe
con- have
that
they
that was
concluded?
withdrawn by Ms Sturgis, is my recollection.
Now might be a useful time to transition to VIQ. Perhaps I'll just give you an opportunity, Mr Pringle, to update us where the VIQ mess is up to.
Thank you, Senator. I do think a lot has happened since last estimates on this one, and it is worthwhile to clarify a few matters by way of backdrop. As we reflected on last time, this is part of a construct which has been a historical one for more than 20 years. It is not ideal in the current modern day and age of how transcript provision should be dealt with. The federal court entity will be giving evidence later on, and I think some of the matters that arise here are of a technical nature. You mentioned in questions yesterday things like cyber CX in terms of the unauthorised access issues and the like. They'll be in a better position to deal with those, but there are some important things that I think are well worth clarifying that have arisen and unfolded since last estimates. The first thing that I would like to do, however, is to thank the Federal Court entity shared services team, in particular, C. Lagos, who heads up that corporate section, but Jimmy Mastarakis and Louise Kenworthy, the amount of work that has gone in by that team to make sure that the services that we had the last time I appeared here were maintained is quite extraordinary. They have worked day and night to try and keep this service provision going, and I'm genuinely indebted to their efforts. There are three sort of core areas that I think are worth touching on. The first is the effort of keeping that continuity of services since the last estimates evidence that I gave. Can I say that that has been a difficult process? The conduct of the Canadian parent company, VRQ Inc., in particular, and to a different degree, the local VIQ Australian group and in administration has been very challenging, to say the least. The Canadian entity essentially off-cut the Australian arm of its business, put out a press release about unauthorised access problems with data, didn't bother telling us about that, and the first we learnt about it was when that public statement was made by that company. And in as early as February, before the administration process, the CEO, Larry Taylor, assured us that they had full commitment to trying to keep the services continuing to our courts. And I've got to stress, it's not just our courts in the Commonwealth realm, but the state and territory courts and many other very serious processes through agencies that require transcript services. In fact, the reverse occurred. VIQ refused to provide any support to the Australian arm. To our knowledge, they have never cooperated and supported the Australian arm in any way in terms of clarifying the unauthorised data access problems. And their behaviour has led the company in administration to have to operate in very difficult circumstances. What occurred then was the administrator essentially at various times through the sale process threatening to withdraw services from our courts. We had to scramble to try and find appropriate contingency arrangements, which I'll touch on in a moment. Again, the shared services structure did an extraordinary job to try and make sure that that was able to be done.
Could I, because it's a long tale, and I will assure you, let you continue the narrative, Mr. Pringle, but at this point, we're talking about the notice of voluntary administration that happened in March.
Yes.
Is that right?
That's right.
And prior to that, the statement about unauthorised data disclosures, did that statement come from VIQ Australia or did it come from the parent company in Canada?
Parent company in a media release to the public over there as part of, no doubt, their listing requirements. as a public entity. And then they forwarded that statement through to us after the event.
And no prior notice to you or any other its Australian clients?
Not that I'm aware of, but certainly not to us.
Not to you. And were there any details given as to whether or not those data breaches, privacy breaches, were you given any detail about whether or not they impacted the transcripts and the service and the data that was being provided by your court?
Yes, I was going to touch more specifically on the data breach issue in a moment, but we had varying figures of files impacted across not just our two courts, but the federal court. The number was at one point around 170 files. It's dropped down to around about 130, 140 files. One of the reasons why
130 or 140 files in the Federal Circuit and Family Court?
In the Federal Circuit and Family Court, it's now stated that it's 136 files that are affected.
And by affected, is it your understanding that the data from those files had been offshored?
It is stated, and this is what we want verification of, and we've been unsuccessful in getting proper verification yet, that the unauthorised access to data was as a result of 5 individuals who were offshore who were doing the transcribing or the typing, and they were not necessarily authorised. Certainly under our contract, we didn't authorise anybody to do work from overseas. We are assured that the data itself was still maintained in Australia, but the typists, 5 of them, were doing that work offshore.
But will they, if they're typing the data offshore, well, perhaps some of the data was kept in Australia, but clearly data must have been offshore, because otherwise how else could they've had it on their device?
They would have to have it on screen. They would have to see it from where they are. So it's completely undesirable to have that situation, particularly when no consent was ever given to it. And I would, again, defer to our shared services colleagues later to give you more specificity on the technical aspects of that.
And those 130, are they 130 separate matters?
Yes.
And have you contacted the litigants in those matters to advise them about the privacy and data breaches?
Well, we've wanted to potentially do that, but I think the difficulty with it is that we don't have the relevant information to make the assessment as to whether we're required to and should do. There are harms that can be caused by alerting people to issues when there might not be a need. It can cause all sorts of distress. So what we did was call on taking you back to February, Larry Taylor, the CEO of VIQ Inc., clarified that they had already started to commission a report, and it's called the FSR report, by an Australian investigator. That investigator was going through the process of clarifying the extent of the breach and the details of the breach, which is what we need in order to properly understand what we have to do by way of our reporting, notification and privacy requirements in Australia. We asked for that report. We've probably asked for it more than 5 times now. We've made formal demand under the contract, and as recently as last week, my request, we have now effectively indicated that we will seek that the Commonwealth will approach the Commonwealth to seek to compel the production of that report through legal process if necessary. The Canadian company has failed, I think essentially refused to provide the report, hidden behind questions of privilege, or just prevaricated or failed to respond. We have put the similar sort of pressure at the Australian end through the administrator, who has indicated that they have not got access to that report, and they have asked the Canadian company for it, that they have not had the report received. They themselves commissioned their own investigation of some sort. They've given us a broad description of what that has amounted to, but not provided, despite our repeated requests, their own report in Australia.
And do you know who's undertaken the investigation on behalf of the administrator?
I'll have to defer to my colleagues on that for later, Senator. I don't know the details of that, but I understand it was a separate process.
But I mean, just stopping here, we have obviously a significant problem where a critical public service, and the courts are a sort of fundamental public service,
Yes.
is effectively at the mercy of a Canadian multinational that's refusing to cooperate to even give the most basic data. I mean, that's
right.
That's the problem you're facing.
Yes.
I'm not putting you in the frame for this because it was a contract that you inherited.
Yes.
But that's the reality of it. We've got a foreign multinational that's been profiting off the public for decades,
Yes.
now effectively withdrawing service and refusing the most basic cooperation with the Australian government and the courts.
Indeed, and failed to support financially its Australian subsidiary and failed to support it in the issue to do with this unauthorised access problem.
But could I also suggest there is some systemic failures in the systems that are in place in your court and in the federal court, because there should have been some monitoring systems in place to follow the data, some integrity and insurance measures that were being repeatedly rolled out when you're handing over such a large amount of critical information to external entities, and here VIQ solutions. As you look at the systems, were there any of those checks and balances in place? Was there any forensic data following, assurances that you were getting under the contract, apart from blanket statements? You know,
Well,
if you look at those systems, what do you see?
We, Federal Circuit and Family Court, didn't administer the contract or deal with the Q&A aspects of it, but I think at last estimates that question was essentially answered for you by the entity. There was a reliance on the terms of the contract being as blunt as they were, that this sort of behaviour is just not acceptable, and this occurred in clear breach of contract.
But on your, as I understand it, you're not aware of any actions taken either by the federal court entity or by your court to go behind those statements and check whether or not those statements, those blank statements about compliance by VIQ, had substance to them. Are you aware of any?
I'm not aware of that, and we don't have privity of contract there, Senator, so it would have been very difficult for us to do so.
Well, we might come back to Cyber CX
Yes.
after and find out what, if anything, Cyber CX has discovered about the breaches, but I appreciate where we've got.
Thank you. So just finishing off the continuity of services issue, I'm pleased to say that because of the extraordinary efforts that have been taken, continuity of services have been maintained, which has been excellent. That is despite the difficulties that I mentioned with the parent company in Canada and also with the administrator. With the administrator, it wasn't just the withdrawal of services that was regularly threatened to take place, but indeed they demanded extraordinary amounts of money over and above our normal contractual sum that we have to pay for our services, because essentially they said they didn't have the money because they weren't being supported by the parent. And I'm not talking small amounts of money. We're talking about something like $370,000 per month over and above the contract amounts, which is multiple times the amount that we would normally be required to pay under the contract.
And they felt they had power as effectively a private monopoly provider. They had you over a barrel. Was that the nature of their engagement?
I can't speak to their particular motivations. They said it was because they didn't have the money and there would be a risk that the services would collapse without it. We refused to make those payments, but the reality is we were put in a very difficult compromise situation, and it's one of the reasons now, as I turn to where we're headed, that I can safely say on behalf of the Federal Circuit and Family Court in particular, we will never be in this sort of situation again.
Mr Pringle, I think my little session will come back to this. And
I'm going to take this opportunity to rotate the call, and we'll go to Senator Whitten.
Thank you, Chair. I've got some questions for the Family Circuit and Federal Court.
Yes.
I've been advocating for the establishment for an office for men due to the many issues that are unique to men in Australia, and not to take away from the office for women in any way, shape or form, because I'm just not sure that the Special Envoy is helping. One of the most prevalent issues that that my office hears is that men are not being treated fairly in the family court system. Could you describe to me the basis under which custody of children is decided under the family court system?
Thank you, Senator.
And sorry, I'm really quite deaf, so I'm okay for yelling.
Okay. No problems at all. Senator, the fundamental and paramount element of the family law system and what our judges and registrars are required to do when hearing parenting disputes in particular is the best interests of the child. Everything that they do is geared towards ensuring that despite what warring parents might be asking for, the best interest of the child is looked after. That can lead to all sorts of different outcomes. It can lead to shared parenting. It can lead to supervised contact parenting visits, or it can lead to no contact orders for either the mother or the father. So at the heart of everything that is done by our judges and registrars, and they're very, very passionate about ensuring that they comply with this, and we have a full court children's service as well that is geared towards finding the voice of the child, interviewing the families, including the children and the parents, and providing expert reports to the judges and registrars. Everything is about the safety and the best interests of the child.
So I've got some statistics out of the Australian Institute of Family Studies from a report from 2019. The father gets majority care 7% of the time, 50-50 care 9% of the time, and mother majority care 84% of the time. So what you've just described makes it all sound very fair and reasonable, but surely the best interests of the child, those numbers just don't suggest that could be correct.
Well, Senator, I don't have that to hand, but I can say that the reality is that the vast majority of parents who are separating don't go through our court system. They resolve between them, usually on an amicable basis, sometimes with lawyers, through other processes. The matters that come into our system involve very serious major risk factors, and that includes in excess of 80% of our parenting disputes alleging family violence and very high levels of potential harm to children. So the matters that come through our court system for Division 1 and Division 2 are in a sense uncharacteristic of the broader family law disputes that might be occurring. But we know that family violence in particular is endemic in our country. As the Chief Justice has said, it's a national disgrace. And we see it playing out at very high levels. So the figures that you quote there, or the outcomes that come out of the decisions of judges and registrars in this process, are guided again by the evidence that's put before them. They can only go by the evidence that's put before them, both in cross-examination and in material. And it's guided by those best interest provisions that I mentioned earlier in the Act. So the outcomes fall where they fall based on careful consideration of the evidence, including the interviews that are done by our expert court child experts in interviewing the family and the children. So I can't comment further than that, I would say, other than to say that I think that whatever the statistics show at the end will be as a result of the nature of the cases coming through and the evidence that's been put forward before the judicial officers.
I'm going to give you another scenario. I went through a separation, and at the time I went and found the best lawyer I could find, and they said to me, my ex-wife could have been in the garage selling drugs and my son could be in the lounge room watching The Simpsons, and there was no court in the land that was going to give me custody of my child, despite me being a good parent, so I didn't pursue it. And I guarantee you there are many, many men that feel the same way, that get the same advice, and you're looking at statistics saying, well, that's how it is, and I'm suggesting that may not be the case.
Well, I'm sorry you went through that personal circumstance, Senator. The advice there, I think, doesn't fit with what we see. And there are many times when our judges and registrars have to order medical testing, hair follicle testing for mothers as well as fathers, making sure that substance abuse is dealt with so that the children can be looked after carefully. Again, I can only stress that our judges and registrars are very, very well trained. They come with extensive experience in this area. They rely on the evidence that's before them. And if they have a case where the risk is high at the mother's end, they will protect the child and make appropriate orders the other way.
But of the 80% or whatever, the figure was that you quoted of people that don't make it to court, there's been no assessment of those people. It's been a self-assessment between the parties. And if your lawyer is saying to you, mate, you've got no chance, or you're going to spend, you're going to lose your house over this, do you agree that that could potentially skew the numbers? I understand.
If that was characteristic of the advice, can I say I've heard the same the other way, that there are many, many women who in fact feel that they can't bear the process of going through the litigation process, the family violence issues that they raise, the trauma that the process can put them through. And they sometimes don't want to go through the process for reasons like that.
I am not taking away from the fact that there are some pretty average blokes out there, and I'd like to say something more drastic than that. Yeah, we all would. So there's no confusion there on how I feel about that. And I don't advocate for those men at all. They're on the opposite end of the spectrum to me. But I do advocate for the fathers that are good. There are some good fathers out there. I'd say many good fathers, and that just feel helpless and lost. My office is contacted by so many of them. And I've got a few more questions that I'll move on to. There's a big discrepancy in the care time. Have you seen what's happened in places like Kentucky in the US, where the presumption has been equal custody?
No, I'm not familiar with what's happening in Kentucky in the US. I'm sorry, Senator.
So in Kentucky, they've seen divorce rates drop at a faster rate than the rest of the country. Is that something that you would look into?
I'd be happy to take on notice any data and what model they're using to achieve those results. Very different systems can apply in different states in the United States.
Yeah, I think the basis is that it's a assumed equal custody as a starting point, and then working backwards from there.
That was a system we had not so long ago, Senator. In fact, it has been changed legislatively, I think in June last year, to remove that presumption and to focus on the best interests of the child.
Okay. Yeah, look, I'll leave it there, but...
Senator, if it's helpful at all for you, I'd be happy to, essentially on taking a notice process, give you an indication of what men's-related programs might be relevant and what the courts are doing to deal with those sorts of considerations, if that would be of assistance.
Yeah, sorry, actually, I did have one more thing. Have you ever considered a national database for orders to allow for faster and cheaper resolution of cases? Because something that we're hearing is mum lives in one state, dad lives in another state, dad turns up to see the children, and mum says, sorry, Johnny's got a cough. Dad has to then go back to court, spend more money, fight it, and there's no penalty for it, and there's no compensation for it. It really, once again, I know there are bad fathers out there, and I'm not advocating for them, but there are good fathers, and I am advocating for them.
Yes. Well, there's two things I'll say briefly in relation to that. Firstly, the need for better data right across the board is right, and our Chief Justice has called for, in particular, the state territory system, which is a criminal justice system, and how that intersects with our system, the family law system, to synchronise better and for data to be shared more effectively there. We do have data sharing that occurs with state and territory police and state and territory child services, which is very effective, but it would be better to have a database that's somehow connected in. The second thing is if a parent, whether it's a mother or a father, is not complying with the necessary court orders, we have now a very fast system of going to the court and seeking orders alleging that the other parent is in contravention of the court orders, so that within a matter of a handful of weeks the matter can be triaged by a registrar and, if necessary, streamed off to a judge. So there are processes in place now to be able to deal with those issues swiftly within the court.
Do you need representation to...
No, you don't need representation. Obviously, it's desirable if everybody does have that, but you can appear unrepresented on those applications.
Okay.
Thank you,
Thanks, Chair.
Senator Whitten and Mr Pringle, for offering to provide further information on notice. Senator Pocock.
Thank you, Chair. Thank you very much for your time here this morning. I've just got a few questions around the court processes and policy relating to divorce. As I understand it, to file for divorce, you have to be separated for at least 12 months and 1 day.
That's right.
And that there are no exemptions to this timeframe for survivors of family and domestic violence. I recently met with a constituent whose husband is currently on remand, charged with attempted murder, and she can't fathom why she has to wait 12 months and 1 day to file for divorce when there's clearly no desire for reconciliation. I appreciate that any change would be a question for the Parliament, but from the court's perspective, are there any ways that this could actually be dealt with in the existing laws?
The provision, Senator, that you refer to is enshrined in statute, so it is a requirement, and our registrars who deal with those divorce applications do have to make sure that that requirement, 12-month requirement, has been complied with. Otherwise, they cannot grant a divorce. The reality is, I believe that provision is in there because it is not uncommon for parties to seek to reconcile at various times, and so it's a policy position that the legislature has taken to say that 12 months is needed. And I appreciate the family violence issues. We certainly have very extensive programs within the court to support people going through those difficulties. But that matter that you raise would be a matter, I think, of policy for government to seek to change if that's required.
Are there any other precedents or examples around the world where things are done differently when it comes to clear examples of family and domestic violence?
I think the reality is that they should be separated for the 12-month period, but in circumstances where family violence is occurring, one would hope, and with wraparound services that are being funded to varying degrees, that they can get out of that situation as a separate issue to the actual divorce, which is a legal issue, and keep themselves safe. Again, we make referrals to support services for those sorts of issues all the time. So I think there's the issue of safety on the one hand and the issue of legally what's required for somebody to be divorced. The first issue of safety we're very much involved with and deal with right across the court in all separation or parenting matters. The issue of what's the appropriate time frame is, again, as I mentioned before, a matter of policy.
And I think, Senator, it's not something I'm aware that's been raised specifically with us before your question. Okay. We would probably expect, as Mr Pringle said, it's a policy matter, so it would be more likely to be raised maybe with government.
Okay,
Senator, if I can add, Chris Collett, Acting Deputy Secretary, Justice and Communities, picking up on the comments from the court, I'm not aware of that particular issue being raised previously. I can certainly see the power of the story that you shared with the committee today. I draw to your attention that following the three bills, now acts, that Parliament has passed, reforming the Family Law Act in the last couple of years, that go to both streamlining legislation as well as improving protections for children and better considerations of family violence. There'll be 4 statutory reviews under those 3 acts in the coming period, which will be an obvious opportunity for these sorts of issues to be raised. And if there are representatives or individuals across the community who want to bring that up, there'll be a vehicle to take that forward.
Thank you, Mr Collett. That's really good to know. Just had one other question on this, and that's around the serving of papers and the cost of filing for divorce. For someone like this, Canberran who came to me, clearly some pretty severe financial consequences the fallout of this violence. She needed access to crisis payments, and then she still has to pay the $1,125 to lodge her application for divorce. Why isn't there a waiver for people who are in these sorts of situations when your partner tries to kill you and you want to get a divorce? Why do you still have to pay that fee? It seems like an unnecessary additional impost.
Senator, you're testing my granular understanding of the regulations here now, but my belief is, and I'm happy to confirm on notice, that there's a reduced fee that can apply for those sorts of circumstances, and that is at the discretion of the court based on the information provided. So there is some provision there for assistance in that regard.
And I think, and further to Mr Pringle's answer, yes, there's built into the regulations, there's a reduced divorce fee. There's provisions around who's eligible for a reduced fee.
What's the process to get that? Do you have to go through a application process, or
there would be things you would have to demonstrate. So some of the, for example, are you recipient of legal aid? Are you a pensioner, holder of certain cards, concession cards, things like that? So there would be a process.
Essentially a hardship process, clarifying hardship.
But what if you're not? Like, what if you're someone who doesn't actually get those payments, but you're just trying to divorce someone who tried to kill you?
Well, the fee is geared towards the capacity to pay. It doesn't second guess what other factual circumstances are happening in the proceeding. Sure. It will look at whether the person has the ability to pay the fee or not.
It's a financial hardship consideration.
Well, maybe it should, but again, that's probably for the Parliament to decide. So thank you very much.
Ultimately.
Thank you, Senator Pocock. We're now at the morning tea break, and senators have indicated they've got further questions, so we will resume with you after the morning tea break at 11 a.m.
Thank you, Chair.
Thanks so much. We will resume and proceed to questions. Senator Blythe.
Thank you very much, Chair. And I'm just going to go back to VIQ, which I know Senator Shoebridge started with, and you did provide a pretty good explanation there. I just wanted to go into some of the more specifics, if we can. Can I just ask when the court first learnt that VIQ had subcontracted to an overseas company, or had their subcontractors subcontract out?
It was sometime after VIQ Inc., the Canadian entity, made their public announcement in Canada to the market, which was then forwarded to us. So I think that was around 26 February that occurred, and so we would have learnt shortly thereafter.
Okay.
I'd have to take on notice the precise date that we received that information.
That would be helpful, but that's a good ballpark. So that's around the same time that the ABC broke their story?
I believe that it was a very similar timing, yes.
Yeah. Okay.
In February.
So can I ask why there was the 6-month lapse between the court knowing in February 2026 and this occurring, given that employees that were based here in Australia knew about it?
I'm sorry, Senator, and what occurring?
In terms of subcontractors being based overseas.
That was just unknown to us as a court,
Okay.
and certainly, as I understand it, to my federal court colleagues as well. So the contract couldn't have been more crystal clear that that wasn't permitted without consent or approval. That was never sought and never provided. So the first we learnt about it was when there was starting to be allegations in the media, but when VIQ made their public announcement, it was the first that it was known.
Is it fair, though, that your own contractors, employees here in Australia knew and still the court for 6 months didn't know?
I'm afraid I can't answer that question. I don't know who other people knew at the time. I can distinctly remember the first I became aware of it. Beyond the broad allegations that were in the media at the time was when the public announcement occurred by VIQ Inc.
Okay. Can I ask...
And sorry, I should clarify, we don't have contractors ourselves here.
Sorry, no, but the contract with VIQ, so VIQ had a contract with the courts here to provide those services here. They obviously had employees here.
Yes.
And then they've then subcontracted offshore. It's a reasonable assumption that the employees that were based here were realising that work was being done not in Australia.
I suspect so. I know there were a number of industrial issues at the time, and that was certainly part of the difficulties that were playing out for the company, it seems. But again, I certainly wasn't privy to that, other than the broad assertions that were being made in the media around the same time.
Okay. And this may be something you have to take on notice, but if you can provide the date that the Chief Justice and the Chief Executive Officer were first briefed on the breach.
Yes, happy to take that on notice. It'll be very close to the date of that announcement.
Yeah.
Yes.
No problem at all. And then what did the court do in the days that followed that briefing?
Yes, so at that time, the Australian arm had not gone into administration yet. We obviously were very concerned and sought further information from VIQ Inc. There was a meeting held by, I think it was Teams online, to discuss that and a range of other issues. The CEO of VIQ Inc., Larry Taylor, was there, including some other senior executives from the company. And we sought further information regarding the unauthorised access. That was the point in time, as I mentioned earlier, where we were promised that we would receive a report from an investigator, that we would learn all of the information that we needed to know, which has since not been forthcoming.
Okay, thank you. And can I just ask as well, if you take on notice, this is probably something you take on notice, when the court notified the Attorney General when it became aware of the breach?
Yes, I believe yesterday in evidence there was some briefings referred to by one of the representatives of the Attorney General's Department, but in terms of when the court notified anything, I'll take that on notice.
That would be fantastic. Thank you very much. Can I ask, when VIQ went into administration on the 16th of March this year, was there a contingency plan that was triggered as a result of that, or was it just a matter of the court was sort of caught unaware and didn't have a contingency plan?
Yes, a number of very active steps took place there. The first thing is that the contract has very clear provisions as to what services need to be provided. We obviously sought immediate assurances from the administrators that those services would continue. In the early days, it was difficult to get clarity, but over time we monitored the services and they continued to flow in broad terms. As I indicated to Senator Shoebridge earlier, there were some very significant challenges with the possibility and the threat of withdrawal of those services at various times. We therefore had to be quite forthright with the company and the administrators about their obligations. We also wrote directly to the parent company because under the contract there are really clear guarantees where if for whatever reason any aspect of the services can't be complied with by the VIQ Australia, the parent is meant to step in and guarantee the provision of those services. We called for that informally, then we called for it formally, and the response, as usual, from the Canadian parent was less than helpful. Essentially, they just said, well, the services haven't been withdrawn yet, so there's nothing to guarantee, but they gave no assurances whatsoever that they would step in and ensure those services to critical justice systems in the Commonwealth would be provided. Thank you for that.
And I guess in terms of it, and I think you've been quite clear that it's not necessarily something that the court was aware of, that it sort of came to your attention at around the same time as the media stories. You've also alluded to the fact that the contract with VIQ was very clear in needing authorisation to be able to subcontract out.
Yes.
So I think that's fair. In terms of the workers that were used, and I think it was in Chennai in India, were they subject to any kind of national security vetting processes?
Well, it's a very good question, Senator, and this is one of the reasons why we are as frustrated and angry as we are at the moment. There should be.
Yeah.
That's the sort of process that's required by the contract. We have asked for those assurances. We've asked for the FSR report from the parent. We've asked for the local report from the administrator. Those reports have not been provided. Okay, the investigator should be able to answer that question, and still that information has not been provided.
Okay. No, that's... And
can I just add to that then, as a result of that, not only have there been more formal demands with the spectre of potential legal action now forming part of that, which was communications that went out last week from the corporate entity. But in addition, on behalf of the Federal Circuit and Family Court, we have made directly to the Information Commissioner in Canada a formal complaint against the parent because of the failure to comply with the necessary requirements, and we have made also a complaint to the company regulator in Canada formally. Okay, thank you. In terms of within the court itself, did you have someone who was responsible for VIQ's compliance and contractual security obligations? Not within the Federal Circuit and Family Court of Australia. The structure is that the corporate entity is the contracting party on behalf of the Commonwealth and the courts. And then there is a separate shared services structure called Registry Services that administered the contract and ensured that the services were being provided the way they needed to be. So it's a shared service provided to all the courts. So I guess in that, are they still
and I guess what are the ramifications of, I mean, this is an enormous breach that wasn't detected. Have there been any changes to how that shared service operates?
Essentially the same structures are in place because we remain in the same contract at present with VIQ.
Okay.
That contract is up until 30 June. So that structure remains in place. But you mentioned earlier the concept of contingency, and if it's helpful now, I can clarify where I think things are likely to be headed in the near future.
We might come back. I have one last question on this block and then we might circle back. Can I just ask if there were any audits or compliance checks done by that shared service in the duration of the contract?
Certainly there was ongoing and quite frequent interaction between the shared services team that deals with the quality assurance aspects, and because there were degrading of the services over many periods of the life of the contract.
Okay.
So there was constant engagement by them, and I think they worked very hard to try and make sure that the services were delivered very well, or as well as they possibly could ask for. But in terms of a formal audit process, I'm not aware of one being done. When this unauthorised access issue occurred, my belief is that we also asked for an independent audit of that process in the communications, but again, there's been less than helpful compliance at a number of ends.
And that shared service, where does that sit in the hierarchy? What department does that belong to?
Yeah, so there is a corporate vehicle called the Federal Court of Australia Corporate Entity, which is essentially a shared services. It supplies what are called corporate services under the legislation to the Federal Circuit and Family Court Australia Division 1 and Division 2, and also the Native Title Tribunal. Those sorts of shared services or corporate services are things like security, IT, the normal sorts of corporate type services. So a lot of this sits under that structure.
Okay.
And the head of the agency for that structure is Cia Lagos from the Federal Court of Australia, who I understand will be giving evidence shortly. But that structure is, the entity itself is comprised of a number of individuals across the courts, and she heads that up and has heads of corporate as well who support.
Fantastic, thank you.
Thank you, Senator Blyth. Senator Shoebridge.
Thanks, Chair. Now, Mr Pringle, I think when we'd last been discussing, we had got to the point of the notice had been provided by the Canadian parent about the privacy and data breaches. I think we touched upon the fact of the administration, and which happened in March. So there would be February for the notice, March for the administration. You'd said that VIQ have been making demands for a significant increase in the contract. Did you say more than $300,000?
Correct.
For what period? Per month? Are you, in your negotiations with the Federal Court, have they explained to you that they've entered into a fresh contract with VIQ Solutions?
No.
Yesterday?
No fresh contract has been entered into, to my knowledge, with VIQ.
Well, a contract variation, it would appear yesterday. Have they spoken to you about that contract variation?
That would be a complete surprise to me, and certainly not one which I would sanction.
Because, AusTender has the Federal Court of Australia publishing an amendment to the VIQ contract with a new contract value of 15 million, almost 16 million, when the previous one had been 10 million.
I'm sorry, Senator, you're taking me by surprise on that one. I'm sure I would have heard of it if it was an actual contract extension to the existing contract, but that's completely unfamiliar to me.
All right. Because it literally turned up on AusTender, published yesterday, but they haven't spoken to you about this?
I'll have to take that on notice, and if during the course of your further questions I can get any further information on that.
Maybe the Federal Court can explain why. Maybe this relates to a failure to disclose an earlier amendment to the contract. I don't know. But you're not aware of that?
No, I'm not aware of it. Certainly, if the suggestion is that a contract extension with the existing company in administration has occurred in any way, that would be a complete surprise to me.
Okay, all right. And you're not aware of why an amended odds tender filing was made by the federal court yesterday?
No, not unless I see the specifics of it, Senator. I'll be happy to take that one on notice.
All right. Well, I'll get a copy provided so as you can take that on notice. Thank you. So the voluntary administration happens in March. You're obviously concerned about data and privacy and what's happening to the, many thousands of records that VIQ have from your court.
Yes.
What do you do?
Well, the process involved a number of different streams. So part of it was communicating with both the parent and the company and administration in Australia, making demands for the services to continue. And I think you may have been out of the chamber at the time that I answered earlier, also making demands of the parent to comply with the strict guarantees under the contract, because we were receiving repeated threats of the possibility of withdrawal of services and, of course, the additional funds being sought. So that was one stream of essentially trying to get compliance with the contract. We felt, certainly I did, on behalf of the FCFCOA, offended that parties could act as if contracts can just be flippantly complied with or not. But
were you a party to that contract, or were you receiving services from the contract negotiated by the federal court entity?
The latter. The contract's entered into by the entity on behalf of all of the courts.
All right. Yeah. And then you make payments. Do you make payments to the federal court, or do you make payments to VIQ under that arrangement?
My understanding is the entity would make the payments, but if it's transcript services done for our court, we would ultimately be the payer of that, and if it's done for the other court, they would be the payer. So
the federal court is the clearance. The federal court entity is the clearance.
Yes, the
so
corporate
you pay into their account, and then they make the payment to VIQ.
All of our finances are done through that corporate structure.
Understand. All right. And so, just to be clear, can you recall at any point being notified by the federal court that there was a $5.3 million increase in that contract with VIQ Solutions?
No, absolutely not. Certainly the administrator did ask for those sorts of things and repeatedly rejected by us and the entity as well.
Yeah. I mean, it could be that this has just been a failure by the federal court to notify about an earlier amendment to the contract from 2024. It's not entirely clear for me from these AusTender documents. Does that ring a bell? A $5 million variation in 2024?
A hangover, Senator. Again, it would come as not just a surprise but a shock if that was something that had occurred because of an extension happening now.
Do you remember any discussions in the middle of 2024 about an extension of VIQ's contract, any due diligence or any responses?
No, back then, as I think I may have clarified last estimates, our involvement was really quite peripheral. I've had much more involvement since the crisis has arisen in February.
Okay. What have you done to check that the data, the integrity of the incredibly personal information you're entrusted with as the Federal Circuit and Family Court? What have you done to find out what's happened?
Well, we've sought verification of the number of files and which files they are. That figure unfortunately has moved around in terms of number of files a number of times, which is one of the things we want to verify with the investigators.
And how did you get that figure? Was that offered to you by the administrator?
No, we had to request the information, and then the specifics were provided, I believe, in emails through to the corporate entity, and then there were further clarifications.
Okay, but that's information that's been volunteered by the administrator, is it? That's come out of that process. It's not as a result of you putting a forensic audit in the field.
Oh well, no. The specific requests were made both by on our behalf, but by the entity on behalf of all of the courts for clarification of how many files were affected.
Well, you see, I have just prima facie difficulty accepting the number of 130 files if there were 5 people offshore in India processing it, because I've had people contact me, which seems to put a strong case that there were dozens and dozens of files being dealt with each day by these 5, by the people offshore in India. And those numbers don't seem to add up for me. that if you have 5 people offshore in India working for a consistent period of time, and on the material that's been shown to me, it looks like dozens and dozens of files being dealt with on a daily basis, which raises quality issues, I might add. I don't see how you get the 130 or 136 unless they only worked for half a day.
So, Senator, I think it would depend on which end user they were working for, in the sense that obviously we weren't the only clients for VIQ. They service state and territory courts and various other agencies. In addition to that, it's actually quite a complex thing, and this is one of the reasons we want the report, so we can actually get to the bottom of it, is that my understanding is the way VIQ worked is they didn't give one whole proceeding to somebody to type up. They would break it up into chunks as small as 15-minute units of time. And so a number of different people could be typing up one proceeding in different parts of the country.
Which is all the more reason why I'm suspicious
It could
that
be
we
higher.
only have 130 matters.
That's one of the reasons why we're not in a position to take further steps, and we've called so heavily for the report, and at this stage I think might need to legally compel the provision of the report.
But I'm just trying to be clear how you got the 136 figure. Has that been provided by you as an assertion by VIQ Solutions administrators, but you haven't been given an audit report or the data underneath? It's an assertion that's been given to you by the administrators.
With file numbers, as we understand it. So they said these are your potentially affected files, and that number changes, I indicated, a number of times. And so we want to get to the bottom of this properly.
So you're hitting a wall with the parent company, you're hitting a wall with the administrator, you haven't got access to the audit that they've undertaken. Was it AKR or the name?
FSR.
FSR. That's
the Canadian Parents Action, their report and their investigator. There was apparently a separate report undertaken by, or process undertaken by the administrative company and administration.
And who undertook that report?
I'll need to take that one on notice. I believe the entity will be able to answer that question for you.
So then, what have you done? I mean, have you looked at your own data? Have you done your own forensic analysis of where your data and where your information moved? Or looked at what's come back to see if there's some kind of digital trail to explain it?
Yes, I believe that the entity has had that consultant on board to help them to make sure that there haven't been more extensive, obvious breaches, that our systems have been looked at closely. And to the best of my understanding, though I'll defer to my colleagues on that, that there's been no further breaches identified. So this is why it's so important to get our hands on the relevant reports and understand what the investigators within the companies have found.
All right. And who has undertaken, are you aware of who's undertaken that work? Is that the Cyber CX, is it?
Yes, I believe they were involved. And
by
of course,
who contracted, as you understand, Cyber
the corporate
CX?
entity would have contracted them, and then within our corporate entity there is a cyber security team as well.
All right. And what has your cyber security team, have they produced a report?
Not that I've seen, but they've been I mentioned them because I understand they've been the team that's liaising with the consultant on that investigate or that process of.
Have you consulted with the Privacy Commissioner about your obligations to provide notice to the 136, well, the litigants in 136 matters? It may well be many more than 136 people. Have you consulted with the Privacy Commission about when your obligation crystallises to inform them about the actual and or potential privacy breach?
The answer in terms of the Federal Circuit and Family Court is no. I believe the entity has had engagement with a number of official agencies. You may want to check with them as to who they've engaged with. You may have been out of the chamber when I clarified that we've made a formal complaint to the Privacy Commissioner in Canada and a formal complaint to the company regulator in Canada over the conduct and lack of provision of material.
I did hear that online.
Yes.
But you, of course, have your own separate privacy obligations, distinct from the federal court entity.
Correct.
And they are serious obligations,
They are.
including to people whom you hold deeply personal information.
Yes.
And so I am surprised that you haven't gone through the process of contacting the Privacy Commissioner and having a thorough understanding about your obligation to notify litigants whose data has, on the face of it, been breached in this way.
Yes, well, this is the difficulty, Senator. Until we know the extent of the potential breach, it is actually very hard for us to form a view as to what steps we are required to take. The reality is that as soon as we understand the extent of that breach, the sort of approach you're suggesting is one that would be taken. But at the moment, we would be able to make some sort of technical approach, but the Privacy Commissioner would struggle to give us any guidance because we don't have the detail we need to explain what the nature of the problem is.
Are you looking to separately contract going forward the services of a new entity to provide the transcript? Are you looking to bring it in-house like the High Court does?
I can say with absolute certainty from the Federal Circuit and Family Court of Australia's point of view, and I've got to be mindful of the fact that this is a collective and other courts can take different positions and views, is that the current model which binds us to an exclusive arrangement for one provider for all our transcript and recording services is just not workable, and in fact it is a risky model as that had been shown. We, as was indicated by the Secretary of the Department yesterday, would prefer a model where we can bring in within the courts as much of this as possible and build a system which is cost effective and genuinely accessible to the average Australian. When one considers the nature of the proceedings we have, the average person who goes through in family law, 84% of our migration applicants are unrepresented. The reality is the sort of model we have, which is cost prohibitive for most litigants, is just completely unacceptable.
Well, indeed. But as this discussion's happening inside the court,
yes,
all the rabbits are running in terms of the tech sector, and I've been given examples of one company that's putting itself forward as a potential front runner, which is Fingerlinks Infotech LLP, also based in India, that has been aggressively advertising for court reporters to come on board in Australia. Have you had any communications or engagement with Fingerlinks Infotech?
No. First time I've heard their name.
All right.
But ultimately, I think it's about making sure that we have something that's quick, cheap and accessible, both in terms of the recording and the transcript for the average Australian to
But surely one of
access.
the other lessons, and I'm surprised I don't find it in the adjectives, which is safe and secure.
Absolutely. Given the nature of, and I think I mentioned that at last estimates, given the nature of the cases that we have to do that in a safe way, which is actually quite complex with family
And
law.
I might even suggest another word, sovereign.
Indeed.
Not subject to a Canadian or an Indian or another multinational.
Senator, I couldn't agree more. That's a deal breaker from our perspective.
Thank you, Senator Shoebridge. Senator Scarr.
Thank you, Chair. Mr Pringle, I want to return to the matter of Ms Sturgis, and I'm going to ask a number of further questions. I anticipate you may well want to take some of these on notice, but it is important I put these on the record. In relation to the concerns that were raised by the Human Resources Department in relation to Ms Sturgis's performance as a registrar,
yes.
Are you aware that Ms Sturgis, or have you seen the opinion Ms Sturgis received from the Honourable Michelle May, AMKC, someone who served as a family law court judge for some 22 years? Have you seen her response?
Yes.
Were you aware that she responded to the concerns raised in the letter dated 28 January 2022 in relation to Ms Sturgis's performance as a registrar? And I quote, "In my opinion, the concerns and their suggested consequences are entirely misconceived." End quote.
I don't remember the specifics of the letter, but something along those lines I do recall, Senator. And again, the reality is that Ms May was provided with only one version of events at that time.
Well, she was provided with the notice of concern letter that the HR department provided to Ms Sturgis.
Yes,
that's correct,
and
isn't
no
it?
other information from any of the complainants in the court against Ms Sturgis or any other information of that nature, to my understanding.
And you wouldn't have thought that Ms May would consider that in terms of formulating her opinion if she had a concern with that?
I believe she formed the opinion she did based on what she was provided by Ms Sturgis.
Okay. Can you tell me what consideration was given by the court in terms of issuing the concerns letter to Ms Sturgis with respect to Section 99 of the Act, the Federal Circuit and Family Court of Australia Act?
So, sorry I don't have that provision immediately to hand, Senator, but to my understanding, and these events occurred some time ago, there were no issues being raised by Ms Sturgis whatsoever until HR approached her in relation to complaints being raised by others.
Okay. So
that's what precipitated all of this unfolding.
Well, that's the court's view. I accept your view.
That's the factual
and
view.
you've got it's your view. Can I ask you, so do you know what Section 99 of the Act says?
I'm sorry, I don't have it in front of me. I'm happy to, if you want to refresh my memory on it.
Well, it does surprise me, Registrar, that you don't know Section 99. I would have thought this would be bread and butter in terms of the Federal Circuit and Family Court of Australia Act. It's the independence of delegates.
Yes.
And it says, despite any other, well, I'll read it for the record, for your benefit. Despite any other provision of this chapter and any provision of the Public Service Act 1999 or of any other law, a delegate is not subject to the direction or control of any person or body in relation to the way in which the delegate exercises powers under Section 98, end quote. So my question is, in relation to what consideration did the court give in issuing that concerns notice with respect to the performance of former Registrar Sturgis's powers? What consideration did the court give to the effect of Section 99?
Absolutely, I can clarify the position in regard to that. All judicial officers, both judges and judicial registrars who perform their functions with delegated functions from judges, are independent decision makers. Their opinion, their outcomes should not be influenced by anybody else. They've got to be independent. That confuses fundamentally the issue with conduct in the workplace and whether it's appropriate to manage the performance or the conduct of a judicial officer. Even judges are subject to that sort of process, as we've heard before, but what was confused about this process, to my understanding, is that Ms Sturgis asserted that HR were not entitled to even question her about the process of performance that she undertook because of her judicial independence. That is just incorrect as a matter of basic principle. Of course, the conduct and performance of a judicial officer can be investigated, should be investigated, particularly when serious wellbeing issues are being raised. The notion that someone's judicial office doesn't entitle the inquiries and the investigation process to be undertaken is completely wrong.
Well, in relation to the actual, I note, though it has particular resonance in relation to examination of the orders which are made by the registrar, yes, and whether or not questions around whether or not a particular order should or shouldn't have been made really fall within the purview of independence of the registrar, and there are ways in which review can be sought of orders which are made.
That's
is that correct? You
that
agree
is
with
correct,
that?
Yes.
Okay.
Although that was one of a range of issues that was being raised by HR at the time. It wasn't the sole issue at the time.
The last few questions on this, if you could take it on notice, and I'll give you a few other things to take on notice. Were there any orders made by former Registrar Sturgis which were amended, varied or replaced by other registrars during this period from 1 January 2021?
I'll take that on notice, thank you, Senator.
Okay. When you take that on notice, could you, if there were, could you please explain the process that was undertaken with respect to the amendment, variation or replacement of those orders, including whether or not the process under Section 100 of your Act with respect to the review of orders made was complied with?
Yes, I'll take that on notice.
We've talked about the federal court proceeding that was discontinued. We've spoken about the Comcare matter. Were there any other court proceedings instigated by Ms Sturgis in relation to this matter?
Yes, I believe that she brought defamation proceedings against a junior staff member, which again have not proceeded. And that's been discontinued.
Okay. Can you take on notice, please? Can you provide me with any submissions or documents which the federal court provided in the course of those proceedings, including by way of discovery?
I'll take that on notice.
Okay, thank you. And I may have some further questions on notice. Mr Pringle, I want to emphasise I have great respect, as you know, for the work that this court undertakes. I don't raise these matters lightly. From my perspective, and this will be the final question I ask you to take on notice, I think, would you undertake to take on notice as to whether or not serious consideration should be given to an independent review of this matter by someone external to the federal, to the court, including potentially senior counsel?
Thank you, Senator. I will take that on notice, and I'll also say I very much respect the position you've taken in regard to registrars in particular in the past. The reality is extend again the invitation to be able to clarify matters for you further, as was suggested earlier. This is a very, very delicate and complex matter that does require further clarification.
Okay, thank you.
Thank you, Senator Scarr. That concludes all the questions that we have for the Federal Circuit and Family Court today. You release with our thanks.
Thank you, Chair.
We will now take a short 1-minute suspension while we welcome the Federal Court of Australia. Ready? Here we go. We're back. Broadcasting's back on. I now call officers from the Federal Court of Australia. Ms Lagos?
Yes, thank you.
Would you like to make an opening statement?
No, I don't. Thank you, Chair.
Okay, we'll proceed directly to questions, and we'll begin with Senator Shoebridge.
Thanks, Chair. Well, maybe we can start with clarifying why there was an amended Oz tender contract notice published yesterday by the Federal Court that indicates a $5.3 million increase in the contract value to VIQ Solutions. What's that about?
Thank you, Senator. This was an administrative action taken, and I'll refer to my colleague here, Cara Lawson, who is directly responsible for the procurement and contract management aspects of the entity's operations, and she's made appropriate inquiries to respond to that.
Yeah, and it's a contract that ends in, what, not even 6 weeks, on the 30th of June.
It's a historical correction, as I understand it.
Yeah, it's to correct an error. So as part of our work in looking at VIQ holistically, we looked at the Oz tender listings and noticed a few administrative oversights or errors, and the $5.3 5.3 million is part of that to fix that. That represents the first option that we undertook of 5.3 million from 1 July 2024 to 30 June 2026. So that hadn't been recorded in AusTender, and it now has.
So you failed to deal with the compliance requirements on a $5.3 million contract with VIQ Solutions, and this is what, 2 years afterwards, trying to correct that failure.
That's right.
How on earth did you have such a significant failure, and how isn't that part of your due diligence and the systems you have in place when you extend a contract? We're talking about $5.3 million of public money. How did this happen?
It was an administrative oversight. It wasn't included. There were also a couple of other elements that we needed to fix, and that included the actual name. We had a change to the supplier name, which was updated, and there was also the start date, which was updated as well.
Wrong start date, wrong amount, wrong contracting entity. Did you get any of it right?
I'd have to take that on notice.
If I could add to what Ms Lawson has outlined, Senator, it has become palpably obvious to the entity over a period of time that we require more expert resources for fundamental processes in corporate services. The courts have expanded rapidly. Their operations are complex. They are national in their operations. There are matters to do with finance, there are matters to do with buildings, there are matters to do with very important contract elements and the like, and we take all of the obligations around our reporting requirements very seriously.
Who authorised the $5.3 million contract variation to extend the contract? Who authorised it? Who ultimately signed it off?
That would have been me as the head of the entity in the context of there being a thorough evaluation process to determine if the contract extension was appropriate, and this is back in 2024.
Yeah, what was this thorough evaluation process? Did it look at guarantees about continuity of service in Australia? Did you do any data forensics to see what had been happening under the contract for the 4 years that had been running up to that point before you signed a $5.3 million extension with VIQ Solutions on a contract that has now unravelled so badly?
The contract had been operating for a period of 4 years and had been actively managed by our contract management, administrative and other roles, and there was no reason at that time beyond making sure that every element of the contract that related to security, data security, confidentiality, privacy, and all those specific contractual requirements were reinforced and extended into the extension.
They were elements in the contract. They'd been elements in the previous contract. Did you undertake any due diligence to see whether or not those elements were actually being complied with by VIQ before you signed a $5.3 million contract extension with them?
There was an extensive process undertaken by members in the corporate services and the court and tribunal services team that produced that recommendation that it was appropriate for us to seek an extension of the contract.
That's a generic answer to my very specific question. So perhaps you could answer my specific question. Did you look under the bonnet? Did you do any separate data investigation, any separate forensic investigation to go beyond the bland assurances that VIQ Solutions were giving you to see whether or not they were complying with the contractual obligations to protect Australian data, to protect Australian privacy? Did you do any of that at the time you signed a $5.3 million extension with this company?
I relied on a recommendation of senior people who had undertaken that evaluation and made that recommendation to me as the head of the entity, and I accepted that recommendation. Beyond that, I think it's preferable that I take the question on notice and provide you with further information.
Well, you see, as the Chief Executive, you don't just sit there and simply rely upon recommendations. It's your job to test them, to see if the appropriate considerations had been looked at, to see if there was a thorough examination. We're talking about a $5.3 million contract extension providing an essential critical service to a major public institution. Did you ask whether or not that due diligence had been done in the manner that I've just put to you before you put your signature on it?
The recommendation included due diligence actions, and at that point in time, Senator, VIQ had been providing those services nationally across the federal courts for a period of 4 years without any incident. In addition, VIQ had been providing those services to other state courts and other institutions, with the fundamental tenets of the contract being that they were a specialised company who ensured that all the necessary controls were in place to provide for data security, confidential information being processed in particular ways and the like.
That's what they said. That's what was in the contract, but you never checked. That's the problem. Do you understand the problem? That's what they said. That's what was in the contract, but you never checked. Why not?
Because the people who had been actively managed the contract made that recommendation on whatever the engagement had been for a period of 4 years without those matters being traversed as matters of concern.
Did you have the benefit of hearing the evidence from the Federal Circuit and Family Court?
I did, Senator.
Is there any part of their evidence that you disagree with or you think should be corrected?
Absolutely not.
Well, then I won't traverse the sorry history that they gave a very frank summary of, and I'm grateful for their frankness. Where are you at in terms of now, finally, getting the Commonwealth, through you, to check what on earth happened to people's deeply personal information? Where are you up to in actually trying to get some answers yourself?
Beyond being absolutely clear that the conduct of VIQ was totally unacceptable, was in absolute breach of significant contractual terms. I just want to make sure that our position in relation to what has transpired here is absolutely clear. We find the conduct totally unacceptable.
What have you done?
And in breach of very critical contractual terms. We have requested all information under notice of compulsion under the contract from VIQ in relation to those circumstances. We did receive...
Just stopping you there, we heard from the Federal Circuit and Family Court that the request they'd made for the investigation undertaken by the Canadian parent had not produced the report. Have you had any more luck?
No. The request has been made by the entity on the court's behalf and has been repeated. It has had legal escalation and we're still awaiting for a formal response. But we were advised by VIQ that we would be given their internal investigation report. As Mr Pringle has outlined, that has not been forthcoming. In addition to that, we have engaged an external cybersecurity expert who has worked directly with our own internal cybersecurity team. Both of them have reviewed... What is the name of that? It's CyberCX. Our internal cybersecurity team, which has grown over the years and provides very essential services to the court's operation, has reviewed the information provided by VIQ and has given us an assessment that the controls are in place. This was an unauthorised, not permitted change to the method of VIQ's operations that the court had not authorised in any way. And
you had no visibility of, and you weren't checking, and the first you heard about it, unless I'm wrong, was when the Canadian parent company put out a media release. Is that right?
When they issued that release and
because you had no measures in place to do due diligence on what VIQ Solutions was doing with the troves of incredibly sensitive data that you were giving to them.
We had measures in place to know that they had all the necessary security controls and their infrastructure was such that all of the data and all of the recording records were retained in Australia,
Except
encrypted to be only accessed in Australia, and had not been transferred offshore.
Except they weren't. Now, the Federal Circuit and Family Court says that they've had an assertion by VIQ Solutions that they haven't been able to verify that 136 of their matters had been offshored to India. What's the state for the Federal Court?
We have reviewed the 10 matters that related to the hearings of the Federal Court proceedings, and we have an assurance made by ourselves that none of those matters traversed any confidentiality or
Sorry.
order.
You've jumped into something about 10 matters?
10 hearings were
so there
subject
of... There were 10 hearings which were offshored?
Yes. Well, were transcribed
offshore
by staff offshore.
Well, if somebody were they some of the same 5 operators in India that were identified?
We believe so. Yes, on the information we've been provided by VOQ, and on the information provided by the administrators, technology and cyber team that has worked directly to provide our own internal cyber security team with relevant information.
Have they given your cyber team full and unfettered access to their data so as you've undertaken an independent audit?
They have given access to all relevant information, and they're doing so now with CyberCX.
Have you got a report from CyberCX identifying that?
We're anticipating that report to be completed at the end of June. But
so you're currently, the 10 matters is relying upon a self-assertion by VIQ Solutions Administrator?
No, it's relying on more than that, Senator. Our cyber team have carefully reviewed VIQ system design documentation, are now working with the administrator's cybersecurity team to verify that with CyberCX.
Working to verify it?
They're actively doing it as we speak, and have also provided me with information that says that the data resides on Australian servers and is encrypted. So there are controls. The controls have been maintained in place, have always been in place. The technical platform is hosted in Sydney, so in Australia, does not allow data to be downloaded by anyone performing transcription activities. That is our assessment.
There was somebody, there were 5 people, at least 5 people in India transcribing it, putting it on their devices.
No, Senator, and that's an important point. And I am not
so what were they doing in
IT,
India?
but this is a very important point, that the data remained on Australian servers and has been encrypted, so the access is under strict control.
So people, when they transcribe court transcripts, have a record in front of them, in writing, about, Senator Cash said X, the chair said Y, the judge said X. They have it on their device. Did that appear on devices in India?
Yes, it does.
Yes.
But they can't copy they can't take it off that device and copy and paste it into another document.
How do you know that they haven't taken photographs of it? How has your CyberCX team been over to India and had a look at the hardware that was being used and the software that was being used in India? Have they travelled and done that?
I don't have specific. They are conducting a thorough investigation, and I think they're taking the full extent of the measures necessary.
How do you know there weren't screenshots taken?
We could say that in any circumstance.
There's no point shrugging your shoulders.
No, all I'm saying in response to that, Senator, is that those actions can occur in any circumstances. The most important thing, though, that I do want to inform you about is that we have the courts, so the entity has now got direct control of all of the recording data going back to nearly 20 years. We have it under our direct control, with our security systems stored onto our secure platforms. So we have, in the period, in record time, transferred and accessed that data directly ourselves, so we can actually control that data going forward.
Do you even know who it was in India who was undertaking these services? Have you been given the names?
We have asked for that information repeatedly. We have not been given the specifics, but we are working...
Did they have any security vetting? Did they have...
It is... First of all, it was an unauthorised act by VIQ to have outsourced that work. It is specifically prohibited unless they refer that request to us and gain
so you
our
don't even
specific...
know. You don't even know.
We don't
who
have
was
that
doing
information yet, Senator, and we're deeply unhappy about it, and we have asked for it.
And you're telling me that there's nothing to see here, that there was no data offshore, which I find on the face of it an assertion that's impossible to accept, but anyhow. And you don't even know the names of the individuals. You have, I assume that they didn't have security vetting, but you have no oversight about whether they have security vetting. You didn't find out through any of your own activities. You found out because of a media release from the parent company just before it put its Australian subsidiary into insolvency.
The parent company provided us under specific requests with the identity of each of the matters, the number of staff that had been in fact contracted in an unauthorised way.
This is the same parent company that won't give you their own report.
We are deeply dissatisfied with the response. Sorry,
respond to your
Chair.
questions.
Thank you, Chair.
Without interruption, please.
Thank you, Chair. We are deeply dissatisfied with the information that we have been provided. As David Pringle outlined, we are deeply dissatisfied and have escalated that to the full extent possible. We are still pursuing that information through the work of our external expert, CyberCX, and through the administrator's cybersecurity team.
Who's that? Who's doing
They have an in-house, McGrath-Nicol, the administrator, has an internal technology and cybersecurity team. Our cybersecurity team has worked directly with them to be able to gain verification of certain controls, as well as ensuring that CyberCX has the requisite access to what they require to be able to conduct their investigation on our behalf and provide us with a report.
So your evidence to this committee that there are 10 federal court matters is based upon an assertion given by the Canadian parent company?
Unfortunately, yes.
And this is the same entity that repeatedly lied about the assurances that they were giving under the contract. The same entity, right?
It's the same entity, yes.
Yeah. And now you want us to accept that this entity that has a history of lying and breaching its contractual obligations, we should accept their word about the 10 matters?
Sorry. Senator, we have repeatedly taken action to enforce our rights in relation to this matter. We are deeply dissatisfied with where this has landed. We have activated significant contingency planning that Mr Pringle was referring to ensure the courts are never in this position again. Firstly, we have secured all of our data and transferred it so it is directly under our control. Secondly, we have engaged expertise in specific roles from the private market and brought them in-house to give us direct access to the knowledge that we require and the actions that we need to have in place to make sure this never happens again. We have contingency planning that in the event that these services cease or degraded, we can operate independently of any requirements under this contract. We have done this in a period of weeks and months, and we have been relentless in how we have approached this to never be put in this position again. The courts have been able to, we have been able to maintain the services of the court in each of the courts nationally. Multiple proceedings have not been disrupted. We have secured the data. We have got in-house expertise and in-house resourcing that we can rely on immediately in the event that these services are discontinued or that we do not renew this contract come the end of June.
There are internal documents from VIQ Solutions from the Administrator indicating 135 staff have been let go from the organisation. Are you aware of those?
I'm not aware of the specifics, but I am aware that there are other courts and agencies that are relying on these services, and we have had to have regard to that issue to ensure that none of our actions are disrupting their services as well.
135 staff from transcription services in VIQ Solutions have been let go at a huge part of their workforce. Were you aware of that? And have you, well, first of all, were you aware of that?
No, I wasn't aware of that.
Did the Administrator tell you?
Not, sorry.
Because we've been dealing with the Administrator through the process, and they advised us due to some reduction in work that was coming from other courts that they were going to reduce staff, but not at the number. The number they referred to us was 45, and that was 2 weeks ago.
Well, they've been telling internally that the numbers are 135. So that surprises you? That extent
That surprises me, but they've maintained our workload, and there hasn't been a degradation of our services.
Well, perhaps you can give on notice, because we haven't got time to go through it now, what the number of matters that are with VIQ, and if you can, on a month-by-month basis.
Yes.
And if you could take us back 2 years, and if you could give the timeliness of the responses from VIQ going back over 2 years.
Yes, happy to take that on notice.
But you didn't know, they didn't tell you that they'd let go 135 staff. They told you 45 only a few weeks ago.
Yeah, a couple of weeks ago.
VIQ Solutions proudly and publicly said in 2022 that its AI product First Draft was deployed in partnership with courts in Australia. What do you know about First Draft?
I'm not in a position, I don't know anything about first drafts. I mean, the prerequisite, the fundamental requirement under the contract is that they produce manual transcription from the actual recording.
Well, when they made the public statement in 2022, did you just not see it?
I certainly wasn't aware of it, Senator.
Are you in a partnership with VIQ, or have you ever been in a partnership with VIQ for their AI product First Draft?
No, not that I have no knowledge of that at all.
Has transcripts and content from the federal court been fed into VIQ Solutions AI product First Draft?
The requirement under the contract is that it's manually transcribed by Australian-based staff who undertake that transcription based on the recording.
That isn't my question. That is not an answer to my question.
I have no knowledge in respect of any of the matters that you've raised.
Well, have you undertaken any due diligence to see whether or not what VIQ Solutions said publicly was true, that they'd been partnering with Australian courts? Does the contract permit them to use the data for the training of an AI?
Not under our specific contract. The contract specifically provides that the recording is accessed for manual transcription of the recording to be produced as the transcript for the court.
That's a non sequitur to my question. You may well have a contract requirement that does that. Is there something in there that prohibits its use, the data being used to train its AI?
Not that I'm aware as the contract is currently drafted.
Well, isn't that a problem? And what, has none of your cyber team been just, like, I'm not here to do your investigation work for you. This is not my job. Did nobody check that this public statement by VIQ just in 2022 about creating their AI was potentially being fed by the data? Like, this is not my job, this is your job. Has no one done this?
Not that I'm aware.
What do you know about the 10 instances that VIQ have admitted to of data going to India? Or you say it's not data, you say it's just, I don't quite know, can't fully understand your explanation, but of people in India seeing transcript of what happened in your courts. What do you know about that?
In terms of the federal court's actual proceedings, the matters relating to federal court proceedings, is that
Yeah, you're the one who volunteered the 10 that you got from the Canadian proven lying company. Yep.
They identified that it relates to the hearings that were identified were transcribed that related to 10 proceedings. We have reviewed each element of those proceedings and satisfied ourselves that all of those proceedings were conducted in open court. There was no specific confidentiality elements that just on the face, and it's again based on our internal review, there's nothing specific to those proceedings that weren't proceedings of a character that were in open court.
Have you notified the litigants in those matters that their data has been sent offshore without, I assume without your consent, but most notably without their consent?
Once again, we are acting on the basis that the data has not been sent offshore. It has been accessed by people working offshore. I'm sorry to be precise about
can I
this.
tell you this? The screen on which the transcript appeared, where the words spoken in the court appear in writing, that was in India. Something went to India. I can't believe you won't accept that.
They were able to access it. It was labelled by VIQ as a configuration error that was accepted as unauthorised, Senator.
A configuration error.
We weren't happy with that description either.
To be clear, you still haven't got the forensic report that was done by the Canadian parent company that obviously was the basis upon which they made their media statement in February about the data breaches and privacy breaches. You haven't got that?
No, we haven't.
You haven't got
repeated requests.
You haven't got the audit or whatever due diligence was done with the independent report for the administrators here, McGrath. You haven't got that?
Sorry.
We do have a readout from McGrath-Nichols' work. The internal auditors and their cyber technology team did conduct their own internal processes and have provided us verification of some of the controls that were put in place. And I can read them out to you, but their remediation actions included the removal of overseas subcontractor access to Australian transcription work, the correction of role-based access control assignments, which is how the work was actually assigned to Indian-based subcontractors, a review of the access roles templates, which is around the particular people that have been provided access to apply those role configurations, and the validation, logging and audit records. So they do have access to all the records and logs of where that transcription work went, and that's why they have verified.
These are a series of assertions and conclusions.
They are work done by the administrator, and they're working with our own cyber contractor to verify. So they have verified that.
Who's verified that?
It's McGrath-Nichols' cyber technology team.
Have you got the report, the full report, with the data that was analysed by that McGrath-Nichols team?
That's what CyberSeeks is working with McGrath-Nichols.
Is seeking to get now.
Yeah, but they have done verified, so they have verified those actions have been taken. So we have confidence that work is no longer being allocated to workers that are offshore.
This contract ends on the 30th of June. What are you intending to do on the 30th of June?
We are currently considering all of our options as we speak. We're working in direct consultation with each of the courts in relation to those options. But once again, all of our contingency planning is in place. We have all of our data under our direct control, so it is not under the direct control of VIQ or the administrators and us being reliant on that. Secondly, we have brought in specialist resources to be able to operate these services internally and interface with all of the parties of proceedings in the court. We have got available on a contingency basis a range of transcription providers who are ready and prepared to undertake these services for us if and when required. And importantly, we are seizing this opportunity, Senator, to ensure that courts are set up to have this as in-house capability and expertise.
I wouldn't describe this as an opportunity.
Well,
have you had any contact or engagement with Fingerlinks Infotech LLP as one of the potential providers? Right.
Thank you, Senator Shoebridge. Senator Blythe.
Thank you very much, Chair. And I just have a couple of very quick questions still on this topic. And Senator Shoebridge has been very thorough and has got through a lot of what I was going to ask. But in terms of having a look at audits and compliance checks, now I understand from our previous witness that that is something that is done by the shared services. Were there ongoing and frequent compliance and audit checks of the service?
I can't be more specific, unfortunately, Senator, as to say that there were regularised meetings and discussions about the performance under the contract. The structure of the contract was such that VIQ was contracted to provide us with those specific and expert services.
Yeah.
We do not have that as an in-house resource.
No, and I'm not suggesting you do, but in terms of, it seems like this came to their attention thanks to the ABC, not thanks to any kind of internal checks and balances that were in place or any kind of audits. So were there audits that were done to make sure that they were complying with the very strict terms of the contract that specifically said nothing could be done offshore without express permission?
Not that I'm aware,
Okay.
and I can assure you that we have enhanced those controls to the fullest extent possible now.
Okay, so, and I'm assuming there would have been someone in your team that would have been responsible for that?
We have people in the role of contract managers that were directly reviewing and assessing the contract in terms of its performance, yes.
Okay. And in terms of the contract coming to a close on the 30th of June, I just want to clarify, you haven't made a decision that you're just ending the relationship with VIQ, even though they're not assisting with an investigation. You're having to take their word for it that there were only 10 files breached. In terms of an audit from the court side, are you sure that it's only 10?
We are relying on the information provided by VIQ back in March, Senator. We are exercising all of our rights to independently verify that through our cyber experts.
But there's no way you could know?
In March?
Yeah.
You're relying upon information given to you in March for the 10?
Sorry, in February. Sorry, my apologies. I meant in February.
It, yeah. Which is when it came out. Okay. Because it sounds like it sounds like contractually the relationship's completely broken down, and they are probably, you wouldn't classify them as a trusted provider any longer. I'm just a little concerned because I think data was accessed overseas. People can take screenshots, they can take photographs. While there were no privacy, I guess, breaches in terms of confidentiality of the court proceedings, I think it's fair to say that matters that are going through court are deeply personal. And so I think for those that have been impacted, they haven't even been notified, but there is actually no way, and I know you've got a team of cyber experts, but it seems to be there is no way to possibly externally verify exactly the scale of the breach, what was breached. You're purely relying on what you would consider now a non-trusted partner or contractor to provide you that information, and it sounds like they haven't provided anything since February.
Sorry, go on.
Yeah, McGrath-Nichol as the administrator is now managing the company, and they are so they are not VIQ, they're not the Canadian parent, and they have used their cyber and technology team, and they have access to all the systems and records, and they have investigated and verified the logs of transcription, and they've verified to us that those were the records that were impacted, and they have ensured that there's controls in place that means records are not being allocated to offshore transcriptionists.
And CyberCX will going to verify that to be in fact the case, so we're not just relying on the administrator. In relation to the actual contract with VIQ, Senator, I can assure you there will be no ongoing relationship between the entity and VIQ going forward.
Excellent. Thank you. Thank you, Chair.
Thank you, Senator Blythe. That concludes the questions we have for you this afternoon. Thank you for your time. We will now suspend until 12:45 for lunch. Excellent. We will now resume, and I call officers from the Administrative Review Tribunal. Mr Hawkins, would you like to make an opening statement?
In the interest of time, no, Chair. I'll pass. We'll go straight to questions if you like.
I appreciate that. And we'll go to Senator Cash.
Thank you very much and good afternoon. Could I just go to some figures? If you could provide how many merits reviews were finalised in the 2024-25 financial year?
Michael Hawkins, CEO and Principal Registrar of the Administrative Review Tribunal. 24-25, yep. Senator. Total finalisations, 46,471.
And could I jump forward to date, 25-26 financial year?
To the 30th of April.
Perfect.
Is 52,412.
400, that's 30th of April.
Yeah.
Thank you. In the 2025-26 portfolio budget statement under outcome, it has the performance measure of finalisation of 100% of applications for which the tribunal had been funded to finalise in the financial year. That was marked as not expected to deliver. So you were funded to complete the 59,045 applications in 2024-25. The total completions was the 46,471. What was the gap in terms of how did that occur? Because it's a rather large gap this time round.
Our target of 59,000 should have in fact been a total of 68,000 because we also have a target of 12,000 per year for our backlog funding that we have.
Sorry, take me through those figures then. So let's go back to what was you were funded to complete how many in
right. So what we call our business as usual funding is 59,045 as I recall. And then we have a target of 12,000 for our what we call the backlog funding, which is a separate NPP.
Okay. Can we take the two figures separately? Is that possible or do you need to combine them?
I believe I need to combine them.
So you've got the 59 plus the 12 is what you're saying, is it?
That's right, is our
And
target.
then so what was how many were then completed?
Well, I'm operating on 46,471.
That was the figure.
Yeah.
Okay.
Yep.
Okay. So sadly, unfortunately, we didn't obviously meet the expected outcome. Why was that?
I think, as I've said before, Senator, whilst we're funded to achieve it, we don't have the member resources to achieve
It's the member resources. Okay. In an ideal world, then, with the member resources to achieve what you're funded to actually complete, what would you be looking at?
If I were to use this year as an example.
So the 25-26, yes?
25-26 year, we are on target to finalise 60,000 matters.
And how much were you funded for?
Out of a target of 68,000.
Right.
Right?
Yep.
So we are on track to achieve 92% of our finalisations.
Okay.
And in round numbers, with only 75% of our budgeted number of members.
It's 75% of the budgeted number.
All right, so a number that I'm very proud of for our members and registrars that have obviously worked very, very hard to achieve that type of outcome.
But no, so the figure is it's the 75%
of our member resource.
Understood.
Yes.
Okay, okay. So in terms of the performance measure, proportion of applications finalised within a time standard of 75% within 12 months, it's also marked as not expected to be achieved. What proportion of applications then were finalised within the 12 months for 2024-25?
So I can explain why we haven't achieved 75% is because in this past 12 months, we have focused very, very heavily on our aged caseload. And if you indulge me a little later, I will explain to you the number of aged finalisations that we've achieved. So
when you say aged, is that those that have been in the system for a long time?
The longest.
Yeah,
so we've
not
had
aged.
Yeah, so as you know, we've had some protection matters there for 7 years and we have really focused on that 3-year plus case. Yeah.
Okay.
So as a consequence, that clearance rate
has dropped down.
Yeah.
Do you have the figure just in terms of the proportion of applications finalised within that 12-month period, 2024-25?
Which one am I looking at? I think we're looking at about, 47% achieved within 12 months.
Understood.
Yeah.
And then we've got the merits review finalised, 52,412. The expectation is 60. The funding is for the 68, but
Yes.
you've explained why. So in terms of, my question was going to be, what measures have you implemented to ensure you can complete the number of applications you have been funded to complete? But it almost answers itself.
It does.
Based on the evidence that you have given.
But some of the very positive steps we've taken, Senator, is our resourcing of registrars.
Yep.
So, for example, our registrar intake has increased from 32 now to 98. And we've been given a lot of powers in that you and the Senate have given us, or given the President rather, to authorise us to make, which has enabled a faster processing of many of the caseloads that we have.
Understood. Okay. Could I ask, in terms of, in the corporate plan 25-26, it states that the ART had approximately 83,500 applications transferred over from the AAT. When you were established, you then increased to 110,000 cases on hand. The President, in his speech of the 31st of October 2025, then said that the tribunal now had, or as of that, 120,248 cases on hand as of the 30th of September 2025. What's the figure to date?
As at 30 April, 130,983.
130,000. Did you say 980?
130,983.
Oh, 983. Okay. So, what's happening? Just more and more lodgements of claims, is there?
There is, yeah. So, take 3 years ago.
Yep.
And for many years before that, we used to average about 40,000 lodgements.
What are we talking now?
And we're now talking, projected this year, 91,000.
91,000 lodgements. So
if
take me through that. So
if I can explain it to you, Senator. So we have a demand-driven funding model agreement with finance, right? We are financed on the lodgements that we have for a defined 12-month period, which is usually the calendar year preceding the budget process, right? So in the previous 12 months, our finalisations were about 90,000 for that 12-month period. Now, within the funding model, we have a cap of 345 FTE. So the funding model determines how much funding we should have, but it also dictates what FTE we should have in our member resource. And that resource is capped based on the amount of accommodation that we actually have and can accommodate. So I'd love to have 600 members.
But you can't.
But I can't accommodate them, right?
Yes.
But we are working on different measures and different accommodation strategies to accommodate that. And you might recall the Senate was kind enough to give us decisions on the papers in our burgeoning student visa caseload. So having flexibility then for members to be able to work from home will free up accommodation space, and I hope that one day I can go to finance and say 345 cap I think we can probably increase, and that might then increase the FTE that we have. But in short, we were budgeted for effectively 60,000 finalisations.
And
we've only got 90,000. So we're always accumulating a 30,000 backlog.
It's just in terms of that, you said that there's a projected or an expected 91,000 lodgements.
This financial year, yeah.
So the one that we're in, not net, right? So where can I get you potentially on notice? I mean, you might have it now. Where are those lodgements coming from? Where have you seen the increase in the caseload? Is it the migration caseload?
Yeah, it's clearly in our migration caseload.
It is do you have any figures for us on the migration caseload?
I do. Migration alone to 30 April is 39,953.
Have you got a comparison for me?
That's an increase of 56%.
Whoa, 56%. Holy shit.
Oh, no, sorry, it's 56% of our caseload. No, sorry.
Right.
Had you excited there. 24-25,
Yep.
we had 46,653 lodgements.
Could you say that figure once more?
Okay, sorry. So 24-25
Yep.
was 46,653, representing 54% of our total
Yep.
lodgements. 30th of April,
Yep.
39,953, representing 56% of our total lodgements.
Right, and we've still got 8 weeks to go
We do.
within that. What is, do you estimate out, or there's no point in estimating out, it'll be what it is?
For that's 10 months, so 4,000, add another 8,000 to that.
You're heading towards a similar figure.
Yeah.
It's a similar figure,
Yep.
okay. So just, could we assume that you receive no new cases? How long would it take you to clear the current caseload at your current finalisation rate?
Okay, so the government talked to us about giving us an additional period of funding for our what we called our backlog members. And you might recall we were given funding for 85 FTE to clear some of our backlog. And in that first 2-year period, we averaged about 12,000 a year.
Yep.
So in this process, I said to our department and to finance, rather than measure this on FTE, let me give you a target. And that target was 38,000 finalisations, give or take a few. And what that was every matter that was over 12 months old.
Yes.
All right? And of those, we had 38,000. Now, we have assigned members to that backlog, and in this period of time, we have cleared 23,000 out of the 38,000. So, to answer your question, backlog maybe 30,000 a year if we had that additional funding.
If you had the, exactly.
And the additional 85 FTE.
Okay.
All right? So 30,000, it depends on the caseload.
And I understand that exactly.
And our priority has been the protection caseload.
Yep.
2 to 3 days each case.
Yeah.
What we're looking at in the future is our student visa caseload, which is going to be our backlog, and you look at about a day for each of those matters.
To turn around a decision. Just in terms of the caseload figures that you gave me, and in particular in that migration caseload, so we had the 54,653 and the 39,953. Do you have caseload or the visa classes breakdown for us?
Not strictly, but they are in groups. So for study visas, if you're interested.
Yeah, would you mind? Yep.
Yeah. So what would you like, the lodgements over the last 2 years or the cases on hand?
Both, if that's at all possible.
All right. So in 24-25, we had 32,202 lodgements.
Of student visas?
Just of study visas, yes.
Right, study, yep.
All right. Now, there's probably 2 or 3 different visa classes within that, but they're characterised as study visas.
Yep.
All right. To 30th of April, we've had 24,545.
24,545, yes.
Now, cases on hand.
Yep.
24-25, so I guess that's as at 30 June 2025, we had 38,060.
Yep.
And as at 30th of April, we have 52,452.
Wow, okay, 52,452. Okay.
So when I come knocking on the door again for some extended NPP funding, I hope you're going to support me.
Well, no, because you also made an interesting comment, though, and I fundamentally agree with this, that when the Parliament gave you the ability to determine certain cases on the papers, again, that made all the difference to you.
It will.
Is there anything else that you require from the Parliament to make it more efficient for you? Because I appreciate what you said in terms of the efficiencies. If people can work from home because they can't get to the office, there is no accommodation for them, that actually makes sense in this case because you're actually getting through this backlog of decisions.
So at the moment, our student decisions on the papers have not commenced. They will commence imminently because we're still waiting for the regs from Home Affairs.
Right.
I understand.
When do you expect the regs from Home Affairs?
I understand it to be imminent.
Imminent, okay. We might follow them up tomorrow for you then.
Thank you.
They might even do them today for you. You never know. Now that I know, I think Senator Dunniam's listening in.
Okay.
So there you go. Hopefully tonight you might get some regulations.
All right, that'd be nice. And if that's the case, then we'll be ready to start on the 1st.
Absolutely.
We'll be starting on the 1st of June.
Well, no, that's exactly. So your expectation is if the regulations were put in place, you're ready to go.
We're ready to the road. Yeah, we've done a lot of preparation work with the notices that have to be sent to parties.
Yes.
Case management systems. You can only imagine what we're dealing with there.
Absolutely. Yep.
She's doing a deal over there. You're doing a deal, Michaela.
Well, no, this is actually really serious because if it is regulations,
Well, I'm not joking about
what
it.
is in the body of the regulations that's taking time?
It's just the process, how we are to do it, the types of notices we're meant to give parties, what our... that's pretty much it, the process.
Yeah. Okay. So in other words, I mean, it's going to make a material difference to you to be able to do this. We would like to see you start on the 1st of June. So hopefully the Minister's office is listening in terms...
And as a precaution, Senator, we've also constituted a number of matters to members already, so about 700 to 800, because you're probably aware the decisions on the papers won't apply to those matters we've constituted.
Correct. Yeah.
But they will apply to the ones we've got in our backlog that aren't constituted. So, yeah, we can't wait to get into it.
Okay. No, thank you very much for that.
And the other bonus too, Senator, is going to be, you know, those matters, well, you're a lawyer, you're well aware, workers' compensation matters, veterans matters, that settle on the door of court, if you like.
Yes.
We're just going to have that capacity to be able to reach into the vault and take a dozen matters out for members to handle.
No, as I said, I fundamentally do believe in, for efficiency purposes, if something can be done on the papers, it should be done on the papers for so many different reasons. Can I get you, if you've got it here, if not taken on notice, can you provide a breakdown of the on-hand caseload in cases finalised in the financial year to date by jurisdiction area?
Finalisations?
Yep.
I think I can give that to you.
Thank you.
Okay, so in the general division?
Yes.
Now, what period? This is to 30th of April?
Yes, please, to date.
Okay, 2,183.
Yep.
In intelligence and security?
Yep.
Just 6.
Okay.
In migration, 18,717.
18,717, migration, yes.
In NDIS?
Yep.
6,192.
6,192.
And I'll also say with some pride to my members and registrars in that area, that's more finalisations than we've ever made. Protection, 18,259.
18,259. 259, yep.
And I want to say probably for the first time in a long time, that's a clearance ratio of 137%. We've actually cleared more than we've received.
Okay.
In social security, 4,647.
Yep.
Which is a clearance ratio of 106%.
Yep.
In taxation and business, 1,239 matters, a clearance ratio of 95%.
Yep.
And vets and workers' comp, 1,169 matters, and a clearance ratio of 91%.
Thank you very much. Does the President, again going back to the President's speech that I was previously referring to, had noted that lodgements between the 14th of October 2024 and the 30th of September 2025 had totalled 85,051, which we previously referred to, approximately double the annual figure received by the AAT. Of those, 49,334 were migration, 17,566 were protection, 7,375 were NDIS. Are those proportions holding steady, or has the composition shifted in recent months?
So protection is reasonably steady, but I've got to say that there has been a slight tapering. So last year, for the full year, 19,133. Year to date, 13,325.
Okay.
So again, just a slight tapering off there. I can only hope that it's long term, but I can explain I don't think it will be.
No.
And NDIS, 7,924 lodgements last year, 7,520 for year to date. So I'd be expecting a bit of an increase there over the year. And that is another caseload that does bother me. To quote a former Prime Minister, perhaps, I'm alert but not alarmed to the possibility of what lies ahead in NDIS.
Yeah, I can imagine, and whether or not... Yep. Whether or not... you'll need the capacity to deal with it.
And the protection caseload I'm quite nervous about too. You're probably aware that about 20% of our protection matters started out as student visas.
Yes.
And given the bulk of student visas I've got now, I do have some concerns about how many of those might become protection visas.
Claims. Is there any way of providing us figures on that, say, for the last 5 years? Because that's a very interesting statistic. How many of the protection claims commenced as, and I don't need to do it here if you don't, but commenced as that student visa?
I'll try. I'm not sure that we have the data that precise, but we can have a look.
Would you mind? It's a very interesting statistic you just raised.
Yeah.
Thank you.
Thank you, Senator Cash. Senator Roberts.
Thank you, Chair, and thank you for appearing. I may have heard on the tail end of what Senator Cash was saying, you're going through some categories, so if I do, forgive me for repeating. Which is the largest category of applications for review currently before the tribunal? I think you said student visas?
Yeah, it's in the migration caseload, Senator, and I hope you're going to be wearing a maroon tie tomorrow.
State of origin?
I'll even agree with that as a Western Australian.
So the highest caseload,
I'm
Senator,
supporting coal today.
highest caseload is migration and the student visas within that.
What would be the proportion migration and then the proportion of that that's student?
If I can say, migration is 56% of our total caseload, and
Wow.
within that, students represent 35% of our total caseload.
Thank you. How many of these applications are waiting for hearing?
Waiting for hearing, which is cases on hand. In migration, we have 77,000 cases, 77,938 on hand.
77,000?
938 on hand. We have 52,452 student visas on hand. And across the total tribunal, we have 130,983.
Wow, no wonder you're aware. What are the other major categories for review before the tribunal?
Our biggest caseloads, working, skilled and investment visas, we have 13,983 on hand. And protection, we have 37,830, which is 29% of our on-hand caseload. And NDIS, we have 7,136, which represents 5% of our caseload.
Although that's only 5%, I heard you say that you're worried about that because of the potential for growth.
Only from the sense of the media talk of what reforms are going to happen, Senator. So,
yeah.
As there's nothing legislated, I can't comment any further. Just as I said to Senator Cash, just alert but not alarmed.
Could I get on notice a review of a breakdown of all the categories and their numbers?
Of each list
yes,
that we
please.
have?
Yes,
I can do that for you.
Thank you. You've given me the total. This question could be difficult. When do you envisage this backlog will be reduced to an acceptable managed workload? And what is a managed workload, a well-managed workload?
I guess a manageable caseload is what we are funded to achieve. If it's 100% caseload that we want to achieve, we need to have 100% funding. And as I explained to Senator Cash before, an issue we have with our funding is we do actually have a cap in it, which is based on our ability to accommodate members to be able to do that work. And so at the moment, our cap is 345 FTE of members, which is equivalent to about 60,000 finalisations, but we're receiving about 90,000.
So 90,000 coming in, so you're going backwards 30,000.
Yeah.
What's the reason for that?
Because we have a cap on our ability to accommodate members at the moment. Now, as I also explained to Senator Cash, with some of the initiatives that the Senate has been able to give us, such as being able to do student visas as a decision on the paper, that will give us some flexibility as to how we accommodate our members. So we might be able to have a number of members being able to do those types of cases from home because there's no hearing involved. We have an initiative that every member in the tribunal will do 10% of their caseload as a student visa. So we're trying to make inroads in that way as well.
So when do you expect the backlog to be cleared?
Well, in present numbers, I don't. I cannot
have a reasonable expectation.
Minister, any comments to add?
Is there a question, Senator?
Yeah, the tribunal is saying that they've got a workload that is increasing, not decreasing.
Yeah, I think, and Mr Hawkins has alluded to this in the comments he made, and I think probably before you entered the room, apologies Senator Roberts, but it's a demand-driven funding model. We're currently considering applications for additional members because we do acknowledge that more members definitely are required. There's applications have been received for additional deputy president and senior member recruitment rounds, and the department can take you through the process of what goes on through those rounds. And as Mr Hawkins has alluded to, the Senate has also made some changes to the way that student visas are being considered, so they can be considered on the papers, and there's regulations that will be imminent to allow that to happen.
How many members of the tribunal?
We have 423 members we will have 423 members as of the 1st of July, representing 347.5 FTE.
So you'll be able to tell us more in supplementary estimates in November?
Certainly will.
Okay, so it's early days. Is there any way of getting a handle on the cost to the taxpayer for each review?
It's a very complex formula, Senator, because every matter is different. For example, a social security matter might take a day, a complex tax matter could take 2 weeks. So very difficult to determine a cost per decision. We could calculate it on an average basis across each decision, and I could share with you a unit cost which shows that this tribunal today is more efficient than it's ever been.
Would you do that, please?
Let me just find the appropriate note. Just bear with me, it wasn't something I was... So this is allowing for CPI adjustment and a weighted cost per unit. In 25-26 year to date, our unit cost is $2,250.88. And to give you an indication...
That's for a hearing?
Yeah, to give you an indication, in 2021 it was $3,053. In 2015-16 it was $2,769.
So it's coming down?
Yeah. And where we have to be most efficient, Senator, is, again, in that funding model, because we are receiving 91,000 applications a year, but we can't just do the 60,000 that we're funded for. At the front end, we still have to deal with the 90,000 in some way. There's case management events that take place. There's outreach with those 90,000 cases. So that's why I say it's very difficult to calculate unit costs, because unit costs might be based on a finalisation, but in fact we're touching matters, all matters that come in our front door. So of those 130,000 matters that I mentioned before, there are touch points all through that process that we can't account for until it's a finalisation. So it's a very complex calculation.
So, Minister, I won't ask the tribunal for an opinion, but I'll ask you, is there any work on alternative systems and processes? I'm not suggesting we should do that, but it sounds pretty overwhelming.
No, I think we've taken you through some of the steps that we're implementing to assist the tribunal with its work. I mean, obviously merits review is a really important part of responsible and accountable government, and applications that are made, as you know, Senator, are made when an applicant disagrees with a reviewable decision. So, for example, when the government denies someone a visa or a student visa in this example. So we're looking at all of the different ways that we can reduce the workload, but also provide the tribunal with the resources that they need to be able to make these decisions.
And you yourself, Senator, have been facilitating that through the Senate with the reforms that you've given us. For example, a decision on the papers. I mentioned before that the Parliament has given the President powers to authorise registrars to handle matters more expeditiously. So I think Senator Cash before was alluding to what more can we ask for, and perhaps there is space in the decision on the papers area for us to consider into the future. But at the moment, we're going to master the powers that we have.
Okay, so we should know more by November, supplementary estimates. Last question. Is this process of using the Administrative Review Tribunal for appeals being exploited by those wishing to stay in Australia who have no right to be here?
That's not a matter for me to answer, Senator.
Minister?
I mean, there's a range of cases and reasons why people make applications. I'm not going to I think I'll take that as a comment from you, Senator, rather than a question to me.
Thank you, Chair. Thank you.
Thank you, Senator Roberts. Senator Shoebridge.
Thanks very much, Chair. So I was thinking out of the evidence of can you, did you include your full-time equivalent membership numbers?
Yes, so I think I said we will have, as at the 1st of July, because we have a batch of members commencing on the 1st of June.
Yeah.
I think we've got 42 new members starting on the 1st of June, which is about 33 FTE. So on the 1st of July, we'll have 423 members representing 347.5 FTE.
Okay.
So to answer your next question, yes, we're shortage of about 82 FTE.
All right. And that's 82 FTE from what you were funded to meet 60,000
correct.
matters. So you're 82 short of meeting 60,000, but your actual workflow is 90,000.
As explained to Senator Cash before, we have effectively two forms of funding, what I call the business as usual funding, which is about the 59,000 finalisations, and then we have the NPP, which is the backlog funding. For the backlog funding, it's 85 FTE.
Yep.
For the BAU funding, it's 345 FTE.
BAU is
put the two together, you
usual.
get 430. Yeah.
Okay, so that, but the truth of the matter is, your business as usual is to deal with 60,000 coming through the door.
Correct.
You actually have 90,000 coming through the door.
We do.
In addition to that, you have some funding to deal with the 12,000 backlog.
The 130,000 backlog, yeah.
The 130,000, sorry, yes. The 130,000 backlog. But on these numbers, when we talk to you again in a few months' time, it'll be 150,000 backlog.
It is inevitable.
Yeah. And has the government explained to you why, even on the business as usual funding, they've still failed to give you the 82 additional full-time equivalent staff members?
Our funding has a cap that's based on our capacity to accommodate members. And I think it's probably for the department to comment. I understand that the government isn't enthusiastic about us taking more office space, and I can understand that, because should our lodgements drop at any moment in time, you wouldn't want a surplus of office space. So at the moment...
Doesn't seem in immediate danger.
But as I said, with these efficiencies that the Senate's been giving us with our powers with registrars, I'm hopeful that we will find efficiencies in how we do the business.
So in other words, even though you're meant to have 400 and how many? What should be your full load?
430 FTE.
430.
Yeah.
You currently have
347.5.
347.5. And one of the reasons is if you got them, you wouldn't have anywhere to put them.
At the moment, that's right.
And that's because the department is not providing you with the hearing space necessary to accommodate.
We don't have the office space to accommodate the members. Yeah.
Ms Jones.
Senator, it's not for the department to provide the tribunal with hearing space. The tribunal needs to manage its accommodation footprint within its resourcing.
Get very thin members. get very thin members, only allow people of a certain weight to find their way onto the list? How is this
like
going to
every
happen?
Commonwealth department and agency, we all have to manage our accommodation consistent with our resourcing. I think it is really worth noting that we're waiting for the regulations to pass to enable the decisions on the papers, and it won't be the whole solution, but I think we're hopeful, and I want to acknowledge, I think it was very much the President and the Registrar who put forward the initial thinking around doing decisions on the paper. So we hope that will have a significant improvement, and of course we are engaging in a number of new recruitment processes to continue to seek to supplement numbers at the Deputy President, at the Senior Member and at the General Member level, and that's on top of the significant number of new members that have been appointed over the last 12 months.
Well, you see, we've got the troika here, don't we? We've got the ART saying that they don't have the numbers because the government's not appointing them. We have a suggestion that the government's not appointing them because there's nowhere for them to go. And then we have the final point that if that's the case, what's the minister doing to fix an impasse? Because I can't tell from the exchange we've had from the Principal Registrar and the Secretary where the truth, I'm not suggesting anyone's misleading, but where the responsibility lies for solving this problem.
Senator, if I could venture a view in terms of context. So we discussed a funding model 3 years ago at the time of the reform of the tribunal. At that point in time, the tribunal had a history of 40,000 lodgements a year. We set a target of 345 FTE based on a reasonable expectation of the office space that we had and would have at some point in time. We did not anticipate reaching that target, if you like, that cap at the time we were negotiating that model.
So at the time you negotiated for your current office space, you were looking at a maximum of 345 tribunal members.
Based on a history of only 40,000 lodgements a year.
Well, you now have at least a funded, if not a reality, funded envelope for 430. I'm not an expert in how to run a tribunal, but my guess is they need hearing rooms, they need some office space, they need somewhere to be a tribunal physically. Secretary, is the answer just back to the ART, well, just do more with less, somehow fit more hearing rooms in the same space? Is what I don't quite understand your evidence that the ART just needs to somehow find the capacity in their existing footprint. What are you suggesting they do?
Senator, I know as a general rule the expectation is that all departments and agencies work within their budget and determine their accommodation, which is what I have to do with our department and what all entities have to do. And I think there are always options about how you can have more efficient approaches in the use of your accommodation, and I know Mr Hawkins is always thinking through those things, and as he gave testimony a little bit earlier on, he's very hopeful about the impact of being able to transition to doing decisions on the papers, that people will be able to avail themselves of flexible work options and to be able to work in that way, which happens right across both the public sector and the private sector.
We're looking for efficiencies in everything we do, Senator. So, for example, even our hearing modality. So moving from in-person hearing, where it's appropriate, to video hearing. Moving from a hearing room where members may have done a hearing into their offices where they can do a hearing room, where they can do a video hearing on Teams. So with the hearings on the papers, and we can have members then working from home, we are striving for every efficiency we can find.
Just to close the loop, the registrar indicates that one of the reasons why the additional 82 which the ART has been funded for, full-time equivalent members, haven't been recruited is because they don't have somewhere to put them.
No, that's not what I'm saying.
sure
That's not what I'm saying,
What was
Senator,
it?
because we have the space up to 430. So I'm not saying we need more office space at the
Well,
moment.
then why hasn't the 82 additional space been recruited?
So we have appointed new members, and
We
we are
heard.
currently, I'm sorry, you may have missed this before you were
No, I
out of
heard
the
it.
room. We are currently considering applications received for additional Deputy President senior member recruitment round. So we understand that the ART has indicated there's an FTE gap. The government recognises that it's not a set and forget. We're still working on appointing those new members, and we'll work constructively with the ART going forward.
All right. Well, I did hear the evidence earlier about the recruitment round that's happening and the expectation.
Apologies, Senator, sorry.
And I didn't necessarily need it repeated, but perhaps you could just answer on notice what your expectation is, given that recruitment for the full-time equivalent will be by 1 July.
I can take it on notice.
Yeah. And if you have the answer now, tell me what you expect the full-time equivalent membership to be on 1 July from the government's perspective.
1 July when?
1 July 2026.
26. I can tell you that our members will be 423 with an FTE of 347.5.
347. Okay, so it's still like 85 short.
Correct.
Yep. Could I ask just a series of questions for perhaps some data on notice, but maybe
sure.
If you have the answers now. Do you have the year-to-date travel budget for the President, yourself, the Deputy Presidents and the SES staff?
No, I don't.
Can you break it down,
Sure.
if possible, by the different office holders?
Sure.
And if once you get into SES, maybe you just do it by bands?
Yep.
And can you do that for this financial year and last financial year? What's the status of the case management system? Are there any concerns with the case management system?
No. We've come through a recent gateway review and a short-form gateway review, and they would appear to have confidence that we are on track.
Or on track meaning?
On track to deliver.
By?
30th of June 2027.
All right. And what was the original price contract for that?
29.4 million.
And what is it now?
6 million.
What is it now?
Oh, the budget hasn't changed. It's still 29.6 million.
And it's on budget, you say, to be delivered by the 30th of June 2027. Is that your evidence?
Senator, Jamie Crew, Chief Operating Officer. The case management system is on target to meet its budgeted amount of 29.6 million on 30 June 2027. The system won't be entirely completed, but there will be a majority of caseloads outside of the migration and protection caseloads that will be commenced on that system by that point in time.
All right. Does that mean to actually deliver the whole of the thing is going to cost more than the 29 million?
Case management systems are never finished being built, Senator. So
yeah, but one of the things I would have thought is you manage all your cases. So
certainly, we've got a system that's still running with with a case management system for the migration and protection caseload. The system that we're building for $29.6 million will have the capacity to take on extra caseloads later at the point in time where it's appropriate to do so.
So currently, perhaps you can provide on notice what the original scope of the contract was and whether it was intended to cover all the caseloads or exclude migration matters. And perhaps if you could provide on notice if the scope has changed and narrowed, why it's narrowed, and what you would estimate the cost to be to meet the original scope of the contract.
Thanks, Senator. We'll take that on notice.
How many complaints have been lodged against the, if any, against the President by members? Do we know?
There has been one complaint.
One. And is there a difference between formal complaints and other grievances? Is there a...
I'm only aware of one formal complaint.
Okay, and what's the status of that complaint?
That was investigated by an independent former judge, and it was not substantiated. In fact, it resulted in an apology from the complainant to the President.
All right. If you can provide any more details on notice, including the status of the current member?
Status of the current member?
Of that member who made the complaint, are they still a member?
They are still a member.
there have been reports that I have heard that there's been an internal prioritisation to address clearing student visa matters, and that has seen a deprioritisation or changing in resource in Department of Protection visas. Is there any truth to a reprioritisation happening to deal with student visa matters?
I don't think that's the case, Senator. What we have implemented is training for all members in the student visa caseload, which has happened. I have been impressed by the enthusiasm with which that was embraced by all members. They did some training, online training, and then each of them undertook, I think it was about 4 cases each, in the form of a hearing to prepare every member for being able to do student visas on the papers. Well, now, I think I said to the Senator before, yes, there is a plan that all members will do 10% of their case days in the student visa caseload, which means they'll do 20 cases. A full-time member will do 20 cases.
Right. Perhaps do you have the data which would allow you to show the membership, the equivalent, full-time equivalent membership time allocated to each of the different flows of work?
Could I take that on notice?
Yeah, and if you could...
It's quite complex, yeah.
Yeah, that could look at the last financial year and what is to this financial year so we can get a sense of what's happening. My last questions are about...
Can I also add, though, Senator, which was part of my answer to Senator Cash before, is that the Tribunal has finalised 92% of its targeted finalisations on 75% of the members. So the members have performed extraordinarily, as have the registrars. We are confident that there will be no diminution in the number of finalisations by members, even if they're doing 10% of their cases in student.
All right. Well, I mean, let's see how much you can squeeze the lemon until the pips squeak. But perhaps to that effect.
But I don't think it is squeezing the lemon, Senator. I think it's just the performance of members.
There was a member pulse survey conducted in 2025.
Correct.
Can you table the results from that survey with the committee, please?
I can table the outcome, yeah, sure.
Yeah. What were the key findings of that? Were there concerns, for example, about the amount, about registry support or some of those fundamentals?
Off the top of my head, 52% of members responded to it. There was some concerns about proofreading. There was concerns about the size of the member support pods that we had, and we've committed to reducing the size of those pods. We've committed to providing more proofreading services. But by and large, I think the takeaway for us was that the objective of the member support model, which is consistency, equity and financial sustainability, is understood and supported by members.
Well, if you could provide the survey,
sure.
Obviously the survey results and whatever report was generated as a result of those reports, we maybe can have a look at that ourselves. All right, thanks, Registrar.
Thank you, Senator Shoebridge. Senator Cash.
Just some very brief questions, and I will put the rest on notice. Just in terms of the 2026-27 federal budget, did you get any further funding?
We did.
And how much was that?
68 million. 68 million.
68 million, thank you. Additional staff, I think you've already taken us through that.
Yep. I think the ASL is about the same.
It's about the same.
1230 down to 1227 perhaps.
And how many applications have you been funded to complete in 26-27?
Our target is 72,000, which is again out of the funding model and also the backlog.
Yeah. Yeah, okay, that's interesting. Okay. 2 other quick figures if you've got them. Is it correct that half the protection refugee reviews finalised between the 1st of October 2025 and the 31st of March 2026 took 3 years and 1 month from lodgement, and 95% took 5 years and 4 months?
Yeah, I did see a number similar to that this morning. I think that's correct, yeah. Again, we've been focusing on those aged cases, so...
Yep, no, I don't know. I was just, I think it's difficult to believe that cases can take that long.
Yeah.
Yes, when you sort of see the figures. I did have a question, but I think we've answered it, that the on-papers process for temporary visa appeals commenced on the 18th of May. It hasn't yet commenced because you haven't got the regs.
Haven't got the regs, correct.
Yep, okay.
Yep.
Thank you, Chair. I can put the rest on notice. Thank you, sir.
Thanks, Senator.
Excellent. It means you are now released and you go with our thanks.
Thank you very much.
We'll take a very short 1 minute suspension while we welcome our next witnesses. We will now resume with the Office of the Commonwealth Ombudsman. Mr Anderson, would you like to make an opening statement?
Ian Anderson, Commonwealth Ombudsman. I'm happy to go straight to questions, Senator.
Excellent. Music to my ears. Senator Shoebridge.
Thanks, Chair, and thanks, Mr Anderson, for your attendance. Has there been any change in how the Ombudsman investigates complaints and which ones are considered? Any change in the triaging, or if there is a threshold required before individual complaints are considered?
Senator, we've made a number of different changes to our processes. So we're conscious of the fact that we have a backlog of complaints. We're trying to improve our performance with complaints to increase our timeliness. So we've made changes which go to building the capability of staff, so training and induction and recruitment and things like that. We've introduced some quite specific new guidance for staff as well about how to make certain decisions about whether to investigate, whether to not investigate matters, things like that, because under the legislation we have a great deal of discretion in terms of whether we investigate, how we investigate, things like that.
A constituent advised my office that when the Ombudsman contacted them and explained they weren't undertaking an investigation of their complaint, the advice they were given was the Ombudsman is no longer investigating individual or one-off complaints against an agency, and that they will only progress complaints where multiple complaints exist against the same department or agency. Now, is that an accurate description?
If they were told that, Senator, that's not an accurate reflection of our stance. We have been advising complainants that for certain categories of complaints, we're unlikely to investigate individual matters. So, for example, we know that Services Australia has a very, very large backlog of matters in the Authorised Review Officer or ARO process. I think it's 75,000 matters in that process. People will come to us and complain about delay. Now, we could seek to intervene and see if we can get them raised up in the queue within that 75,000 backlog. What we've instead been trying to do is engage with Services Australia at a systemic level to say, what are you doing about this backlog? It doesn't necessarily seem fair to say someone should be able to jump up or within that 75,000 backlog. Similarly, Department of Veterans Affairs, we get a lot of complaints about delay there, and we have been advising some complainants that we're less likely to look at individual complaints if it's simply about delay in Department of Veterans Affairs assessing their applications for various benefits, because that's a known issue, and we're again engaging with Department of Veterans Affairs at a systemic level about their delays.
Well, on one level you can understand that decision making, but on another level it means that the worst performing departments with substantial backlogs get a little get out of jail free card in that they don't have individual ombudsman complaints to address. it's kind of, it's rewarding the poor performance of those agencies, isn't it?
Senator, I don't think that either Services or Australia or Department of Veterans Affairs would say that they're getting out of jail free. They're getting a lot of attention from us about delays in some of their processes.
And then, so apart from Veteran Affairs and Services Australia, are there any other agencies where you've taken the approach that individual complaints of a particular nature won't be progressed?
And just to be clear, Senator, it's individual complaints if the complaint is simply about delay with the ARO process or with the application to Department of Veterans Affairs. I believe they're the only agencies where we've taken that approach. We will still look at particular matters though, even if it's about delay, and if it's someone who has a particular vulnerability, for example, we might be able to see if we can get them something different in that treatment.
And that you can assure me, and through me, the community, that threshold or anything similar to that threshold is not being applied outside of those two streams of work.
Yes, Senator, that's certainly my understanding. I'm not doubting that your constituent was told that, and so that makes me think I need to go back to my staff and just reinforce that it's not a blanket position, that we won't investigate individual complaints.
I have another constituent who obtained FOI documents in relation to their complaint, and those documents show that there was 15 months where the matter sat in the Ombudsman's office and there's no evidence of any written update, no evidence of any outcome, notification of any kind, just sitting there for 15 months. Now, I don't have permission to show you those documents at this stage, but could that be explicable as you understand the normal workings of the office might operate?
Senator, we've got about 574 complaints currently that are over 12 months old. So we do have a challenge with getting to all complaints within the time limits that we've set. We aim to resolve 99% of our complaints within 12 months, and clearly we're not making that, given that we've got 500.
But this isn't just not resolved. This is not moved, not touched,
Yes,
maybe it was dusted. That's what this one is.
I understand that, Senator, and we're trying to make sure that we do in fact touch matters much more frequently than that, and we certainly communicate with complainants. But I accept that in the case that you're referring to, that doesn't seem to have happened. So I'm aware, Senator, that we're not meeting some of our targets in terms of performance and timeliness, and I'm doing everything I can to actually address that. I could talk more about other things that we're doing to address that challenge as well.
What you say there's 574 complaints that are more than 12 months old. What's the oldest?
I'd have to take that on notice, Senator.
What's the average?
I'd have to take the average on notice.
Or the median?
Well, I'd have to take that on notice. I mean, Senator, we've got 7,441 complaints open at the moment, of which 574 are over 12 months old. So I can't give you the mean or the average at the moment. We are still dealing with most matters within 12 months, but unfortunately there are some matters that we're not dealing with under 12 months.
All right. Well, perhaps you could give some of that data on notice, including if you break down your caseload, maybe it's by agency, maybe it's by complaint matter. I don't know how your database works, but if you could give some understanding of where the delays are, and if you could provide some sort of granular detail about those that are more than 12 months old, such as the oldest cadre of those complaints, etc.
We'll certainly see what we can...
You know better than me how to make that data visible.
Yes, Senator, we'll see what we can do.
Yep. There is, my understanding, there's an open complaint relating to American Express and the OAIC with the Ombudsman. Is that true?
Senator, you've already yourself indicated that there are some challenges with talking about individual complaints, and we are required to investigate in private. So I'm conscious of that legislative prohibition on sharing certain information about individual complaints. But yes, we do have an open complaint of that nature.
Does that involve reviewing answers that were provided on notice to Parliament, that investigation? Is that any part of that investigation?
I think, Senator, the main part of that investigation is about we've been seeking information and further information from the Office of the Australian Information Commissioner. I'm not sure if we've actually received the information that we're seeking from them. So that's what I understand is the focus of that information.
Is any of that in relation to an answer given by the Attorney-Generals in response, I think, to Senate Question on Notice 531?
I don't know, Senator.
Can you take that on notice?
I'll take that on notice, Senator.
Yeah.
I mean, it's not usual that we'd be investigating matters in parliamentary proceedings, obviously.
Unless they were providing material information in relation to an existing complaint or something.
Look, if there was relevant information that was provided, but the focus of that investigation, as I understand it, Senator, is on the Australian Information Commissioner.
Well, my understanding is that matter has now been live for some 4 years.
I think that's right, Senator. Live with the Office of the Australian Information
Yes, not with
Commissioner.
you.
Yes, that's right.
That's true. Can you shed any light on what your expectation is for a timely conclusion of that matter?
We have, I think, recently received some correspondence through the complainant that they'd received from the Office of the Australian Information Commissioner, where the Australian Information Commissioner talked about a systemic investigation that they're doing and that they believe that that's coming to a head. So I believe that the Office of the Australian Information Commissioner has said that their processes are well advanced.
All right. We had evidence yesterday from the department that the relevant UN oversight body had made a statement to the effect that Australia was compliant with its OPCAT obligations. Had you seen such a statement?
I think I'll broadly say I'm aware that such a statement had been made, Senator.
Is Australia compliant with its OPCAT obligations?
As I think you pointed out yesterday, Senator, I'm part of the Australian National Preventive Mechanism. We issued a statement when the UN Subcommittee for the Prevention of Torture recognised Australia as being compliant, and we said it's important not to lose sight of the fact that Australia, in our view, is not fully compliant. While a number of bodies have been nominated to be national preventive mechanisms, they're not necessarily appropriately resourced. In some cases, they don't have appropriate powers. And of course, the three most populous jurisdictions in Australia have not nominated NPMs.
Yeah, and indeed, I think your office gets a fairly nominal sum of money to undertake that role as the national NPM. It's about $300,000 a year or something. How much do you get for that?
Senator, we're both the Commonwealth NPM, so we oversight places where people are deprived of their liberty by the Commonwealth, and then we're also the coordinator of the national NPM. Collectively, for those two roles, we have funding for 3.8 FTE plus some small travel money.
All right. And is that sufficient?
I have 9 staff, Senator, doing that work. And this goes back to the complaint performance that when we're not resourced or not fully resourced for our functions, I have to take those resources from other places.
So the Commonwealth funds you for 3.8 staff to do those joint roles for the NPN.
That's correct.
But you're actually required to put 9 staff.
I believe that that's what's required to do that work.
Secretary, can you explain the discrepancy between the funding and the reality?
Senator, obviously we work closely with the Ombudsman's office. We've allocated the available funding to them to support them in this activity, and we'll continue to engage with them.
When you say available funding, do you mean the funding that the government has given you through the budget? Is there a line item that you've been given for that in the budget?
Senator, I don't have the team with me that could assist me with the specifics of that. I'll have to take it on notice.
Minister, can you explain why there's such a discrepancy between the actual staffing that's required to do the work the government's given the Ombudsman and the resourcing the government has provided? Why there's such a big shortfall?
I also don't have any information about that in front of me, Senator Shoebridge. I wouldn't want to give you the wrong information, but I think it's entirely appropriate that we take that on notice for you. The Ombudsman's an independent agency and they manage their workload appropriately, but we'll get you some more information about that funding.
When you say independent, Minister, I'd urge you to read the report delivered by the Centre for Public Integrity today, which pointed out that if an agency doesn't have independent funding and adequate funding to do its work, it can't really have functional independence. Are you aware of that report that the CPI delivered today?
I've been preparing for Senate estimates today. I haven't been reading other people's reports.
Yes, well, I would urge you to give a copy of that to the Attorney General, and it might assist in providing the funding needed for independent oversight bodies. Thank you, Chair.
We can finish up now. Excellent. That concludes the questions that we have for you this afternoon. Thank you very much for your time. We'll take a short 1-minute suspension while we welcome our next witnesses. Thank you. We will now resume with the Office of the Commonwealth Director of Public Prosecutions. Ms Sharp, would you like to make an opening statement?
Thank you, Chair. I would like to make an opening statement. Good afternoon, everyone. I'm pleased to appear before the committee today, and I thank all the members of the committee for your interest and ongoing engagement with the work of my office. Thank you also for the opportunity to make an opening statement. Joining me today are Mr Mark de Crespigny, the Commonwealth Solicitor for Public Prosecutions, and Mr Warren Day, my Executive Officer and Chief Operating Officer. I would like to take this opportunity to note that this will be Mr de Crespigny's last appearance for the office, because next month he will retire after 37 years of service with the CDPP.
That's impressive.
We're all grateful for his service. Following a recent competitive recruitment process, I determined to appoint Mr Day as the next Commonwealth Solicitor for Public Prosecutions. Mr Day brings extensive experience in executive leadership, litigation and government administration, having been the CEO of ASIC. Turning now briefly to matters that are significant to the committee, funding and finances. In addition to the Office's ongoing annual budget of $102.4 million, the 2026-27 federal budget included $59.8 million funding over 4 years, more than half our annual budget. I would like to thank the Government, the Attorney General, the Department and our partner agencies for their support. This continued funding is an acknowledgement of the CDPP's work as the peak agency in the Commonwealth criminal justice system. It supports our work in relation to several key areas, including prosecutions arising out of the Fraud Fusion Task Force, which focuses on fraud against the Commonwealth in a range of areas, illegal foreign fishing and terrorist offences, to name a few. We are currently prosecuting a number of matters that are of significant public interest. Recognising that a key aspect of our criminal justice system is the principle of open justice, the CDPP maintains web pages about specific cases that are of public interest. Those pages are kept up to date and they contain information about any court hearings and information about the date the matter is next in court. We are conscious that prosecutions are rightly the subject of public discussion. That said, public discussion of ongoing proceedings must be approached carefully. We know that the committee appreciates that the answers we can give in relation to matters currently before the court require prudence. The CDPP's work continues to be multifaceted and complex, and I do want to acknowledge the work that all the staff of the CDPP do to support the criminal prosecution work of the Commonwealth. In doing that work, the standard we hold ourselves to as a prosecuting agency and as public servants is one in which the Australian public can have confidence. I thank the committee for allowing me to make this opening statement, and we look forward to assisting the committee with its questions.
Thank you, Ms Sharp. Appreciate that opening statement. We'll proceed to questions. Senator Cash.
Thank you very much, Chair, and thank you for the opening statement. Who within the CDPP has the authority to offer immunity from prosecution to a witness in a Commonwealth criminal matter?
Thank you, Senator, for that question. That's a power that's contained in the Director of Public Prosecutions Act in Section 9, and it's a power that I, as Director, can exercise, and only I.
Only I. Is it delegable?
No.
No, so that is you personally exercising that power. Thank you very much. Is there a formal written policy or internal guideline that governs when and how immunity from prosecution can be offered to a witness?
Yes, Senator. So all of the decisions that my office makes in relation to which prosecutions proceed are made in accordance with a document called the Prosecution Policy of the Commonwealth. That's a publicly available document.
I was going to ask
it's been presented to Parliament.
Yes.
And it contains paragraphs that outline the considerations to be taken into account when an immunity is granted.
Thank you very much. Does the CDPP's general immunity framework, as set out in the prosecution policy, apply equally to immunity offers made in the context of Division 268 war crimes prosecutions, or is there a separate or modified framework that applies?
No, it's the same framework that applies, Senator.
Regardless of?
Regardless of.
The prosecution and the section under which you're being prosecuted?
Senator, the factors that are outlined in that prosecution policy are generic factors that relate to the considerations to be made in relation to any case in which that's a question.
Thank you very much. When considering whether to offer immunity to a witness who has admitted personal involvement in the very conduct being prosecuted, what criteria must be satisfied before that offer can be made?
Well, those are the matters that I set out, Senator, in the prosecution policy. I could read those for
you. Would you mind? If you've got that, I would appreciate it. Thank you.
There are a number. In section, it's paragraph 6 of the prosecution policy. This is a document that can be tabled. As I said, it's publicly available. It runs to sort of a couple of pages.
Oh, that's fine. Perhaps, okay, I will...
Preferably, yeah.
Preferably, that way we can keep moving through. That's fine. But when considering whether to offer the immunity, as you're saying, it is actually contained within that document, which I now have in front of me from people listening in. So thank you very much for that. Just in terms of the evidence on the immunity and yourself being the person who exercises that, is there any legislation upcoming which is going to change that?
That would be a matter for the department.
Ms Jones, is there any legislation
about that particular immunity aspect?
That is upcoming. Is there an omnibus bill in which there will be a delegation to the new deputy?
I'm not aware of any.
Not aware of that. That's fine. I just wanted to check. Thank you very much. Is there a requirement that the CDPP assess the relative culpability of the persons being offered immunity against the person being prosecuted before immunity can be granted?
Senator, that's one of the factors that's outlined in the prosecution policy.
Thank you very much. How do you then document that assessment?
In terms of the internal process?
Correct, yes.
We have a case management system that records, like any litigation firm who's running in litigation files. We have a case management system.
Similar to, so it's obviously you who's, are you looking at these factors, or do you have someone look at those factors for you and provide you with advice?
Well, both, but ultimately the decision is mine and I consider the factors.
Right. So in terms of the documentation, as you said, like any large firm or any firm, you've got a case management system, and that is the inputted into that the considerations that you've taken into account.
Yes.
Okay. Can immunity be offered before a brief of evidence has been fully assembled, or must the evidentiary case against the primary defendant reach a certain threshold first?
Senator, an immunity can be granted when the factors in the prosecution policy are met. So that might be at a particular stage in an investigation, or it might be at an early stage, it might be at a later stage. It just depends whether the factors relevant for the exercise of the power have been met.
At a given point in time?
At the point in time when the decision is made, if those factors are met, then an immunity can be given.
So the evidentiary case against the primary defendant does not have to have met a certain threshold. It's actually in relation to those you're offering the immunity to.
Well, it's difficult to answer that question in the abstract, Senator, and all I would say is that in order to assess the factors that are set out in the prosecution policy, there's a level of information that's required, and so I can't make a decision assessing those factors unless I have sufficient evidence. Now, it might be that evidence, that an investigation continues past that point in time.
Yes.
It might be that decision is made at the end of an investigation. But every case will be different, and it's a matter of the decision maker, in this case me, being satisfied that the factors relevant to the exercise of that power have been met.
Understood. What conditions, if any, are routinely attached to an immunity offer? For example, requirements to provide full disclosure, to not commit further offences, to submit to pre-trial interviews. Do you attach conditions, or can you?
I hesitate, Senator, because I'm just trying to think of the context of some of them. There are some that might come with the on the basis that a person will give evidence, yes.
And can I ask, where's that set out in? Is it set out in the prosecution policy? Is it set out in the law?
That's set out in the document
that we've been talking about, that we've all got in front of us? Or?
Yes.
Yep. So if I say, what conditions, if any, are routinely attached to an immunity, for example, that is actually set out, I can go and read them.
Well, yes, Senator. I think routinely is a difficult word in this context because every case is different.
Sorry, and that's my mistake then. Could be set out.
Could be set
out. Not routinely,
yes.
but could be set out as per.
Yes.
Yes. Does the person granted the immunity have to sign a document? Well, accepting the conditions potentially that may be put on any grant.
Not always, no.
So there's no. They could, but they don't have. Sorry, no.
There's no legislative requirement.
There's no legislative
for the individual
requirement to sign.
Understood.
Thank you.
The undertaking.
If a witness who has been granted immunity subsequently provides false or misleading evidence, what mechanisms exist to revoke or limit the immunity?
Senator, could you just excuse me for one moment? That is normally a condition of the immunity, that the evidence is true and correct.
No, I understood. No, I understand that. But if they were to subsequently be found, so I completely understand that that is obviously a condition of the immunity, but if you subsequently found that a person did provide false or misleading evidence, what does the law then say?
In relation to which particular?
That they have now breached their immunity agreement, basically.
Well, they would be charged. If they gave false and misleading evidence, they could be charged.
They could be charged themselves.
Evidence. Yes.
Okay. So the immunity deal's basically off.
Well, the immunity relates to the offending for which it was given,
yes,
not relation to subsequent offending, for example, giving false or misleading evidence.
Understood. If the granting of immunity to a witness in a war crimes matter, is the granting of immunity to a war crimes matter, to a witness in a war crimes matter, recorded in any central register?
Senator, it's recorded in our case management system, but in our annual report, we do report annually on the number of immunities granted, and that's reported in our...
With a name as...
No, Senator.
No, so it's just a number. Understood. Is that register or report subject to parliamentary oversight or audit, or is it literally just a report from the CDPP as to the number of persons in a given period of time granted immunity?
We include that number in the annual report
Yes.
as a matter of public oversight. I'm not aware of any formal external audit process in relation to that, but I'll be corrected.
Is it merely a number, or is there also an explanation?
Senator, I can...
I mean, I could probably pull your annual report, obviously.
Yeah, I've got a copy of it here.
Oh,
and,
you're a star.
If you just excuse me one moment, I'll get to that page. So in our most recent annual report, of course, we're preparing the report for the financial year that's just concluded. It's only 4 short paragraphs. If that's appropriate, I can read
That would be
those.
wonderful, thank you.
Indemnities. The DPP Act empowers the Director to give an undertaking to a potential witness in certain circumstances. Section 9, subsection 6 authorises the Director to undertake to a potential witness in Commonwealth proceedings that any evidence the person may give or anything derived from that evidence will not be used in evidence against the person other than in proceedings for perjury, which is...
Understood, yes.
Returning to the report. Section 9, subsection 6, capital B, empowers the Director to undertake to a person that any evidence he or she may give in proceedings under state or territory law will not be used in evidence against them in a Commonwealth matter.
Yes.
The DPP Act also empowers the Director to indemnify persons from prosecutions, which is the power, Senator, you've been asking about. Section 9, subsection 6, capital D, empowers the Director to undertake to a person that he or she will not be prosecuted under Commonwealth law in respect of a specified offence. This kind of undertaking is referred to as an indemnity. During the reporting period, that is the reporting period for this annual report 24-25 financial year, the Director provided 13 undertakings under Section 9, subsection 6 and 2 undertakings under Section 9, subsection 6, capital D.
Can I ask what the difference in the sections is?
Yes, so 9.6D is the indemnity provision that we've been speaking about, and 9.6 was the first one I outlined, which is an undertaking to a potential witness that answers they might give in a proceeding will not be used against them in a Commonwealth matter.
Understood.
Senator Cash, can I use this opportunity to share the call and then come back to you?
Absolutely, thank you.
Thank you very much. Senator Shoebridge.
Well, thanks, Chair. I only have a small corpus of questions, so thanks all for your attendance.
Thank you.
Are you in a position to advise the committee about the travel expenditures for the senior leadership team?
I'd have to take that on notice, Senator, over a particular period of time in relation to
this financial year and the previous financial year?
Yes, we can provide that.
Can you do
senior executive, do you mean all SES or which particular?
Well, I mean yourself, Director, to the extent that the Commonwealth Solicitor and the Executive Officer travel. Do you now have an Associate Director as well?
Not yet. The recruitment process for that is ongoing.
All right, and we'll come to that in a bit. But, I mean, this is my assumption of the leadership team. Is there then another layer of the leadership team?
Well, we have a number of Band 2s, SES Band 2s, and then a number of SES Band 1s. I just was curious as to which information...
Well, then why don't we go down to the SES Band 2s?
Yes.
And that would satisfy me for this financial year and last financial year.
Yes, Senator.
Have any trips coincided with personal events? Was this part of the travel?
I'd have to take that on notice, Senator. I don't believe so, but...
All right. But you'll take that on notice, and that's for that same corpus of...
Yes, Senator.
And if so, what trips coincided with personal events and what was the explanation and what was the funding? You can take that on notice?
Yes.
Yep. What was the rationale for the appointment of an Associate Director, and what's the role of the Associate Director?
Perhaps if I can speak to that, but I would then maybe see if Ms Chidgey from the Department or the Secretary wanted to add anything further. The role of the Associate Director is the same as my role. The Associate Director under the DPP Act has all the powers of the Director, save for the power of delegation. And I approached the department asking them to consider to fill the role simply because of the increasing nature of the workload of my office and to provide an alternative person when I'm on leave who has similar and same skills that I do and background.
So if they hold...
I don't know, sorry, if the department wanted to add anything extra to that.
No, I think that covers it, and just add in relation to earlier questioning that it would mean that the Associate Director could exercise the immunity power, and would just note I've been advised that an omnibus bill we have before Parliament as well on that matter would also enable the attorney to authorise someone else where there was a conflict of interest, but the associate director position is there to enable someone to step in and perform the duties of the director if required.
And which section of the Act authorises an associate director?
Of the bill? Do you mean?
No, I assume there's a current statutory provision.
Yes, there is, Senator.
You're not recruiting in the hope of law reform.
Miss Chidgey should be able to find it pretty quickly.
And so if they have all of the functions and duties of the director, save for delegation, how is it going to work in terms of the management structure and their responsibilities?
Thank you, Senator. So just to clarify, Section 18, capital A of the Act provides for an associate director. Senator, as you'll appreciate, we have about 2,500, we received about 2,500 cases last year. We have a series of systems in place that manage who makes what particular decision on those cases, depending on a range of factors. A large number of them currently come to me for decision, and so those decisions will come to myself and inner chambers, so myself and the associate director, and as between us we'll decide who makes a decision on what particular case. It will mean that if there is a conflict, as Ms Chidgey identified, there's another person who can make the decision. It will also mean that one of us might be involved in making a decisions in a long-running matter that might have multiple accused in it, and so obviously the same person would make decisions in relation to the same case.
All right. So how do you ensure that you don't potentially have two directors with co-equal powers making contrary decisions on a matter?
A decision required to be made on a particular matter comes up through our case management system and is identified as a decision for me to make. I get a list of decisions to make, and then it will either be I or an associate director making the decision. There are discretionary decisions that prosecutors make, as you'd well be aware. And if I understand, Senator, your question correctly, it's in that space where reasonable minds might differ about a particular decision that you might see some conflict between the two. I'm confident that I would be able to work with the Associate Director if there was a case that either of us felt we wanted to speak to the other one about to get a sense check on what the other one would do. We can consult, but it'll be one person's decision in relation to a particular case.
And Senator, I can just add under Section 18B, subsection 1, the powers of the Associate Director and their functions are subject to any directions given by the Director.
Yeah, so I mean, I understand that. You could give a direction, but if the Associate Director has power to make a decision, well then it's effectively the same authority as you have, unless an earlier direction had been given.
Yes, Senator.
You're not suggesting, are you, Ms Chidgey, that direction power enables the Director to overturn or reverse a decision made by an Associate Director, are you?
I have to take that on notice, but their decision-making is subject to the Director's direction.
Well, I mean, is this clear to you, Director?
Yes, Senator. I'm not concerned.
Do you believe that you'd have the power to, if you didn't like the decision of an Associate Director, issue a direction to reverse that?
Well, I have the power under Section 18B, subsection 1, to issue a direction to the Associate Director in terms of a decision that's made. If I disagreed with it, I'd have to take on notice the legal avenues for making a different decision.
Well, that's right. They would have exercised your power.
Of the 2,500 cases currently, I don't personally exercise my power in the vast majority of those cases. That power is delegated down, and it's delegated down with a range of protections and guidance for the people exercising that delegated power. And those guidelines and guidance would be available to the Associate Director. And so I have every confidence that the decisions that would be made by an Associate Director, if there was any concern, that person would speak to me and we would be able to discuss them.
And can you provide on notice what the actual organisation structure will look like with the Executive Director in it, including the lines of responsibility and reporting?
Yes, Senator.
Was there a pay rise to the Director's position authorised in the last 18 months?
there was a REM tribunal change. I'm not sure of the exact dates, Senator. I'm sorry, I'd have to take that on.
What did it produce, Mr. Day?
You might be able to assist, for the sake of Hansard, Warren Day, Executive Officer at the CDPP. There was a review by the Remuneration Tribunal, I think within the first 12 months of Director Sharp's appointment, which increased the remuneration. My understanding from a discussion with the department, Ms. Chidgey might be able to confirm, that the Associate Director's remuneration has been the subject of review as well and has also been made public.
Can you inform the committee what the increase was, what it went from to?
I don't have the exact numbers in front of me. My understanding is for the Director, I think the remuneration decided by the Remuneration Tribunal, as I said, a year after, or within the first 12 months of Director Sharp being appointed, was from about $500,000 to $700,000.
Yes, a significant increase. Do you and is it there currently a live matter before the Remuneration Tribunal to determine the Associate Director's position?
I think it's been concluded, and I think it's actually been reported on publicly by the Remuneration Tribunal.
Do you know what that is?
I think the salary, again, I'd have to take on notice the detail, but it's a matter of public record. I think it's moved from about $400,000 to $500,000.
All right. If you could, Mr. Day, could you just confirm those numbers, including dates?
Certainly.
On notice. Can I ask about the funding? Has there been construction of a new office for your position?
Physical office?
Ms. Sharp, yes.
In the Melbourne office where I'm located, there were some remodelling works done to expand the size of the office, yes.
All right. It was to expand the size of the office?
Yes.
And what was the budget for it, or how much has been spent on it?
I would have to take that on notice, Senator, but we can certainly provide that.
Is it completed?
Yes.
And what was the rationale for the expenditure?
The office was, in our opinion, the officer's opinion, not commensurate with the head of an agency office. It was the same office that everyone was sitting in.
If I might,
what, sorry?
It was the same size office.
If I might
Is that
assist,
a problem?
Well, Senator Shoebridge, if I might assist, the office that the Director moved into when she took up her role in Melbourne, and her predecessor had been in Sydney, was a standard size office that we offer for any of our Band 1 SES, etc.
Yep.
On the basis of that, the nature of the meetings that the Director holds, etc., it was seen fit to increase the size of that so that she could have a modest space for meeting with the people that, are asking her to make decisions as part of her decision task, etc. It was nothing more than that.
Well, could you provide on notice if there was a report or some kind of recommendation, what it was that justified the expenditure and what the budget was and what the final expenditure was for the project?
We can take that on notice, Senator.
And Senator, I've just got the Associate Director remuneration details. So the Remuneration Tribunal made that decision on the 31st of March and increased the Associate Director total remuneration from $439,000 400 to 525,190.
Okay.
And it's got to be considered too, on that point, Senator Shoebridge, that the Associate Director role hasn't been filled for nearly 30 years. And it was thought that it was a needed role to fill, and so therefore the remuneration hasn't been obviously reviewed for a long time, outside of any standard rise that the Remuneration Tribunal might hand out across the place.
Well, I mean, I understand that there's this process, but to be honest, for myself, I'm always astounded at the sheer scale of the contract, of the remuneration given to the executive level and higher level in the Commonwealth bureaucracy. I can't comprehend it. My understanding is there's an element of public service to the work and people would do it for a sense of public service. So when I see their salaries and I think about those salaries being paid by taxpayers all around the country, I find them quite shocking myself. But, I suppose I'll leave it there.
Thank you, Senator Shoebridge. Senator Cash.
Thank you, and I'll just pick up where I left off. Thank you. In the context of a Division 268 war crimes prosecution, where the Attorney-General's written consent is required under Section 268.121 of the Criminal Code, before proceedings can commence, does the CDPP seek any separate or additional consent from the Attorney-General before granting immunity to a witness who is themselves potentially liable for a Division 268 offence? What's that no.
No, Senator.
If the CDPP considers it has independent authority to grant immunity in those circumstances without further AG involvement, what's the legal basis for that position?
Well, Senator, that's asking for an opinion.
Okay, so hold on. No, okay, I've incorrectly stated the question then. Under the Criminal Code, there is no requirement. Are you saying, it's obviously yourself as the CDPP,
yes, Senator,
to seek any separate or additional consent from the Attorney-General? Perhaps I better phrase it that. I'm not looking for a legal opinion, I'm actually looking for the legal position.
Well, Senator, I can relay the words of the Act,
yes,
and the Act requires that consent be given for proceedings to commence.
Thank you. That's the consent that is required. Okay. Yeah. No consent is required in relation to the granting of an immunity to a witness. That is a decision for you as set out in the relevant legislation.
Yes, Senator.
Yep. Thank you. Is the Attorney-General's Department informed, even if not formally, or formally consulted when immunity is offered to witnesses in a Division 268 prosecution? Is there any requirement to do that?
There's no legislative requirement for that, Senator, no.
No. Is that something that, by way of practice, the CDPP would do?
Speaking in relation to indemnities generally, no, Senator.
No. Okay. Does the requirement that a war crimes prosecution be brought, and I quote, in the name of the Attorney-General, close quote, under section 268(121) in brackets 2, close brackets, have any practical effect on the CDPP's operational decisions during that prosecution? So you're delegated the conduct of running the case.
Yes, Senator.
Can the Attorney-General then have any involvement in the case?
Well, the case is brought in the name of the Attorney-General, yes, and so the Attorney-General then retains a level of control over the case for that reason. In addition, the Attorney-General retains the power under the Judiciary Act to decline to proceed in any Commonwealth prosecution. That's a power that exists, that the Attorney-General has, regardless of the Section 268 requirement that it be in the name of the Attorney. But the authorisation to continue the prosecution is an ongoing live document,
yes,
and should the Attorney decide to revoke that authority, I don't see why the Attorney wouldn't have power to do that, but I don't have any specific...
No, and we're just talking general here, exactly. So in terms of the practical effect on your running day-to-day of any prosecution that's been consented to, you are effectively left to run the prosecution, but can the Attorney-General of the day give guidance, give direction, etc., including witness immunity decisions, or is that solely left to you?
Well, Senator, there are a few sort of parts to that. There's a prosecution to which the Attorney-General has consented.
Yes, so it's in the name of?
No. A general consent. There are a whole range of prosecutions which require the Attorney-General's consent to continue. And that might be the only involvement the Attorney has. And that's a point-in-time decision in relation to a particular prosecution. They've consented to the charges being made, and then that's a matter for my office how to run the prosecution. Then there are cases, this small subset, where they're brought in the name of the Attorney.
The war crimes.
And there are some others. And in those cases, then the equation is slightly different in the sense that the prosecution is brought in the name of the Attorney. And so we would engage with the Attorney about particular decisions for that. But the Attorney also, you asked about general guidance and guidelines. As I said, the Attorney has the power in Section 71 of the Judiciary Act to decline to proceed in relation to any particular prosecution.
Yes.
The Attorney also has power under Section 8 of the DPP Act to issue guidelines, formal guidelines to my office about matters.
On a specific individual matter basis?
It could be on a specific matter basis. That's a general power that exists.
Are these guidelines made public?
Yes, Senator.
Have any guidelines been issued in relation to the prosecution of Mr Schultz or Mr Ben Roberts-Smith?
No, Senator.
No. If they were issued, what's the public process to know? Is there a tabling in the Parliament?
Yes.
Right, okay.
If I could just take, Senator,
Yeah,
Section
thank you.
8 of the DPP Act.
Yes.
Just excuse me one moment.
So they do have to be made public, though?
Yeah. If I could just read from the
Yes,
Act, if that
please.
assists.
Thank you.
In the performance of the Director's functions, this is Section 8, subsection 1 of the DPP Act.
Yes.
In the performance of the Director's functions and in the exercise of the Director's powers, the Director is subject to such directions or guidelines as the Attorney-General, after consultation with the Director, gives or furnishes to the Director by instrument in writing.
Instrument in writing, okay,
Yes.
thank you.
And then subsection 3, subsection 2 says they could relate to various functions given or furnished in relation to particular cases, so
Yes.
they can be.
Yes.
Subsection 3, where the Attorney-General gives a direction or furnishes a guideline under subsection 1, he or she shall, paragraph A, as soon as practicable after the time that is the relevant time in relation to the instrument containing the direction or guideline, cause a copy of the instrument to be published in the Gazette.
Lovely. Thank you very much. I do appreciate that clarification. At the time the immunity was granted to the 4 witnesses in the Ben Roberts-Smith case, that's made public, isn't it? What's the process for making that public by your office as opposed to reading it in the media?
I am going to sort of resist answering cases about questions about specific cases.
Okay, so
as a general matter.
General matter, yes.
If I speak about cases generally,
yes.
The fact that an immunity has been granted at the time it's granted is not made public. However,
yes,
the fact that an immunity has been given to a witness in a prosecution,
yes,
is a piece of information that is disclosable by the prosecution and would always be known to a defendant before the person who has been granted the immunity gives evidence, so that the defendant is aware that an immunity has been granted.
Okay. So you never make any formal public statement that immunity has been granted?
No, Senator.
No. Okay. So my next questions were in relation to specific witnesses, so without naming them, but I'll put the questions to you, but I know what your answer is going to be.
There's also a non-publication order that's been made in proceedings, so I'm just conscious of that as well when I answer your question, Senator.
That's fine. No, okay, I'll put the next 2 on notice.
Thank you, Senator.
Okay, this is process, the questions that I'm going to ask now. Was the Attorney-General or the Attorney-General's Department consulted, notified or briefed formally or informally before immunity was granted to any of the 4 witnesses in the Roberts-Smith matter?
Senator, whilst that's a question of process, it is specific about an individual case.
Would you normally notify the Attorney-General's office that a decision to grant immunity has been made?
In the normal running?
In the normal running?
No.
Again, that is your running, well, it's your decision?
That's correct.
Okay.
In a normal case, no.
Okay. And is there a provisional law that says that?
Well, Senator, the short answer is no, but if I could give that some context.
Yeah, would you mind? Yes, please.
The DPP Act was established in 1983 and the office was established in the early 1980s with a specific intention of removing from the political process decisions about prosecutions.
Yes.
And so it's for that reason that the vast majority of decisions that are made by the person occupying the role of the director or delegated on their behalf are made independently from government and independent from the government processes.
Okay, and thank you for that explanation. In relation to immunity agreements themselves, are they ever made public?
The document, I'd have to take on notice what form the disclosure takes in cases where there has been an immunity, but certainly the fact of an immunity that the fact that a witness who's giving evidence in a proceeding has been given an immunity is disclosed to the accused. And if you'll just excuse me for one moment. Thank you, Senator. Yes. So if there's a prosecution in which there's an immunity being granted, and as identified from the annual report, there were 13 granted in that reporting year, the fact of the immunity is disclosed to the accused person.
The fact in relation to any details of the immunity, who knows that? Is that kept to the parties like yourself and the person to whom the immunity has been granted?
Yes, but relevant details about the immunity would be disclosed. So the disclosure test,
I
if it
don't
meets
want to
the
go near a
disclosure
specific
test,
case, obviously, but how would those details get into the public domain?
Well, they would only get into the public domain as opposed to being served on an accused once they're the matter of evidence.
And that's what's happened in... Yeah, understood. Okay. Yeah.
Well, I'm not sure that's what's happened. Once there's public evidence been given and a witness is asked about any immunity,
then it will become...
For me, that's in the public domain.
Yes.
Once information is provided to an accused, we have met our duty of disclosure, which is a significant duty that all prosecutors bear. For me personally, just to clarify language, for me that's not putting it in the public domain. That's just a matter of...
And I understood, and I do understand the difference. Thank you. I'm happy to come back after the break.
We are due for the afternoon tea break, so we will break for 15 minutes and we'll return with further questions for you, but we will suspend until 2:45.
Thank you.
Okay, we will resume from our afternoon tea break and return with Senator Cash.
Thank you very much. That line of questioning is finished. Again, I will go to process to the best of my ability. If I could now turn to consent that's required of the Attorney-General in relation to certain prosecutions. So, Director, can you confirm that the CDPP is the agency that requests the Attorney-General's consent under Section 268.121 and Section 268.122 of the Commonwealth Criminal Code?
Yes, Senator.
Thank you. This is based on evidence that we received yesterday when the Attorney-General's Department were before the Senate. So I'm now putting to you, it's a question I know the answer to. It was given to me last night, but I'm going to ask you if you could confirm it. Can you confirm that the CDPP made such a request to the Attorney-General in respect of the proposed prosecution of Mr Ben Roberts-Smith?
Yes, Senator.
Thank you. On what date did the CDPP make that request?
Well, we made the request to the department. It was then passed on, and the request date, I'll just confirm, I think 30th of March off the top of my head. Yes, 30th of March.
It was the 30th of March. And on what date did the Attorney-General provide her written consent?
On the 1st of April.
Thank you. When the CDP or yourself, is it yourself or someone on your behalf, but it's done in your name?
So the process for consents generally, which as we've discussed relates to a number of matters, there'll be a request document that we provide to the department, and the department will provide that to the Attorney-General.
Is it any different for crimes against humanity or war crimes, or they are within reason a similar pro forma document that goes up? Okay.
They're the same documents.
What material did the CDPP provide the Attorney-General in support of its request for the consent? I don't need to know the details of it, obviously, but do you provide a brief of evidence? Do you provide a summary of the alleged offences? What actually goes with that consent form?
Senator, that's a difficult question to answer because I don't want to disclose matters of legal advice that I've provided.
I don't want to know the contents of anything.
Well, Senator, with respect, the question is asking for the contents.
Well, if you were to say to me...
Information about the alleged offences and the prosecution's assessment, the CDPP's assessment of the prosecution as against the prosecution policy.
Thank you.
In terms of there being a prima facie case, reasonable prospects of prosecution, and that the prosecution is in the public interest.
Thank you. I think you've answered my next question, but I just want to confirm it. When you requested consent, you don't communicate to the Attorney-General directly, you go through the AGD.
The request is provided to the AGD, who facilitates that being passed on to the Attorney.
Yep, okay. Do you, when you request consent, do you provide information about the operational aspects of that consent, being the next phases of what occurs? So, for example, if consent is provided, then obviously there's a process that now entails the AFP, etc. Do you have any role in that, or is yours limited to the legal case for consent?
Our role is limited to the legal case for consent.
After that?
That's correct. Operational matters.
That's for another agency to answer questions on. Yep, okay, thank you. What would be the reason an arrest happens in a particular jurisdiction?
Senator, the decision when and whether to arrest is a matter for our operational partners.
Okay. So if a person was to live in one jurisdiction but was arrested in another jurisdiction, do you have a role in that, or is that the operational, it's a decision for, say, the AFP?
The AFP makes decisions around when and where to arrest.
Yep.
Yep. That's an operational decision for them.
Does anybody have any say in the jurisdiction? So, for example, a person lives in State A but is arrested in State B. Is there any direction provided by the CDPP as to the jurisdiction in which an arrest is made?
No, Senator.
So that is purely a decision for the AFP who appear in another block. Okay. Can I just confirm as well then that the CDPP's national legal direction states that a decision to commence a prosecution must not take into account any real or perceived advantages of a particular jurisdiction?
What document are you reading from, Senator? Just so I can...
I've got here the CDP national legal direction.
I only query because we do have national legal directions, but they're not all of them are public. I'm just wondering if that is a phrase in a different document. Could you just excuse me for one moment?
Absolutely. But in any event, you're saying it doesn't, it's an operational matter.
Arrests are an operational matter, yes.
Yeah, so that's got, you're in the consent for the prosecution, not what then happens after that. I put that to a different agency is what you're saying.
Sorry, Senator?
I put that to a different agency. The
yes,
AFP,
yeah,
the operational. Yep.
If I could just complete the picture.
Yes.
Criminal law is traditionally, and I'll take half a step back to answer,
Yep.
and I apologise.
Thank you. No, please.
Criminal law is traditionally geographic in
Yes.
the common law world from England.
Yep, exactly.
And we know that, you know, crimes that happen in Victoria are prosecuted by the Victorian DPP. Where a federal crime is not committed in any one state,
yes,
the Judiciary Act in section 70 capital A provides that the prosecution can be in any jurisdiction.
Right. Who chooses the jurisdiction? Is that at your part of the process, or is it at the operational part of the process?
It's not the case to say that there's a choice in that sort of context.
So how does that sort of arise then?
Well, Senator, the matter of the jurisdiction, I imagine, in certain cases, which you've said you don't wish to speak about.
We're trying to be very. I know.
Will be the subject of could be the subject of litigation, and so I'm loath to run my case in this context. I think that's. I don't think that's appropriate.
The consent was provided on the 1st of April in relation to the Ben Robert Smith case.
Yes, Senator.
It is a public fact, again I'm trying to not go through, that Mr Robert Smith was arrested and charged on the 7th of April 2026. During the intervening period, was the CDPP involved in any discussions about the arrest and when it would occur, or more generally?
At a very high level, only to the extent that it was imminent.
Okay. When were you made aware, or the CDPP made aware, that the arrest would be made at Sydney Airport?
I'd have to take that on notice.
Okay. I may have some questions that I'll place on notice.
Thank you, Senator.
But that concludes. I'm trying to be. I'm respecting, and you've been very kind so far. Think you've been, as I said, we're trying to talk to law here. There isn't. I'll turn to the ISIS bride shortly, but you probably may have had this brought to your attention from your media team. And it's in relation to, we discussed it yesterday in the Attorney General's Department. There was media reporting about the issues of amending the hors de combat definition with the Attorney-General's Department. As I said, we discussed that yesterday. The evidence that was given to me when I was pursuing how did it actually occur at the time was, and I quote, "My understanding is that it was brought to our attention by the Commonwealth Director of Public Prosecutions as an error." Is that correct?
Yes, Senator. So we identified what we thought was a drafting error in the provision, and we brought that to the attention of the Attorney-General's Department.
And can I ask, when you say we identified what you thought was a drafting error, I mean, these laws have been in place for a very long time. How did you identify the law? What were you, and that it may have been a drafting error?
Well, Senator, there's some legal advice buried in the answer to that question.
Yes.
But in the context of work we've been doing with the OSI, we were looking at all of the relevant provisions, and the anomaly between the definition in the
Rome
definition
statute,
in the code and the definition in the Rome statute was identified, and that anomaly was brought to the attention of the department.
Understood. Did you ask for the change to the law that had been in place, as we've said, for 22 years? Did you ask for it to be made retrospective?
I'd have to take that on notice. I haven't looked at it, but I'd have to take that on notice.
Would you mind? And look, the reason being, I'll be very upfront with you on this, because it's certainly been suggested, given what's now occurred, the charge had a significant impact on the prospects of prosecuting Australian soldiers for war crimes. Mr Schultz had already been charged in 2023 on your recommendation. Was it your recommendation at that time? Were you?
No, Senator, I was not the director at that time.
It was the previous. Sorry, I won't say you then. Apologies, I will withdraw that. On the recommendation of the then...
The previous office holder.
Previous office holder to the Attorney-General. One of the issues that has now been raised is, did the CDPP make this change the following year in order to make it more likely you could successfully prosecute Mr Schultz and other Australian soldiers?
If that's a question about the motivation, I'll just refer to Ms Chidgey's evidence yesterday about the nature of the amendment, that it was clarificatory to confirm that the words in the statute actually mirrored the intent when the legislation was passed. So to the extent people are speaking about a retrospective application, Parliament's, as I understand, and Ms Chidgey will correct me if I'm wrong, as I understand it, Parliament's intent when the legislation was passed was that it looked as it does now post-amendment. And so whilst people use the word and the language of retrospective, because it's clarificatory, I don't know that it's technically retrospective in the way that it shifts the goalposts in the way that people are speaking about.
In terms of the operation of the law, so the words changed being and to or, does that have an effect on the threshold that you no longer have to have the and elements of the offence, you can actually choose which element of the offence?
Senator, that involves providing some legal advice about the construction of the particular provision, which is, and I'm loath to provide advice. I'll just repeat, I think, if I can, I'm sorry, the evidence that it's clarificatory and that it just reflects the requirements of the provision of that definition of order combat that's in the Rome Statute, and that's the internationally accepted definition.
Just talking through, given that you picked this up and that, not you personally, the office picked it up and the request was then made to the government, can I put to you, isn't it the case that what the change does is alter the circumstances where an enemy combatant has actually surrendered, and by extension it expands the range of activities covered by the criminal offence?
Senator, to the extent that it's a clarificatory amendment, it doesn't actually have that effect because it's simply clarifying what it was intended to do at the time it was passed.
Understood. I may put some further questions on notice to you in that regard. Can I turn to another topic?
Please.
The ISIS brides. So, yesterday we heard from the Attorney-General's Department about the timing of the CDPP's request to prosecute 2 of the cohort. I'm going to refer to them as the ISIS brides, purely because that is what we know them as, with crimes against humanity. Can I confirm, what date did you send the brief to the Attorney-General for that, or to the department?
To the department. I might ask Mr de Crespigny if he has those dates in front of him there. Or just excuse us one moment, Senator.
No, please. It's...
Senator, unfortunately, I'm doing this from memory, but I believe it was about the 20th of November.
Thank you.
If it was a different date, I'll correct the record.
20th of November. So that was when it went to the department. And then I think the evidence last night then, because it was very kind of you to do it from memory, consent was provided on the 15th of December.
Yes.
Yeah. Thank you for that. In relation to the... Was it only 2 requests for consent that were submitted for consideration?
Senator, if there were more and those people haven't been charged, it wouldn't. I'd be loath to go into details about ongoing operational matters.
That's fine. No, I accept that. Which means you are probably not going to be answering the rest of my questions, but I'm going to ask them. No, and you've been, as I said, you've been very kind so far. Thank you for the answers that you have provided. I very much do appreciate them. Today, another cohort of ISIS brides is due to arrive back in Australia. Is the CDPP expecting to request consent to prosecute any in this cohort?
Senator, we are responsive to our partners, and if we have briefs referred by our partners, then we will review those and...
Understood.
If consent is required, we'll seek a consent.
There's a process before it gets to you. It goes through the AFP, who are gathering the evidence, etc., and come to you. Yes. I'll push my luck. Have you received any briefs of evidence from the AFP? I pushed my luck.
Can I pushed my luck. Ask the AFP?
I know. Understood. No, I
don't want to not assist, but
no. I completely understand. It's. In terms of any involvement by the CDPP in a consent application, is that process initiated when you receive the brief from the AFP?
So we receive briefs in a number of different contexts. Sometimes we receive a brief for what's called pre-brief advice. So we'll get a brief, we'll provide advice about whether there's sufficient charges. We'll identify that a consent will be ultimately required.
Yes.
We'll get a brief. Sometimes we have a completed brief. Some people can be charged before the consent is required to be obtained. And we'll identify in the process of assessing a brief or assessing material that we're provided that a consent is required. And then throughout the process, we'll seek and obtain the consent hopefully in a timely fashion and certainly before it's required.
In terms of the 2 consents that we've been discussing, so the one that was provided to the department on the 20th of November...
The ISIS brides consent?
The ISIS, thank you. When was the AFP brief of evidence presented to the CDPP?
We'd have to take that on notice, Senator.
Is it a long time beforehand, or is it...
It depends.
It
depends. Yeah. It depends on the matter.
If I could get you to take that on notice, and was it provided in one tranche where there's several requests?
Yes. Yep. It's difficult to, when we use the word brief, traditionally...
It used to be...
It used to be 5 statements and a record of interview. Briefs are an iterative process, and as you've identified, there are several tranches. And so it might be that we receive material on one date and further material and further material, and that material can keep coming. So it's oftentimes difficult to identify a specific date on which we would say a brief
as such. Perhaps the first time you received the substantive body of evidence.
Thank you.
In relation to. Thank you. In terms of when you do get the substantive body of evidence, or we'll refer to it as the brief, is that an AFP-only investigation, or is evidence gathered and provided by other agencies to you as well?
Are you speaking about a specific matter, Senator, or generally?
Generally, like ASIO, the ABF, the Australia...
Senator, we... unlike the state DPPs, who have a very limited number of partners, their state police force, we have up to 60 different Commonwealth partners, and from time to time they have joint investigations with each other and with state and territory authorities. So I don't necessarily know in a particular case which agencies have provided evidence that might contribute to a brief, and it may or may not be clear. We get a body of material which we assess for its relevance, and we assess the gravity of the evidence as against the prosecution policy and make decisions based on that.
So I was going to ask, was there a formal referral document? No, you get a brief of evidence.
We get a body of material.
You determine from that brief your position going forward.
Yes.
Just in terms of the crimes against humanity, consent to prosecute for crimes against humanity is required under section 268.121 of the Criminal Code. Can you confirm that this is the legislative provision under which consent was sought? And can I then get you to explain the legal effect of that provision?
So, Senator, there are a number of questions there. So if a consent is required under a particular provision, it's sought under that provision.
Yep.
That will be identified in the materials. The effect of that is that the proceeding cannot be brought without a consent.
Without the consent,
it's a precondition. So the effect is that the proceeding can be commenced. Or
that is literally. Now, something we discussed yesterday, and we're taking on notice to get an answer. If consent is not given, what do you... Can you go back with a reformed brief?
Well, I could. It's a hypothetical situation, but I don't...
But nothing stops you?
There's no legislative barrier to seeking a consent in relation to a supplemented brief or a different brief. Yes.
And you'll probably need to take this on notice. In terms of the provision of the request to the Attorney-General's office and then the period of time that elapsed when the consent was actually given, can you just take on notice whether or not there was any correspondence or communication between the CDPP and the Attorney-General's Department during that period, requests for clarification, supplementary briefs, etc.?
Yes, Senator. I can say that I did meet with the attorney and there were some communications, but I'll take on notice the details.
Thank you very much. Thank you.
I'm sorry, Senator. Let me clarify which consents you're talking about.
The ISIS brides.
Thank you.
Yes.
Sorry.
No, you have to. I don't know. Completely understand. Just in terms of you requesting consent from the Attorney-General to prosecute, which in this case consent's been given, the two women for crimes against humanity, were you aware at that time that the Department of Home Affairs is separately managing questions relating to that same cohort, including temporary exclusion orders, passport decisions and border management? Are you brought into the whole picture, or do you just see a part of the picture?
We make our decisions based on the material that's provided. I can't speak to individual officers' knowledge of other matters that might be in the media about that cohort, but we're very clear in terms of the guidance that we make decisions based on the evidence we have, my reference to the prosecution policy.
Do you have an obligation, if consent is given for something like the crimes against humanity, so the people are still overseas, to notify any other department?
No, Senator.
No,
it's a
that's not for you to do?
It's not for me to do, but equally it's a procedural matter in the context of an ongoing criminal investigation if it's pre-charging. And so normally those matters, the AFP would keep a tight hold on the matters it's investigating in order to protect those investigations.
Okay. when the Home Affairs Minister and his department were when the Home Affairs Minister, not the actual minister, but the person representing the department, were appearing before Senate estimates in October 2025 and February 2026, and were answering questions about this cohort and being managed, including on temporary exclusion orders, passport decisions, and the AFP's investigation. Is the CDPP in any way involved in preparing for any of those answers, or is that completely separate to you?
No, Senator.
Totally separate, yep.
No, Senator.
Thank you.
Thank you, Senator.
And I really do appreciate it. Thank you very much.
Excellent. That concludes the question.
No, and really and truly, that very much appreciated the way you approached the answering of the questions.
We have for the CDPP today, and thank you very much, Mr.
Thank you, Chair. Thank you, Senators.
All the times you've come before Senate estimates and provided very important information, and all the best for your retirement. We will take a short suspension while we welcome our next witnesses. Thank you. We will now resume with the Australian Human Rights Commission. Mr. Kurtzer, would you like to make an opening statement?
I do have a brief opening statement.
Sure.
So I acknowledge Ngunnawal and Ngambri elders and ancestors, their ancient and ongoing culture and their unbroken connection to the country.
Sorry, I might just get your microphone turned off if I can, or if you might be able to speak a bit louder into the microphone just because it's a bit soft.
Yep. Is that better?
Yeah.
I can hear myself. Senators, I acknowledge we're meeting on Ngunnawal and Ngambri country. I acknowledge their elders and ancestors. I acknowledge their ancient and ongoing culture and their unbroken connection to country. Today is National Sorry Day, a day to acknowledge the injustice of the policies that led to the stolen generations and the strength of the people who survived that injustice. The day was chosen because it was this day in 1997 when the Australian Human Rights Commission's landmark Bringing Them Home report was tabled in this Parliament. Our report built on the generations of advocacy by First Peoples. It documented their testimony and drew on their calls to recommend change. It was an important act of truth-telling that led to former Prime Minister Rudd's apology and which contributed to widespread public understanding of the historic injustice and its ongoing impact. It also led to compensation schemes in all Australian jurisdictions, including the territory scheme set up by the Morrison government in 2021. Only Queensland has so far failed to establish a compensation scheme. Today also marks the day that the Uluru Statement from the Heart was issued in 2017 with its call for voice, treaty and truth. Victoria completed its truth-telling inquiry in 2025 with the Yuruk Justice Commission, and Travis Lovett, a Deputy Commissioner from that commission, is currently on the penultimate stage of his 800-kilometre national walk for truth to promote the importance of national truth-telling, healing and change. He started walking from the Victorian Parliament on the 19th of April and will finish his walk at this Parliament tomorrow. His journey is an important call for action to ensure equality and justice for First Peoples. Senators, I want to acknowledge the commencement of the hearings of the Royal Commission into Anti-Semitism and Social Cohesion. The evidence heard from the Jewish community in the Royal Commission's opening weeks has underscored the extent of anti-Semitism in Australia and the profound impact it is having on people. I acknowledge the courage of those who have shared their testimony through the hearings and through submissions, often at great personal cost. We must honour their evidence and bring about change to eliminate anti-Semitism and all forms of racism in this country. Finally, I want to acknowledge the important full court of the Federal Court decision in the Giggle and Tickle case, which has received significant attention. In the case, the court found that a women's-only social networking app had a policy of excluding trans women. It put that policy into effect by removing a trans woman from the app based on her appearance and then refusing to readmit her when she asked. These two acts amounted to direct discrimination on the grounds of gender identity, and in the circumstances of this case, discriminating against someone by refusing to provide them with a service because of their gender-related appearance breached our national legal protections against gender identity discrimination. The case provided important consideration of the meaning of key terms in the Sex Discrimination Act. This legislation protects people from discrimination on multiple grounds, including sex, sexual orientation, and gender identity. It includes exemptions and special measures recognising circumstances where different treatment may be desirable and lawful. The Commission was granted permission to intervene in the case and to provide independent, impartial submissions to assist the Court on questions of law and the interpretation of the legislation. The Commission did not appear for either side in the proceedings and was not a party to the proceedings. The Commission supports the right of all people to live free from discrimination. We look forward to today's session with this committee.
Thank you, Mr De Quetzer. We'll proceed to questions and begin with Senator Cash.
Thank you. Commissioner, as the head of the Commission, are you able to answer the very simple question of what is a woman?
I think we've been asked that question before, but
not
yes,
by me.
Happy to answer.
Thank you.
And I was just going to say, I think one of the things that we were clear about is asking matters of opinions rather than what the legislation and sets out for, like the sex.
This goes directly to the heart of the case that the Commissioner just raised.
Sure, as long as it's not asking Mr De Quetzer for an opinion, sure.
No, I'm asking him from the Commission's perspective, what is a woman?
An adult female human.
Thank you.
And includes a transgender woman.
Thank you very much. I now have questions for the Sex Discrimination Commissioner. Commissioner, just before I go to the Sex Discrimination Commissioner, just in response to your previous question, you defined a woman as an adult human female. You then said it includes a transgender woman. On what basis can an adult human female include a transgender woman?
Is that question directed
to me?
Yes,
I said Commissioner.
My apology. Oh, to the Sex Discrimination?
No, to you. I said,
sorry.
I will come to the Sex Discrimination Commissioner.
So I'm the President of the Commission.
Oh, President.
So you asked on what basis is that
Can
definition?
an adult human female, did you say includes a transgender woman?
Yeah, correct.
So the definition of woman includes a transgender woman is what you said?
If you look at the Sex Discrimination Act, which is the legislation that we administer, the definition of sex was interpreted by the court in Giggle and Tickle, both in first instance and on appeal, and the court has said that the definition of sex was intended by this Parliament to not be binary and not be immutable, so that someone under state and territory law, under identification law, can change their sex, and someone can also be non-binary, and that's recognised under state and territory law and federal identification law, and therefore a trans woman in the circumstances of this case is a woman for the purposes of the Sex Discrimination Act.
And I think the court also said that it interpreted the law, and on that basis, if the Parliament wished to change the law to reflect that male and female represented biological sex, it was for the Parliament to undertake that change.
I think there were comments to that effect, and also recognising that these are questions that people hold deeply held views about and contested views about.
Thank you, President. Commissioner, just in terms of the Sex Discrimination Commissioner's role, is the result of the full federal court decision in Giggle and Tickle that a women-only app cannot exclude a biological man who identifies as a woman?
That is correct. The full federal court has found that, as the President has just referred to, that there were two acts of direct discrimination by excluding a trans woman from the social media app, which was for women and girls.
Yes. So, as I said, a woman-only app cannot exclude a biological man who identifies as a woman.
The use of the word biological man is not used in the Sex Discrimination Act. That's not the term that the full federal court was defining. What it defined was, what does sex mean under the Sex Discrimination Act? And what sex means under the Sex Discrimination Act, it takes into account biology and physical characteristics, but it also takes into account someone's social recognition and their presentation of themselves.
But in plain English, for people who are not over the Sex Discrimination Act, what it meant for them is the women-only app, the Giggle for Girls app, is not able to exclude someone who is a biological male but identifies, to use your words, as a female.
There are ways in which, if a particular service wants to discriminate against particular groups, if it is a special measure to achieve
yes,
substantive
equality. I will be coming to the Lesbian Action Group in their 3-year battle for the lesbians to be able to hold lesbian women-born only events. I will be coming to that. I might as well put you on notice as well. I will, and I might as well circulate this now so people can actually become familiar with it. We'll also go through the fact that on International Women's Day, the trans women had a forum by trans women only event, and I just want to understand how that was able to occur as well. But we'll come to that. Your commission, I understand, welcomed that decision, the Giggle and Tickle decision, in a media release on the 15th of May 2026. Is that correct?
That's correct.
Okay. Was it, when it's the commission that welcomes a decision, is that all of the commissioners, or is it only certain commissioners?
I might defer that to either the Chief Executive or to the President to answer for the process for approving media releases.
Yeah, it depends who's quoted in the media release, but normally if it's a statement on behalf of the Commission, that would be endorsed by all Commissioners and the President.
Is it a formal endorsement?
Normally, yes.
So are you saying to
I should clarify, recognising that media responses are often time sensitive. It's a decision taken normally by email communication.
Right, okay, so all commissioners agreed to welcome the decision.
I would need to check that and come back.
Would you mind checking that on notice and getting back to me? Thank you very much. Commissioner, you personally celebrated the win on LinkedIn, is that correct?
I would not use that verb to describe my post on LinkedIn, Senator.
Well, how would you describe it?
That it was a decision which provided clarity about the constitutionality of the amendments to the Sex Discrimination Act and ensured that the effect of the 2013 amendments was to protect people on the basis of gender identity.
Okay. Commissioner, for the purposes again of this estimates hearing, as the Sex Discrimination Commissioner, what is a woman?
Under the Sex Discrimination Act, clearly there are biological differences between men and women, but in terms of protection from discrimination, biology is not the only part of what defines a man or a woman. It is also defined by how that person identifies themselves as well as how they are socially recognised. And one of the key parts of the Sex Discrimination Act is the importance of protecting all women from discrimination.
And that's in terms of the Sex Discrimination Act as it was changed in 2013 and as it's now been interpreted by the full federal court.
Correct.
Thank you. The Commission's January 2026 explainer states that sex is not binary and can be changed from the sex you're assigned at birth. Can I just confirm that that is the Commission's position?
That is the legal position that has been recognised since 1993 in a case SRA in the DSS, that sex is not immutable, that it can be changed and that it is not binary.
one of the issues that therefore comes up, and in particular just with mum and dads in the street who are not all over the Sex Discrimination Act, in terms of what then actually is the test for someone who is a biological man identifying as a woman, what is actually that test? So, for example, can a man put on a dress and call himself a woman, and then for the purposes of the Sex Discrimination Act, and in particular, say, Section 5B, they are a woman?
As I referred previously, it'll involve a court or anyone looking at those three aspects that I referred to. So biology and physical characteristics
is one. So
as well as how they present themselves and how they are recognised.
When you say they are recognised, I understand how they present themselves. So a man puts on a dress and he wants to give the physical appearance of wearing a dress and being associated with being a woman. When you say they are identified, is that by themselves or by another person?
There are two aspects. One is socially recognised and how they present themselves. So it's both self-presentation as well as social presentation.
Do they both have to, do you have to tick all those categories, or?
The full federal court, it referred to those three aspects.
So all three must be satisfied. So I put on a dress, I want to dress like a woman, even though I'm a biological man. I am now telling you that today I am a biological woman, even though I am a trans woman, even though I am a biological man. Is that not enough to satisfy the definition?
I think I've answered the question, Senator, which is that there are three aspects that the court must look at.
Because some people would look at a trans person and say, well, I don't recognise that. Are you saying that unless I get that recognition, I'm not a trans woman?
It's up to the court in defining what is socially recognised.
So are you saying the court said those three elements have to have been satisfied?
Those are the three elements that they referred to in the decision.
Senator Cash, I'm going to share the call and come back.
Thank you.
Yeah.
Yep.
Thank you. Senator Faruqi.
Thank you, Chair. Good afternoon, everyone. I have some questions for the Minister representing the Attorney General and then for the Race Discrimination Commissioner. So Australia, as you know, is seeing an alarming rise in racism. I mean, just recently, a man was charged for threatening to have an AK-47 firearm after entering a Brisbane mosque. And people of colour across the country are living in fear and exhaustion while racism becomes increasingly normalised as the far right, One Nation, and the Liberals escalate their hate-filled anti-migrant, anti-Muslim rhetoric. And I'm afraid to say, Minister, that your government is sitting on its hands as the National Anti-Racism Framework gathers dust. Why is the government refusing to fund the National Anti-Racism Framework? There was no funding in this budget to start implementing the anti-racism framework. Why aren't you funding it?
Thanks for the question, Senator. Obviously, the framework was published by the Commission in November 2024. The government has provided funding to the Commission to develop the National Anti-Racism Strategy, of which the framework was a part of that. Further to that, we're carefully considering the recommendations of the framework. It's not a requirement that the government would respond in the way that other reports require a response, but we're considering those recommendations. And, you know, further to that, we're certainly committed to a holistic response to address racism. There's quite a number of projects that are underway that you would be aware of. We're funding the Commission $2.5 million for the Racism at Uni project, $2 million for the Commission for the Seen and Heard project. And we're looking at, we're funding the Commission to deliver a new anti-racism campaign, which I'm sure that they can speak to in full detail. There's obviously a range of other things that we're considering or addressing, including comprehensive hate speech reforms, which we brought to Parliament.
Yeah, Minister, I'm asking specifically about the National Anti-Racism Framework. It took years and years of work. and many millions of dollars for the AHRC and the Race Discrimination Commissioner and the department to complete that. It has been 19 months since that framework was launched. I mean, how much more consideration do you have to give to 63 recommendations that will start, actually you said you want to look at it holistically, start addressing racism in a systematic way in this country. Like, you can do report after report, and I've seen all those reports as well, but even the Racism at Universities report has been out there now for some time with no response from the government. So I want to ask you, has the government, do you think have you identified a flaw or an issue with the framework that justifies you shelving it for 19 months and not even responding to it? You said you don't have to respond to it in the usual way. I don't know what that means. A response should be fund the budget, put some money in the budget to start implementing some of the recommendations. So have you found a flaw in that national anti-racism framework that you are still considering it after 19 months?
No, Senator, that wasn't my evidence. My evidence was that we welcomed the framework and we're providing a holistic approach to making sure that we are addressing racism in our society. We certainly have taken you through a number of the ways that we are doing that. If there's broader policy questions, of course, there was an opportunity to ask those yesterday, but if there's questions about the work that the Commission's doing, they're here to answer those.
Well, the Commission did produce the framework, so I'm asking you, this is the right place to ask the question. The framework, just in September last year, the Race Discrimination Commissioner warned the Attorney General that unless Australia addressed the structural roots of racism, racist hatred would continue to spill onto our streets. And the framework is the holistic way, as you keep saying, and the structural way of addressing racism. I guess my question is, do you think that racism is an issue in this country?
Senator, there's no place for racism in this country, for hate, discrimination of any kind. We've been very clear about that, and we certainly believe that every Australian, no matter of their race, is entitled to live their life freely, without prejudice, without discrimination, and that's how we're approaching this issue.
Do you think racism is an issue in this country?
Oh, Senator, I've answered your question.
No, you have not. Of course, racism is unacceptable, but do you think it's an issue in this country? Do people face racism in this country?
Senator, I've answered your question about what the government is doing about this issue and the way that we are approaching it.
When will you provide a response to the National Anti-Racism Framework?
I'll let the department answer that. If there's any work underway, they can let you know.
Thanks, Minister. Consideration of the framework is being conducted across a number of departments. I note that many of the recommendations are directed at the Commonwealth Government, some are at state governments, some are at the private sector, so it's not for the Commonwealth to solely implement the recommendations or consider the recommendations. There is ongoing work alongside considering the reports of the special envoys for anti-Semitism and Islamophobia. So there's a broad range of connecting issues that are being considered across government.
Sorry, that wasn't my question. You said there are recommendations to the Commonwealth. When will the Commonwealth respond to those recommendations?
Well, I think, as the Minister has already said, there is no requirement to respond to Commission reports. Obviously, there's a process of looking at the report and using those recommendations to inform further work, and that's what's happening at the moment.
Well, it's been 19 months. Like, it just seems to me, Minister, that the government really does not give a damn about what people of colour are facing in the community every single day. Like, the documents that we forced out of the government recently show that the Race Discrimination Commissioner has written to the Attorney General on multiple occasions, literally pleading for action on the National Anti-Racism Framework, and yet the only response that even the Race Discrimination Commissioner gets is it is being carefully considered. So, who am I to seek a response from you? But while you are carefully considering, people are being harmed every single day in this country. So I would really want you to do something about it. I mean, it's exasperating coming here, every estimate, asking the same questions over and over, getting the same non-responses over and over, while people in the community just keep kind of suffering. You said that you were, you are considering the other reports that are being done. And I do know that obviously there is a lot of focus on anti-Semitism at the moment. There's a Royal Commission going on. We should address obviously all types of racism. But is there, when you really want to tackle social cohesion, you have to tackle racism in all its ways, shapes, or forms. Do you think there's an issue in giving higher priority to some sorts of racism and not others? Don't you think that further exacerbates and divides communities when you don't fund one sort of racism but try and fund some other sorts of racism? Do you think that's an issue, and is that a double standard?
Senator, I think first of all, a couple of things. First of all, that's not what the government's doing. I reject that assertion. I think if we are still here giving evidence in the section of the Australian Human Rights Commission, which the committee agreed to, I'll speak to what the Human Rights Framework does. It doesn't distinguish between different types of people who are entitled to protection under the law. And the government from time to time will fund different programs for different reasons. But we have spoken to you about some of the things that we are doing as a government holistically. Of course, there is work across the entire Attorney General's Department, which our officials were here yesterday to give evidence about that, and across government on a range of matters. I think, in the way that you're entitled to give long preambles to your questions, but I reject the assertion that you've made.
Okay. Well, how much funding have you provided to the anti-racism framework in this budget? How much funding have you provided, for dealing with anti-Muslim hate in this budget?
Senator, I've taken you through the different pieces of work that we are funding. I can take on notice your question.
But I can tell you zero funding for the anti-racism framework, zero funding for addressing Islamophobia.
I can take your question on notice.
In 2020, in this year's budget, the AHRC had its staffing slashed from 165 to 154. Since 2024, the Commission has had its staffing cut by 29 positions, I think a cut of 16% over 2 years. In this year's budget, the government has also cut funding by 9.425 million, down to 67 million. And speaking about Australia's recent UN periodic review, the president of the AHRC noted that the country has regressed on a number of human rights issues since the last review, namely racism, failure to meet the closing the gap targets, the age of criminal responsibility, a lack of progress on truth-telling and treaty, and our treatment of people seeking asylum. And these areas of regression, which have been identified by the president, all predominantly impact First Nations people and other people from culturally and racially marginalized backgrounds. So I guess my question to you, Minister, is how can you address these issues while cutting funding from our big human rights body?
Well, I'll let the department take you through the budget measures. The advice that I have is that is not correct, what you have put forward, that there has been work that has been funded, which we would refer to as a terminating measure, that has come to an end, and that is reflective in the budget figures. But I can let the department or the commission take you through the breakdown of that funding.
Sure. Just if you could tell me, has there been a funding cut to AHRC in this budget?
There has not been a budget cut, Senator.
Okay.
So the government's invested from the 2022-23 budget, an additional almost 50 million over 4 years in the Commission. I'm sure the President can speak further to it, but the Commission has project and terminating funding work for specific work, and that on occasion is time limited, but the government has increased the Human Rights Commission's annual appropriation.
Okay, I think my time is up, Chair. If you could come back to me in the next round. Thank you.
Sure. Senator Roberts.
Thank you, Chair. Thank you for appearing again today. Could I speak with Dr. Cody, please? Hi there again. My first question seeks to clear up your role in Tickle versus Giggle. You did not prosecute the case and you did not fund the case, yet you presented a legal opinion in an amicus curiae, friend of the court submission. Is that correct?
That is correct, that our role was as amicus curiae to assist the court to understand aspects of the Sex Discrimination Act.
Thank you. For clarity, your submission set out the law, the Discrimination Amendment, Sexual Orientation, Gender Identity and Intersex Status Bill 2013, passed under Prime Minister Gillard. It changed the definition of woman, which can now be a person's self-described gender identity, including appearance, mannerisms or other gender-related characteristics, with or without regard to the person's designated sex at birth. You argued Tickle was a transgender woman with female legal recognition and presentation, and therefore the treatment from Giggle was properly characterised as gender identity discrimination. Other sections around special measures to promote gender equity, including Section 7D, were subordinate to the overarching definition of gender in the Act. In simple terms, is that your advice to the court?
No, Senator, it wasn't. We did not make any submissions on whether or not Ms Tickle had been discriminated against. Our role was to assist the court to understand the constitutionality of the 2013 amendments and then also to discuss meanings of sex and gender identity within the Act, also the meaning of special measures and how they would apply, as well as any role for exemptions.
Okay. Thank you. Amicus curiae, pardon my Latin, is a neutral or advisory role to help clarify legal questions. Are you neutral in the Tickle versus Giggle case?
Our submissions were to assist the court to understand and to interpret the Sex Discrimination Act. So yes, that was our role as a intervener to assist the court.
Are you neutral?
Our role was to assist the court to understand the provisions of the Sex Discrimination Act.
Are you neutral?
Senator Roberts, the Commissioner has answered your question.
How can you be neutral when you marched into court at the head of the scrum of people on the Tickle side of it? You were making a clear statement in that action of support of one side of this case, a personal show of support not appropriate to an amicus curiae role. Were you not?
No, Senator. We took seats on the only space that was available in the courtroom. That's why we were sitting on the right-hand side of the courtroom.
I saw your comments in the publication Out in Perth in April 2024 where you said, quote, "We stand with trans communities and will continue to advocate for their rights and the rights of women." You are making a very clear distinction here between the rights of women and the rights of transgender women. Do you agree your comments amount to a statement that trans women are not women?
I'm sorry, Senator, could you repeat that question?
You talk about trans women and you talk about women. Doesn't that show that they're different?
Transgender women are a subset of the broader category of women. Women includes First Nations women, women with disability, older women, younger women, women from culturally, racially marginalised backgrounds, and trans women, lesbians, non-binary sometimes would include in that as well.
Okay, I'll come back to that. Moving on, this report, titled Equal Identities plus a long subtitle, was published under your name as Sex Discrimination Commissioner. Can I confirm your official position as contained in this report is that trans female exclusion from sex-based spaces or services, for example, women-only apps, shelters, sports and bathrooms, is unlawful gender identity discrimination under the Sex Discrimination Act, Section 5B? Is that correct?
No, that's not correct, Senator.
It's not correct.
That's not what the report refers to, and that's not my position.
Section 42 of the Sex Discrimination Act, which provides an exemption specifically allowing sporting organisations to exclude someone, including a trans woman, from a competitive category of strength, stamina or physique matters in that sport. I haven't heard your office mention this exemption, which is directly relevant to controversies surrounding or around, for instance, the Flying Bats Football Club. If you do in fact provide independent advice, as you claim to do so in the Tickle case, why haven't you advised the opposing teams that keep getting injured that there is an exemption to protect them in the Act?
It's not our role to provide advice to individual parties. We conciliate complaints if someone makes a complaint of unlawful discrimination, and we advocate for the human rights of all people within society, recognising that all people have a right to equality, respect and dignity. That's human rights law, and as it applies in Australia.
Do you want Section 42 sport exemption removed from the Act?
No, Senator. It has a legitimate place to play where strength, stamina and physique are relevant to a sporting activity.
Why strength, stamina and physique? Is that a distinction between male and female?
The words are strength, stamina and physique, so different sports have different requirements around each of those, and so that's an important exemption that when the Parliament passed the Sex Discrimination Act, it included to ensure that sport enabled people to participate fully within it.
Let's move on. Your report recommends repealing or narrowing exemptions in the Sex Discrimination Act, such as Section 43A, that allow sex-based or faith-based exclusions. Broad religious exemptions are criticised as creating uncertainty and legitimising exclusion. What right do you have to present an amicus curiae brief when you are already clearly heavily biased in favour of Tickle and opposed to religious freedom?
Our role within the Australian Human Rights Commission is to advocate for the human rights of everybody within our community. That is a part of our role as a national human rights institution. Our role as amicus curiae is a different role. We're not advocating in that situation, but rather providing clarification to the court on the meaning of the Sex Discrimination Act.
I note the Gillard government legislation that caused this ludicrous outcome passed on the voices with Senator Birmingham, head of the Liberal Party in the Senate, on behalf of the coalition, calling the bill, quote, a very welcome piece of legislation, and end of quote, and specifically supported the absurd and illogical gender identity provisions. So I'm just clarifying the record. Dr. Cody, what is the difference between gender identity and gender? Because in your answers to Senator Cash, you implied there was a clear difference between gender identity and gender. What is the difference?
I was referring in my answer to Senator Cash to how sex is understood within law and in terms of the protections provided in discrimination law. Sex looks at three aspects. Those are biology and physical characteristics, as well as how someone presents themselves, as well as their social recognition. So those are the three aspects that relate to how sex is understood under the Sex Discrimination Act and within discrimination law more broadly.
And what about with regard to the differences between gender identity or people who identify as a gender and the real gender? Does it apply there?
Gender identity is within the Sex Discrimination Act. I can refer you to the provision for gender identity, but I don't have it to hand right at the moment.
So gender identity is a construct of the law. Is that correct?
Gender identity is protected as a protected attribute within the Sex Discrimination Act. It's not only an aspect of the law.
So if someone introduces a bill and it gets through the Senate and the House that says men are the same as women, that's the law. Is that correct?
It's up to the Parliament to pass its own laws, Senator.
Right, so the Parliament can say men are the same as women, end of story, that's it. So, okay, thank you. What is the meaning of gender identity and gender?
Gender identity, if you'd like me to refer under the Sex Discrimination Act.
What's that? Could you read it out, please?
Yes, certainly.
Senator Roberts, I'm going to share the call after this too.
Okay, I'll have another set later.
I'll allow Commissioner Cody to respond to your question, then I'm going to share the call.
Yeah. Could I come back to me later?
Gender identity within the Sex Discrimination Act means the gender-related identity, appearance or mannerisms or other gender-related characteristics of person, whether by way of medical intervention or not, with or without regard to the person's designated sex at birth.
Thank you. The key word would seem to be or. I'm not a lawyer, I'm not a judge, but that would seem to be the key word, and it's used twice in the definition, separating the three characteristics.
Thank you.
So you don't
Senator
have to
Roberts.
have a gender. You can be whatever you want to be if you identify as such or if you dress as such. Thank you very much.
Thank you, Senator Roberts. Senator Cash.
Can I just build on that, because that was exactly the question that I put to you, Commissioner. I said to you that in terms of the definition of gender identity, it is gender-related identity, appearance or mannerisms or other gender-related characteristics. I then put to you, so at law, to satisfy being a transgender woman, a man can put on a dress and call himself a woman. You said to me, no, all three elements have to be satisfied. I'm going to put to you that at law you are wrong. And I'm going to give you a chance to now correct your evidence.
I'm sorry, Senator Cash, I'm having difficulty following the question that you're putting to me.
I said to you, one of those elements needs to be satisfied. You said to me, no, all three of those elements need to be satisfied. That was in the context of me saying to you, to be a transgender woman, does a man merely have to put on a dress and say he is a woman? And you said to me, no, that is not enough. All three of those elements need to be satisfied. That is not correct at law, is it?
What I was referring to, Senator, was the three aspects that define what is sex, what the court looks at to decide sex and what is a person's sex within the law. In terms of gender identity, then the definition that I've just read out is the relevant definition to apply.
Yes, but there
so
is...
a gender appearance
is
would also be one of the
aspect of it. So a man can put on a dress, which is the appearance, a gender-related appearance. The dress is associated with femininity. He does not have to do anything else other than his appearance is now that of a woman, a transgender woman. Is that correct?
It depends for which purposes, but yes, a gender-related appearance
Thank you. I just
is one
that's
aspect.
exactly what Senator Roberts was pointing out. It is or, not and. So going back to my original question to you at law, what is the test for a biological man to be able at law, because the good news today is we've moved from previous estimates hearings, which I haven't participated in but I've watched. Today we are at least focused on the law, because we now have a case that is interpreted the law. So all of our answers are now guided by the law as it currently stands, unless, as you have just acknowledged to Senator Roberts, that law is indeed changed by the Parliament to recognise biological reality, as it currently doesn't. So what is the test under that section for a biological man to be considered a woman?
Are you asking what is the test for someone to be recognised as a transgender woman?
Correct. Does he have to just put on a dress? And the answer is actually yes.
For the gender-related appearance?
Yes, absolutely. Correct. And you can be, therefore, a transgender woman for the purposes of the Act. So any bloke can put on a dress, walk into a girl's change room, and I'm allowed to be there because I actually identify as a woman. That is correct, isn't it? There is no test other than I think I am, I put on a dress and I look like one. Do I require surgery?
Okay, can I?
No, Senator, you don't require surgery.
Exactly.
But the test that is required at each state and territory is different.
I'm talking at a Commonwealth level. We are here as the Commonwealth Parliament looking at the Sex Discrimination Act and the recent court decision in relation to the Giggle for Girls app and the person who tried to join and was, on the basis of their appearance, told that they could not because they were not a biological woman. So can I ask you this? A man says he is a woman. Is he a woman for the purposes of the law? You appeared amicus curiae in your evidence to Senator Roberts to assist the court in the construction of these sections of the Sex Discrimination Act, and in particular evidence was in relation to what is a woman. So I am now asking you, if a man says he is a woman, is he a woman for the purposes of the Sex Discrimination Act?
And I refer to my earlier answer, the 3 aspects which define someone's sex under the Sex Discrimination Act.
But you only need one element.
No, Senator, that's incorrect. You're confusing gender identity with sex.
So gender identity...
Sorry, Senator Cash, can we let Commissioner Cody answer your question, please?
Sex has 3 aspects. It includes biology and physical characteristics.
Yes.
It includes how the person presents themselves.
Yes.
And how they are recognised socially.
But for gender identity...
Sorry, Senator, I hadn't quite finished my answer.
Gender identity?
Senator Cash, please.
I was trying to work out how to go to gender identity.
Yeah, I think she was just indicating she was going to gender identity, so if you let her finish.
Gender identity can include gender appearance.
Yes.
So some aspect that relates to gender.
Correct. So if a man puts on a dress and says he's a woman, he is now identifying as a woman. That is correct.
That is one aspect of gender appearance, is how someone dresses.
Thank you very much. Your commission, I understand, rejected the Lesbian Action Group's exemption application because for a lesbian-only space, a biologically born woman's space. I understand because the Commission was not persuaded that it was appropriate to make distinctions between women based on their biological sex at birth and transgender women. Is that correct?
That is correct. We went through the process that we follow for deciding on exemptions, which is outlined in our guidelines, sought public consultation, received a range of submissions and then made a decision.
Do you think that most Australians would find it utterly extraordinary that lesbians are unable to have lesbian-only groups?
The decision was to allow lesbians to enable them to have separate spaces. That wasn't what they were seeking. What they were seeking, the Lesbian Action Group, was to exclude transgender women who also may be lesbians. So it wasn't a lesbian-only space.
The lesbians were seeking, let's put it in plain English, the biological lesbians wanted to meet as biological lesbians. Under the Sex Discrimination Act, they are able to apply for an exemption. They acknowledge they will be excluding transgender women. That is the reason they are applying for the exemption, because the law is so crazy that lesbians have to do this. And your Commission said no. Was it a unanimous decision of the Commission?
It was. I'd have to take that on notice.
Or perhaps
Senator.
there are commissioners here. Did you vote yes to not giving the lesbians an exemption?
To which, sorry, to me or to
yes, did
the
you
other
vote yes or no? Were the lesbians allowed an exemption under you or not?
No.
No. President, were the lesbians allowed an exemption under you or not?
So I think it's important to clarify. To answer directly your question.
Yeah, I don't need a direct answer.
No, this happened before I assumed this office. So.
Understood. We don't need your opinion then. Was there any other commissioner currently here who voted on the application for the lesbians to have biological lesbian-only spaces? Is that the Human Rights Commissioner? Can I ask Human Rights Commissioner, what was your vote?
Sorry, Commissioner, you will need to come to the table.
I can't hear you, sorry.
No, I'm sorry, there's room down the other end of the table. Yeah. Commissioner Cody, you're welcome to. There's seats down this end.
Sorry, Commissioner, my question is, and I think this, the Racial Discrimination Commissioner, I'm not sure if he was involved in this decision, were you part of the decision in relation to the Lesbian Action Group applying as it rightly can at law, because it understands the law as it stands, does not allow biological-only lesbians to actually meet in their own spaces? Did you vote on that decision?
For the purposes of the record, the Human Rights Commissioner from the Australian Human Rights Commission, yes, I did, Senator.
And can I ask you, what was your position on this?
It was not a unanimous decision and I took a different view.
So when you say you took a different view, you supported the Lesbian Action Group.
Yes.
Can I ask on what basis, given it's a decision that it's an exemption is there because you're overriding the law, on what basis did you determine that the Lesbian Action Group should be entitled, as I believe they should be, their exemption?
It was after reviewing the materials and on my consideration of the guidelines that guide our decision-making in that process.
So how did the guidelines therefore enable you to make a different decision to the Sex Discrimination Commissioner?
Well, I think the guidelines allow for different decisions to be reached based on the different way that people balance rights in terms of rights to rights relating to sex-based discrimination, gender discrimination and gender identity discrimination, and how those are applied through the Sex Discrimination Act and the exemption process.
And can I ask, how did you balance those rights to end up saying that, yes, in these circumstances, the Lesbian Action Group have done the right thing, they've applied for an exemption, and I think the Lesbian Action Group should get their exemption? How did you undertake that balancing act?
Well, again, I don't think it's appropriate for us to go through the internal decision-making process, other than to say, in terms of the decision that is public, the exemption decision, I reached a different view to my colleagues on the Commission about how those rights should be balanced.
So for you, lesbians should be able to meet in private?
Yes.
Okay, thank you very much. I do appreciate. The Racial Discrimination Commissioner. Sorry, Sarah, I will ask you to come up, so...
Is this what down here, Commissioner?
Sorry, I just had to go back. Thanks.
So, Commissioner, were you involved in the application by the Lesbian Action Group for the exemption?
I don't believe so. I think it was before my time.
Oh, it was before your time. That's fine. So there's only two at the table. One voted for, one voted against. Thank you very much.
Just checking the records, Senator, to give you accurate information about who was present at the Commission at the time.
Sorry, Senator, just to be clear, I don't believe so, but I guess checking the records.
Thank you very much. I appreciate that.
Yeah. Senator, I'm advised that Commissioner Finlay was the only Commissioner at the time who didn't agree with the Commission's decision.
Thank you. And Commissioner Cody, can I ask, what is now the status of the Lesbian Action Group's exemption? When did they apply for it? Recently? Or 3 years ago?
I believe it was in 2023.
Yeah, 2023. Have they yet got the exemption to meet as biological-only lesbians?
The decision about whether or not to grant them an exemption has been returned to the Administrative Review Tribunal to be redecided.
Right, because the Lesbian Action Group didn't agree with your decision, is that correct? So they appealed it. They then had to appeal the next decision off to a court, and the court has now remitted it back to the tribunal. Is that correct for decision?
That's correct, Senator.
Okay. But just to confirm, you do not believe that biological lesbians should be entitled to meet in their own spaces?
Not as a blanket. I retract that. In this situation, the exemption was not granted.
Okay.
There may be some situations where there is room for that decision, but it would be decided on within the guidelines and in a case-by-case decision.
Okay.
So, Senator,
can
I just clarify, because there's some really important facts here that need to be understood in understanding this application. And for the record, I support the Commission's decision. I've read that decision and I think it's properly decided. The members of the Lesbian Action Group are able to meet as a membership organisation or a voluntary organisation and determine who are members of that organisation. They don't need, there's a permanent exemption for that in the Sex Discrimination Act. They're allowed to meet in private. There's a permanent exemption.
In private, yes, but not to have public events.
My understanding of the Commission's exemption application said that under substantive equality special measures, they would be entitled to exclude men. They would be entitled to exclude heterosexual women. And so you're narrowing it down to this issue of them wanting to exclude transgender women.
That's what they've raised.
Yes, so I just wanted to clarify.
I'm a little confused at this.
Have it on the record that
I'm very confused. They want to exclude biological men.
Can we just allow Mr de Kretser to please just complete his answer without interruption? It would greatly assist the committee.
My concern is that this discussion will leave people with the impression that the Lesbian Action Group was unable to exclude men and heterosexual women from their application to hold these events. And that's just what I wanted to clarify for the record.
Okay, but they want to be able to exclude biological men.
Transgender women.
Correct.
Yes. So I just wanted to clarify that is the issue in contention here.
That's
because
exactly
when
right.
I've been following the media commentary around the protection of women's only spaces, I think it ignores a lot of the exemptions that exist currently as permanent exemptions or as special measures under the Sex Discrimination Act. Senator Roberts referred to the competitive sport example. We published guidelines in 2019 referring to that exemption and working with sporting bodies in Australia to help them to apply that exemption to ensure that there are fair and equitable provisions and policies and leadership around
With all
sporting
due respect,
codes.
President, as a biological woman, I'm insulted, utterly insulted by that explanation, that you think that I and the other biological women here need to apply for an exemption so that we can say no to having our own space to biological men. That is an insult to every biological woman, quite frankly. But the good news is what we've established today is we're talking about the law, and the law as it currently stands is an ass, and we will change it so we do not have to have these conversations again. Sex is biological reality. The fact that the Lesbian Action Group have spent 3 years now just trying to do what everyday mum and dads would think is perfectly normal. Quite frankly, it's no reflection on you. You are actually implementing the law, but it is a reflection, quite frankly, on the law, and the law has to change.
Thank you, Senator Cash. I'll take that as a statement. I understand Senator Blythe has one clarifying question that she wants to ask before I go to
just
Senator
while we've got
Shoebridge.
the Human Rights Commissioner up at the table. So there is this, and I do echo Senator Cash's comments, but it's clear that biology has been removed from the definition of sex for the purposes. For the purposes of the Act. So when we don't have sex-based rights grounded in biological reality, and what we've got now is we've got conflicts where there are, say we use the Lesbian Action Group as an example of women who want to get together, so they are biological women, and then you've got the rights of those who want to identify, so based on gender identity. Those two are clashing in terms of rights. Both are clashing. Whose rights take precedence in that? Because when you have a clash of those, one has to come above the other. How are you making that decision? And I'm referring to the decision that you've made about not allowing the exemption to happen. It seems as though the Human Rights Commissioner is balancing that up very differently to everyone else. So when you have this clash of rights, why is it that biological women in reality are being pushed down the bottom and their rights, their human rights, seem less important than a bloke who wants to identify as a woman?
It's a transgender
Thank you.
How do you justify that?
transgender woman.
Thank you, Senator Faruqi. Just indicating that I am going to share the call after the response to this question.
Sorry,
Senator Blythe. I was just going to say, can you clarify who you were asking the question of?
Perhaps the best way I can approach this is to note that when you talk about conflicting rights, there's one thing that really unites all of the groups that you're talking about, and there's a common humanity attached to this. So the framework that the Human Rights Commission takes, and even where there might be differences of opinion amongst individual commissioners about individual exemption applications, we're ultimately wanting to apply a human rights framework. And when I look at that decision, and I know that when my commissioner colleagues look at those types of decisions, we recognise that whether you're talking about lesbians or transgender women, you're talking about groups of people who've been subjected to hatred and discrimination and who do need the protection of the law. So we need to find a way of applying these provisions in ways that recognise the humanity and the rights of all of the people that we're talking about. And when you look at the decision in the judgment of Giggle and Tickle, it really does set out what the law is now and what we can reflect on how that works in practice to ensure all human rights are protected.
As a female, I feel like my human rights are being
Thank you,
infringed on.
Commissioner May. I will now go to Senator Shoebridge.
Thanks, Chair. Thanks, everyone, for the work you do. I was going to ask some questions about the Equal Identities Report, Doctor. And I just for the record, I just want to commend you on the work and the way in which it starts and some of the language that starts. For example, the quote from Amal Leota-Lu. There are so many things I love about my gender, my creativity, my art form, my playfulness, my joy of just being fully myself. Nothing beats the truth of it. I love my whakawhine and trans identity. I wear it as a badge of honour. I think for a lot of trans people living their authentic self, it's one of those goals that's so important to us because that's all we want at the end of the day, to live and be our authentic self. Thank you for starting your report with that quote. I thought it was really powerful. But there are a series of recommendations. Can you start walking us through those recommendations?
Certainly, Senator. So the report is divided into 3 sections, which is around the experience of violence and harassment by trans and gender diverse people. We know that trans and gender diverse people experience harassment and violence at much higher levels than non-trans and gender diverse people. So there's a series of recommendations around access to housing, to crisis accommodation, for training and involvement in policing and policy development for trans and gender diverse people.
Can I just stop you there for a moment? So, for example, trans women wanting to get access to crisis accommodation, what are the specific barriers they're facing? Is it some of the intolerance, lack of understanding? What are they facing in those moments of crisis in their lives?
Sadly, they face some of the same barriers that other women face, in that there is a dire need for emergency and crisis accommodation. As you would well know, we have a housing crisis in Australia, and that extends to crisis accommodation. Yeah. There are some instances where trans women are refused access to crisis accommodation for being trans, but that's not the overwhelming experience. It's also the lack of availability of crisis accommodation more broadly.
But you have heard some instances where the intolerance and the exclusion of trans women has seen them excluded from that essential shelter.
That's correct, and also where crisis accommodation or emergency housing is run by religious organisations, then that also adds an additional layer of allowed discrimination. Yeah.
No, I stopped you, sorry.
So one of the other areas, the recommendations, which is overarching, is the need for trans and gender diverse people and LGBTQI plus community more broadly to be involved in government program and policy development. So that's where there are advisory groups, that there are representation within those advisory groups to ensure that the perspectives and experiences of those communities are included.
Like the experience and perspective of Amawa.
Exactly.
Yeah.
And the full range, as we know, there is diversity in all levels, and so ensuring that that diversity within the trans and gender diverse community is represented.
How culturally diverse is the trans community in particular? When you were talking, you had a series, I think more than 80 people contributed. How culturally diverse is it and complex?
There is strong diversity within the trans and gender diverse community. We know that within our First Nations community, there is a strong trans and gender diverse section, some who would refer themselves as sister girls or brother boys. Yeah. We also know that in terms of culturally, racially marginalised groups, that they are certainly there are also trans communities. Within Australia, we have people seeking asylum or protection on the basis of their trans or gender diverse status. And we know also recently at the Women Deliver conference in Melbourne, the strong representation from the Pacific, like Amata Leota-Lu, the strong representation from the Pacific of trans and gender diverse people.
Yeah, and when you're talking about ensuring representation for trans and gender diverse community, I think being mindful of that diversity in the community and those cultural strengths in the community. How does government do that? Sort of, if you're looking at appointments, you're looking at consulting. Is it a resourcing issue? Is it finding multiple opportunities for engagement? How does that work?
It's not necessarily a resourcing issue. It's actually a commitment. So, for example, the development within health of a policy for LGBTQI plus communities, which was led by Minister Jed Carney. That is not necessarily a resource requirement, but rather a commitment to include those voices and develop specific policies for those communities. Or, for example, within policing or within any department or service delivery, ensuring that the service is adequate and well matched to the communities that it is focused on.
And when we're talking about the trans and gender diverse community, they're often facing multiple exclusions, multiple barriers to getting just the basic services that perhaps you or I would take for granted. Can you talk me through that?
So one of the other issues that came up was access to healthcare, and it's not just gender-affirming healthcare, but rather healthcare more broadly. Because of fear of going to the doctor, the stigma, the discrimination that a trans or gender-diverse person may experience when they attend their GP, if their GP is not educated around the needs of those communities. So one of our recommendations was to have training within health and allied health training facilities around the experience of trans and gender diverse people in seeking healthcare.
Can you give us some idea about what, sometimes this is dealt with in abstract as some kind of culture war or some kind of, political or culture war, but in terms of the impact of people seeking, basic health care and facing those exclusions on the basis of being trans or gender diverse, what's the lived experience there, and what impact is that having on our fellow citizens' lived experience?
Well, we know that the trans and gender diverse community is a tiny percentage. It's less than 1% of the Australian community, and yet there continues to be a strong pushback or fear of that trans and gender diverse community, and that has an ongoing impact on them and their ability to participate.
I mean, you can sometimes pick up a publication like The Australian, and I'm not asking you to comment on The Australian, but I look at it and you would see pages and pages of quite often hateful rhetoric, attacking, trying to further marginalise the trans and gender diverse community. I'm not asking about what your response to that kind of media attack and that kind of hateful commentary is, but what is the trans and gender diverse community telling you about the impact on them when this hateful stuff gets so much airtime?
It has a deep impact. It makes people feel less able to be on social media where there is that ongoing abuse and violence and harassment, and it also means that people feel less able to participate in public life, and that is one of the recommendations, the importance of the participation of all parts of our community. That is one of our human rights, is the ability to participate in public life, to participate in employment, to get work, to be able to enjoy education. All of those things are our basic human rights and certainly need to be enjoyed by our trans and gender diverse community also.
To live and be our authentic self.
Correct.
Yeah. Could I ask about what practical reforms did the report identify to help improve some of that legal clarity and reduce conflict or misunderstanding? What were some of the practical reforms?
So some of the practical reforms were around ensuring that that lived experience is included in policy formation, that police are often at the front line, and so ensuring good education for police across all states and territories, and also within education facilities to ensure that teachers have a clear understanding of the needs of a range of children within them, as well as in universities and higher education.
Did you get a chance to look at some of the training materials or the other educational materials provided to police forces, for example?
No, Senator, we didn't go to that extent. Yeah. That wasn't part of the submissions that came to us.
Yeah. There's some discussion in our anti-discrimination framework about balancing different interests and balancing different competing rights, sometimes competing, sometimes parallel rights. Can you talk us through about how you see that sort of balancing those different rights when it comes to trans and gender diverse community?
So within the Sex Discrimination Act, there are two ways that substantive equality can be ensured, and that is through special measures, which, if they are for the purpose of substantive equality, means that that type of discrimination is not unlawful. There are also legislated exemptions for example, religious institutions, for single-sex accommodation, and then there's also the capacity to seek exemptions for a 5-year period. And the Commission has granted exemptions, for example, to Family Violence Prevention Legal Service for women only to be employed where those women who are seeking that service have experienced violence from men.
And sometimes we get this very reductionist concept about rights, that everybody must be treated the same for equality to be established. And it reminds me of that cartoon where you have 3 differently heighted people trying to look over a fence. You know, one can see over. If they're all treated the same, put on a flat basis, only one can see over the fence. But if they're all treated with equality, they're put on different sort of levels of a podium and they can all get equal access to what's happening over the other side of the fence. We sometimes get this really shallow and false political discussion about treating everyone the same. But of course we know the world is not equal. And you know, when we're talking about the trans and gender diverse community in particular, just rolling out the same treatment, given we know some of the structural barriers and exclusions they're already facing, that's effectively excluding and discriminating against them in practice, in my mind. But how did you confront some of that in your report?
So our report drew from 97 submissions that we received from the public and was particularly around those who had expertise, who did research in this area, who provided healthcare to trans and gender diverse people, or who worked with or provided mental health services. And so we drew from that research academic base, as well as organisations, NGOs who work directly with trans and gender diverse people, and drew that together to come up with the 3 sections of the report, as well as the recommendations that we have within it.
Thanks very much, Dr. Day. I mean, just on behalf of many of my friends and colleagues in the trans and gender community, the work you do is really important, and I hope you appreciate the sense of importance that many people place on it.
Thank you, Senator.
Thank you, Senator Shoebridge. Senator Roberts.
Thank you, Chair. Could I have at the stand Ms Katie Kiss, Aboriginal and Torres Strait Islander Social Justice Commissioner, please? Thank you for appearing. You recently made comments warning of the dangers of right-wing parties. Apparently that was after the resounding One Nation win in the Farrer by-election. Is that correct?
Thank you for the question, Senator. I'm not sure what you're referring to.
After the resounding One Nation win in the Farrer by-election, you made comments warning of the dangers of right-wing parties.
I don't recall using that language at all. Can you clarify what you're talking about?
No, that's all I've got here. What benefits for Aboriginals and Torres Strait Islanders would such a statement bring?
Senator, again, I'm not clear what you're referring to, so if you could give me some clarity around where I might have used that language. I don't recall using that language.
You didn't use it?
Not that I can recall.
Okay, thank you. What are your thoughts on the Aboriginal industry, what's referred to as the Aboriginal industry, the lawyers, the politicians, the public servants, the bureaucrats, the contractors, the academics, the activists, living off the money allocated to assist Aboriginal and Torres Strait Islanders living in poverty, despite receiving welfare payments the same as other Australians in need? The money's being allocated, but it's not getting to where it needs to be. What are your thoughts on that?
Senator Roberts, that sounds awfully lot like you're asking the Commissioner for an opinion.
Do you have an opinion?
I do have an opinion, but it's not my role to share my opinion, Senator.
Are you aware that that's happening?
Sorry. Senator, I can speak to the fact that we know that there is a fair amount of financial allocation to Aboriginal and Torres Strait Islander services and supports. I'm not sure what you're referring to in terms of welfare support, but I do have concerns about the fact that funding that's being allocated to our communities and to our organisations and to government agencies is not actually meeting the needs of our communities, and that's evident in the Closing the Gap targets.
Thank you. We're agreed. Are you aware that often more than half the grant money is eaten up by salaries and other middleman costs before getting to the people the grant was supposed to assist?
The indication of that has been presented in Productivity Commission reports and Indigenous expenditure reports. So, yes, I am aware that there is consideration of that, Senator.
Senator Roberts, I'm just struggling to see the connection between your questions and the role of Commissioner Kiss.
I think we'll see it fairly soon.
Okay.
Are you aware that most assaults upon Aboriginal women in the Northern Territory and in Western Australia are committed by Aboriginal men?
No, they're not.
I'm not sure that those statistics are necessarily accurate, Senator.
Okay.
Check your facts, Malcolm.
Why does nobody comment that the large proportion of incarcerated Aboriginal people are in jail because they committed crimes warranting a jail sentence from a magistrate or judge? That's called social justice.
I can't make comment on that, Senator. That's not a question for me.
Again, asking a Commissioner a question for her opinion.
Senator, I don't make the decisions about who goes to jail and how they're sentenced. Sorry.
Minister, when will this government learn that throwing money around is not the solution? These people are living in misery, in poverty, and throwing more money at them and throwing it to the activists and the parasites in between is not being effective. It's quite clear. Social justice includes people accepting responsibilities for their own actions and genuine help on the ground. What is your government going to do about closing the gap? Because it's widening now.
Sure, thanks for the question, Senator. I reject the language in your question. Yesterday, in front of the Finance and Public Administration Committee, the National Indigenous Agency appeared and gave a lot of evidence about all of the work that we are doing to improve outcomes and to close the gap. Our government is committed to that. The Prime Minister gave a statement to acknowledge the Closing the Gap reports, and we acknowledge that not enough is being done and more needs to be done, and that's why we've made significant investments in the budget. Thanks, and I want to thank the Commissioner for the work that she does in highlighting this, not just to governments around the country, but to everyone in the country about how important it is that we do close the gap, not just for our, not just for the people that are living in these lives right now, but for future generations of Australians.
Thank you. Could I have Dr. Cody again, please? Thank you, Ms. Kiss. I want to read a statement from the Australian newspaper. It's wrong, what we've learned today. It's wrong, so I'm not accusing you of doing this, okay? I want to ask you a follow-up question. Yet it is women from across the political spectrum who are appalled by her relentless campaign to erase sex-based rights. The problem is not you, is it? The problem is the Labor Party's 2013 law, correct?
Senator, the law is as it has been passed. My role is to advocate for gender equality, for the rights of women, and also for the rights of the LGBTQI+ community within a human rights context.
So what I've picked up today is that the problem is the law. The law is an ass. Yet many people perceive you as an activist. Does that tell you anything about the way you fulfil your role?
I'm not sure what the question is, Senator. Yeah.
Okay. The global pushback, another quote from this article, the global pushback Cody is witnessing isn't against women's rights, it's for them. Do you agree or disagree?
Senator Roberts, I think this is veering into the territory again of asking for opinions. I think Commissioner Cody, if you've got questions relating to her role and her responsibilities, feel free to ask.
Okay, I'll just finish with that the global pushback isn't against women's rights, it's for women's rights and women's safety. Thank you very much for appearing.
Thank you,
Chair.
for that statement, Senator Roberts.
Yes.
Senator Cash.
Thank you, Ms Cody. If I could also, or Commissioner Cody, continue with questions, and in particular in relation to, we're interpreting the law. The law, this is the good news about this estimate. It is literally, as Senator Roberts has just said, the changes in 2013 where the definition of male and female on the basis of biology was removed has led us to this position. In your amicus submissions in relation to the tickle and giggle matter, is it correct that you treated pregnancy protections in Section 7 as available to trans women?
No, Senator. Clearly, trans women cannot become pregnant. The discussion was around technical meaning of the pregnancy and potential pregnancy and meanings within the Sex Discrimination Act.
Okay, so you weren't advocating for pregnancy protections for trans women on the basis that they can't become pregnant?
The words relate to potential pregnancy that is included within pregnancy, and that was the discussion.
So you're not advocating that trans women can potentially become pregnant, though, are you?
No, Senator.
Yeah, because they're biological males, so you can't obviously become pregnant. So in terms, did you ask the federal court to extend pregnancy protections to transgender women?
Senator, not from my recollection.
No, that's what I'm asking. I was wanting to understand the status of your submission.
No, in the submissions
No.
we talked about the meaning of pregnancy and potential pregnancy and how that may apply.
So can I ask,
gender
how do you see that applying in the Act currently to trans women?
Trans women, if someone is who applies for a job, for example,
yes,
and it is a trans woman and she may be asked whether or not she intends to have children, and if she replies, yes, I do, and then doesn't get the job because that employer doesn't want to employ women who may be of childbearing age, then she may have been subjected to unlawful discrimination on the basis of potential pregnancy.
I'm very confused. A biological male can't become pregnant.
But the grounds of pregnancy includes potential pregnancy as well as pregnancy.
But if they can't become pregnant, how can you then become potentially pregnant?
It's about the unlawful treatment by the employer. If someone is treated unfairly on the basis of pregnancy or potential pregnancy, then that is unlawful discrimination on the basis of pregnancy.
So if a bloke came in and they said, are you going to have children? Which is the same question really, and he said, oh, yeah, maybe. Are you saying that he could also claim that ground?
If he didn't receive the job because...
But they can't get pregnant?
No, not a man who is seeking a position, then it's not going to apply to a man.
Well, they're both biological men. It makes no sense. A biological man, you stated before, a biological man can't get pregnant. Am I correct? Because if I'm not, I've got to go back to school. I seriously do, because I missed that lesson in biology. I went to a convent school. The nuns may not have told me about it. But you said a biological man can't get pregnant.
That's correct, Senator. But someone who is a trans woman may be assumed to be pregnant or to be able to be pregnant.
So what stops a man putting on a dress, walking in and claiming the protections? He's now a woman. You've admitted that.
That would be up to a court to decide whether or not it was discrimination on the basis
so it's the and with all due respect, it is the absurdity of the law yet again, which shows, again, the law does need to be changed. Because for the record, biological men, doesn't matter what way you cut it, you cannot get pregnant. And quite frankly, it is an insult to women who actually are discriminated on because they want to have children when they biologically can get pregnant. But the good news is what we're proving today is the law needs to be changed. Can I ask, what was the total cost to taxpayers of the Commission's appearance as a friend of the court in the Giggle and Tickle matter?
I'd have to take that on notice, Senator.
President, do you know? Have you had any costs yet?
Yes, we've got costs of briefing external counsel, and I will try and dig them up now. If we can move to the next question, then we can.
Would you mind? Thank you very much.
If not,
in
we
particular,
can provide them on answer.
When you're saying you're briefing external counsel, how many external counsel did you brief?
There were two. There was a senior counsel and a junior counsel.
Senior counsel and junior counsel, and all paid for by the taxpayer, obviously.
At a reduced fee.
Oh, that's fantastic news. I'd like to know their hourly rates, please, seeing as it was a reduced fee.
I think it was a capped amount, but the President will.
Oh, that would be great, please. And also, how many solicitors did you have instructing?
One solicitor.
One solicitor. Okay, what firm were they from?
They were internal to the Commission.
Oh, internal to the Commission, but you still billed them, obviously.
Correct.
Because you've got to keep on, you have to understand how much this is actually costing to go in and argue that biological men have some way of being pregnant and affording a protection under the Sex Discrimination Act. Do you have those fees yet, President?
No, not yet.
Okay, keep looking. I'm sure it's there somewhere. I've been in your position before. It's amazing what you find in estimates briefs.
We've got a team looking for us online.
Thank you very, very much. And if I could have a total cost to date of the costs incurred by the taxpayer in relation to the Tickle and Giggle case. Ms Cody, the Lesbian Action Group, the very group your office exists, I thought, to protect, but the law clearly goes further than that, had to fundraise to oppose you in the same case. They argued the opposite of your position. Does that concern you, that women arguing for the rights of biological women, while the Commission argued for the rights of biological men to have women's rights applied to them, does that concern you that they had to fundraise to fund their case while you were able to use the taxpayer's dollar?
Any legal case can be expensive, and
yes,
their decision to appeal the exemption refusal was a decision that they made and would incur costs for them.
Yes, sadly it did. That's right, and they're still 3 years on, don't have an exemption to meet as biological lesbians. At law, can I ask you, given again you're the Sex Discrimination Commissioner, but also you did present an interpretation of the Act in the Giggle v Tickle case. On International Women's Day, there was an event organised by Jackie Turner, Director of Trans Justice Project. International Women's Day for and by trans women. And my understanding is it was just that. You could say no to others. Do you need to apply for an exemption? And I want to know the legal position here. At law,
Senator Cash, you seeking to table that?
Yep, I'm happy to table it. Yep,
Yeah,
and I've got copies that can go out. At law, are trans women able to have a space only for trans women and therefore say no to biological females and males? Or do they need to apply for an exemption?
It depends whether or not it would be considered a special measure for substantive equality.
Okay, so what does the law currently say in relation to trans women and trans women only spaces? So the Lesbian Action Group, biological lesbians, it's unlawful, they've got to apply for an exemption. 3 years on, a lot of money later, they still don't have an exemption. Is this unlawful?
It depends on whether or not it would be considered a special measure.
No, so I'm asking you, you're the Sex Discrimination Commissioner, you
Senator
interpret the
Cash,
law.
If you can let...
No, I understand, but I'm asking, you interpret the law. Is that considered at law at this point in time a special measure?
It depends on the purpose of the meeting and how many people were intending to be there. I would need more information to be able to answer that question.
A forum that's publicly advertised only for trans women by trans women. It's a serious legal question in terms of the interpretation of the Sex Discrimination Act. So you have, because biological sex no longer appears in the Act, our rights are no longer recognised as biological women as such. We have to apply for an exemption as biological women in the case of the Lesbian Action Group so that we can meet in a public place, publicly, I understand the private at law, publicly as biological only lesbians. At law, I need to know, is this defined for transgender women as a special measure? Because my understanding is it is.
And as I answered your question, I don't have enough information about the event, what its purpose was and why it was being held.
I'm actually trying to understand a legal position. I'm trying to be smart here. I actually want to understand the legal position. Are there circumstances in which trans women can actually meet as trans women only without applying for an exemption?
If it is a special measure to achieve substantive equality.
Right. And on what basis would it be a special measure?
Depending on the nature of the event, which is why I can't answer your question, because I need to know more about who are the Trans Justice Project, what are their aims and what are they trying to achieve.
Their aims are to stand up for transgender women. It's pretty obvious. They're celebrating transgender women, biological men, on International Women's Day. It's actually a legal interpretation. I'm asking you at law, are they able to meet without getting the exemption?
I think the Commissioner has indicated a number of times now that to be able to give you an answer to this question that she would need further information about the event. I understand what you're trying to...
Oh, is it legal? I
understand what you're trying to do, but I think Commissioner Cody has answered a couple of times now saying she needs more information about the event. I am going to take this opportunity while I've interrupted to rotate the call, and I'm sure you'll come back to this line of questioning. Senator Faruqi.
Thanks, Chair. I have some questions for the Race Discrimination Commissioner.
Chair, while we're waiting, shall I provide the answer to Senator Cash's question about the cost?
You're welcome to do that now.
Senator Cash, at the appeal, there were two council briefed on a capped fee total basis, and it was $23,000 for both, excluding GST. For the first instance...
So that's the total figure?
Correct.
So when you say for both, it's not times two?
No.
It's for both, at $23,000?
$10,000 for one and $13,000 for the other, plus GST. And for the first instance federal court matter was $15,000.
$15,000. Were there any other costs involved?
Well, staff costs.
Was this a solicitor as well?
So we don't bill. We have an in-house legal team, and in this occasion, our in-house legal team was instructing solicitor.
Oh, sorry.
Sorry, I was just trying to.
Thank you.
Apologies.
And before I return the call to Senator Faruqi, the committee tables the document provided by Senator Cash. Senator Faruqi.
Thanks, Chair. Thanks, Commissioner, for being here. Commissioner, the National Anti-Racism Framework was a product of years of consultation, of research and engagement with the communities experiencing racism in this country. Is that correct?
Yes, it was a significant consultation. The project took nearly 3 years in total. We consulted with 300 community organisations across Australia. We consulted with 1,500 individuals, also across Australia. It's not just urban, but regional and hard-to-reach areas, including 496 Aboriginal and Torres Strait Islanders. And we commissioned significant pieces of research to support the work.
So, Commissioner, the government obviously has not funded the implementation, any measures, any recommendations that are in the National Anti-Racism Framework in this budget. The government has not formally responded to the framework. It's been 19 months since it was launched. Would you view this response as a rejection of the work that has been undertaken by the Commission and so many people over so many years that have worked on the National Anti-Racism Framework?
I don't view it as a rejection because it hasn't been rejected, but I do hope that the framework is supported and that it's endorsed and that the recommendations are funded for implementation, because we have a significant problem with racism. We find that the target keeps changing, but the problem remains, and I think that the framework provides us with a unifying way forward, a way in which we can all be treated with respect, dignity and equity.
Commissioner, has any minister in the government, from the Attorney General to the Minister for Multiculturalism or anyone else, provided you with any substantive explanation of why they have not to date supported the National Anti-Racism Framework or funded it or even responded to it?
I mean, I guess that depends on what you call substantive, but rather than, I'll answer that by telling you what I've been told. What I've been told, and it's in correspondence, I think, as well, is that it's being considered. It's being considered alongside the report from the Envoy to Combat Anti-Semitism and the Envoy to combat Islamophobia. But beyond that, no, I haven't had a further response.
Yeah, so nothing more than it is being considered.
Correct.
Have any of those ministers actually, or the Attorney General, raised any concerns with you about the National Anti-Racism Framework, about any recommendations within the Anti-Racism Framework?
No, not directly, no.
And has the Attorney General or any other minister spoken to you, or have you spoken to them about not funding the Anti-Racism Framework after the budget was announced?
Not yet, but I actually am meeting tomorrow with the Minister Ali, Minister Rowland and Minister McCarthy, and I'm going to raise the issue.
Okay. Commissioner, the final report of the Racism at Uni study was handed to the government in December 2025, am I correct?
Correct.
Have you had a response from the government to this report?
No.
No. So have you raised it? I know that you did contact because we forced this information out of the government, that you had contacted many ministers over some period of time asking about the National Anti-Racism Framework, and there was either no response or, they're considering it. Have you had any response that says we're considering this report as well, or nothing?
Well, Minister Clare indicated that the government was considering that report at the time we released it publicly, which was about a month after it was tabled with government. So it wasn't specifically in writing, but certainly he indicated that and indicated that publicly.
Do you have any idea of when there will be a response to this report? Has the government given any indication?
In discussions with Minister Clare, look, not in terms of specific timing. I think probably I'm hopeful, or I'm hoping that we get a response this year, but beyond that, I don't think that there's been any commitment to anything yet.
Do you view the recommendations in that report as needing urgent responses and attention?
Yes, that report surveyed nearly 75,000 staff and students. Nothing like that's ever been done before. I'm very grateful to all of those people that responded, and sometimes having to relive trauma to do so. And of those 75,000, over 70% said that they'd experienced racism. That's a significant issue. And if we consider higher education to be one of the most important aspects of people's lives and the way in which we progress as a country, we want to do it in a way that means people can be their whole selves and can prosper. So I think in that sense, absolutely, I think it's a matter of priority.
Commissioner, speaking on the ABC's National Forum in March this year, you said I think the problem is that to date, what we've seen is a piecemeal approach, or an approach that can pit communities against each other, which is quite different to what the Minister told me earlier, that the government has a very holistic approach to anti-racism. Is your opinion still the same? I mean, no response to the National Anti-Racism Framework, no response to the Racism at Unis report. I don't know if there's been a response to the Seen and Heard report yet. I don't think there has been. There were thousands of people, thousands of people who have, put their heart and soul and a lot of trauma into giving information for this report. To me, it seems like it's a bit of a slap in the face of all those people who have contributed so much. Do you think that at this moment, this country has a systemic approach to dealing with racism? Or is your opinion still the same as it was a few months ago?
I think that we continue to lack a cohesive whole of government, whole of society approach to tackling racism. And my comments about it being piecemeal and ad hoc were not just my opinion. That was based on research commissioned by PwC, Indigenous and the Jumbunda Institute in support of the National Anti-Racism Framework. I think that first and foremost we need a national mechanism that involves community, involves government, involves business, that can work through the recommendations of the National Anti-Racism Framework. I appreciate it's 63 recommendations, it's a lot. It can't all be done at once, but what you can do is create a mechanism that has input from the communities affected by racism, from those that will implement the solutions, those that will be impacted by the solutions, to progress through it as a means of elevating and identifying critical issues, because racism affects people in that it means that systemic racism in the migration system means that doctors are driving Uber, pharmacists are working as cleaners. It means that kids internalise a sense of deficit in schools and don't get to thrive. It means that people miss out on accommodation. It means people aren't represented. The flip side is if you implement these recommendations to progress through the work, you're having an opportunity for people to thrive and to prosper, and for our country to thrive and prosper. It means there will be enough doctors and nurses for everyone. It means that people's health outcomes will be better. It means that kids can achieve everything they want to achieve. That's the society we see as a result of implementing the National Anti-Racism Framework.
Commissioner, in a Crikey article earlier this week, Shakira Hussain, who's a researcher at the University of Melbourne, wrote that based on the interchangeability of hatred driving hate crimes and mass killings, it makes little sense to address various forms of racism in isolation rather than as part of a general anti-racism strategy. Yet, treating anti-Semitism and Islamophobia is treated as a zero-sum game. Would you agree with that analysis, and are you concerned that the government is cherry-picking or has created this hierarchy of racism where they're willing to fund some sorts of racism and not others?
I haven't read the article, so without seeing it in the context, I wouldn't want to comment on it. But I do think that we need to fix structural problems if we're going to actually eradicate the way racism manifests. Of course, people's experiences of racism have unique aspects to it. If you're targeted by anti-Semitism, that will have unique aspects to it. Islamophobia, racism towards First Peoples, and more recently, of course, we've seen a surge in racism towards people of Indian origin. But if you want to solve the problem, you have to fix the structural problem. So, for example, there is racism, a torrent of it flowing unchecked on social media. The way it might manifest on a particular person will differ, but the structural problem is that social media platforms profit from racism, and they've got rid of fact checkers, and there isn't any mechanism to control it. I could give you the same sort of examples in other areas, whether it be workplaces or health or the justice system, where the way in which the racism target impacts on someone might have unique aspects to it, but fundamentally there will be a structural problem that needs to be fixed. And that's what our National Anti-Racism Framework was trying to do. It was trying to fix those structural problems so that everyone could live with dignity, equity and respect.
Commissioner, you've made a submission and also some recommendations to the Royal Commission into anti-Semitism and social cohesion. And in one of your recommendations, you call for the government to fund programs and workshops to help communities have safe conversations about Israel and Gaza. Reading your submission, it appears to recognize that communities need support to engage on Israel and Gaza rather than censorship and suppression. Are you trying to, I'm trying to figure out what you're trying to say there, and is my interpretation that attempts to silence protest, to silence academics, to silence writers, to silence artists, and the conflation of criticism of Israel with anti-Semitism risks deepening racism, fear, and social division instead of addressing it?
Senator, so that was an interim submission. There's still going to be a further final submission, which we will do by the 14th of June, which is the deadline. And I just want to note that that specific recommendation actually came out of our consultations in the Seen and Heard project. And for those that don't know, that was a project where we sat with Jewish, Palestinian, Muslim and Arab communities, as Senator Green pointed out earlier, based on a grant from the government. And I think what came through, well, many things came through, and I encourage people to read the report, but one of the things was that often I went to many of those consultations and you could sit in any number of them and you'd hear something so similar, despite the community being a different one. And one of the similar things we heard was creating spaces for difficult conversations, because these are difficult conversations. The same themes and topics are being explored by Commissioner Bell in the Royal Commission into Anti-Semitism and Social Cohesion, because the difficulty often arises from the friction between expressions of self-determination and racism. And I wouldn't want to say it's a particular issue. I just think it's actually about building racial literacy as a whole, and understanding people's experiences, including in terms of, I think important to note here, First Peoples and the need for self-determination and sovereignty for First Peoples on this continent. So that's one of the pillars that supports the National Anti-Racism Framework, building that racial literacy.
Yeah, Commissioner, you said earlier about creating a mechanism to implement the National Anti-Racism Framework. Were you referring in particular to the task force that is one of the recommendations of the NAF?
Correct, Senator. That's the primary recommendation, effectively. You can call it a task force, you can call it a working group, you can call it whatever you want, but it's a mechanism, a collaborative mechanism by which you can usefully work through the recommendations.
Thank you, Commissioner. Thanks, Chair.
Thank you, Senator Faruqi. Before we go back to Senator Cash, we are going to take the opportunity to do a quick 5-minute suspension and return at 5:02. We will resume with the Human Rights Commission and return to questions with Senator Cash.
Thank you very much, Chair. Commissioner Cody, if we continue with our analysis post the Tickle and Giggle decision, just in terms of, you were speaking prior to the break of special measures, so a special measure intended to achieve gender equality. That's not applied for, is it? You don't need to, do you have to apply for a special measure?
No.
No. You just argue it is a special measure.
Correct.
If you're actually challenged.
Correct.
So a person may take a special measure for the purposes of achieving substantive equality between men and women, or people who have different sexual orientations, or people who have different gender identities. So just on the basis of the Jackie Turner International Women's Day for and by trans women only event, which one would they fit into if they were arguing we said no to a biological woman and it's a special measure? How do they fit into that?
So I'd correct my previous answer, Senator, in that event, I've now learnt, was open to all women and also to all men, and both
so
men and women went to that event.
If, though it was just to work through the legal position, if they wanted a trans women only event, and you said that would be a special measure, can I just ask, how do you fit into one of the three, obviously not men and women, how do you actually legally fit into it?
So it may be it is for the purpose of achieving substantive equality.
Yes.
So that issue would be depending on which group of trans women, for example, what the nature of the event is, how long it was for, and what the purpose of it was.
And that only comes up in the event that it's challenged?
Correct.
And then they would argue it is a special measure?
That's correct.
Understood, right. Can I just go, though, the Lesbian Action Group, in saying no to transgender women, they can't argue it's a special measure?
They could argue that it's a special measure, but they had sought an exemption. So the court case was around their exemption.
The exemption. How would they argue it's a special measure that biological women want to exclude trans women who are biological men? How do you fit legally within that?
They would have to demonstrate that it was to achieve the substantive equality between lesbians and I'd have to look at it, Senator. I find it difficult to do that mental...
no, that's okay. I was just trying to get an idea of how the special measures actually work to understand the law as it stands. So I'll continue on. So gender identity is a protected attribute under the Sex Discrimination Act. Is biological sex a protected attribute?
Sex is an inclusive term.
No,
it draws...
biological. No, I'm asking you, is biological sex a protected attribute?
So to answer your question, sex is an inclusive term. It includes all women. That includes what you're referring to as biological women. It includes First Nations women, women with disability, trans women, and those who are intersex, also who may identify as women.
Prior to 2013, what was the meaning of biological sex, or man and women, in the Act?
There was a definition of woman in the Act. I couldn't give you the
And it was a
words of
biological definition?
I don't remember the terms of it,
Oh,
Senator
well,
Cash.
we took out the definition of man and women in biology in 2013. So that's currently what's missing from the Act. Is that correct, that standalone definition of man and woman?
No, Senator. The current term, the Sex Discrimination Act has multiple objects, and it reflects a range of human rights obligations that Australia has under the civil and political rights, economic, social, cultural rights, as well as CEDAW. And CEDAW has been interpreted to have an inclusive definition of women, and it includes trans women, and that is why the Act is now inclusive of our human rights obligations under that range of instruments.
So how would you ensure that biological sex as a stand-alone is a protected attribute? Stand-alone, only confined to biological sex. Would you have to amend the Sex Discrimination Act?
That would be up to Parliament to
decide.
decide.
I'm just asking from the legal position.
I can't give you an opinion on that because that would be counter to our obligations under human rights law.
I don't know how answering a question about whether or not changing an act is contrary to your obligations at human rights law. Seriously.
Because women is defined in an inclusive way under the Convention for the Elimination of Discrimination
that.
Against
That's
Women.
the problem at the moment. That's what we're saying. The law is actually currently the problem. So we're saying if you included back a definition of biological sex as a standalone, is that how you can actually get it to be the protected attribute?
I think the Commissioner's answered your question, Senator Cash.
So can I go to some real-world consequences now of the tickle and giggle just to understand it from a legal perspective? Because I want to understand exactly how the law flowing from this decision now applies. So your Commission's, I think it's the Trans Explainer, states that excluding a trans woman from services or spaces for women would likely be considered discrimination. Is that correct?
On the basis of gender identity.
Yes. So under that guidance, can a women's refuge turn away a biological male who identifies as a woman on the legal basis?
It depends on the grounds on which they are excluding I think what you're referring to is a trans woman, what I would refer to as a trans woman, whether a refuge can exclude
a biological male who identifies as a woman, yes.
It would have to be generally what the practice is in those situations is that they will make a decision on the basis of who's currently in the refuge, what their concerns are, and the particular safety needs of both those who are within the refuge as well as the safety needs of the person who's seeking refuge.
But you've said it would be likely to be considered discrimination.
I don't think that's what I answered, Senator.
So I'm saying, can a women's refuge turn away a biological male who identifies as a woman?
It would depend. It would be a case-by-case decision. If the refuge is for example, women who've experienced domestic or family violence from men, then it may be a legitimate decision to turn away a trans woman. It would depend on the circumstances and the needs of the individuals who are actually in the refuge at the time.
If they turned away the biological man who identifies as a woman, a claim can still be brought, correct? For discrimination?
I'm sorry, Senator, you're going to have to be a bit more specific. A claim by who?
The person who was turned away, that they were discriminated against according to your Trans Explainer.
She may be able to make a complaint,
yes.
And depending on the circumstances
what would
as to whether or not
argue?
there would be a finding of discrimination.
What do the service then argue?
It would be up to the service to make its argument as to why they had made that decision and the needs of the other participants or the other people who were staying in the refuge at the time.
And so where does that legally fit in the Act?
Well, if someone made a complaint, then that would be their response to the complaint.
But what's the legal basis for it? I have to have a legal defence. What's my defence under the Act?
That it's not unlawful discrimination because it's for the purpose of it's a special measure, so it's for the purpose of achieving substantive equality of women.
Okay. Could I just turn to another issue? Did you send an email to the AHRC Chief Executive Leanne Smith asking whether GANRI could have any role in influencing the reappointment of UN Special Rapporteur Reem Al-Salem?
Senator, I did send an email seeking advice about the appointment processes for special measures.
Right. What was the date of the email?
I'd have to take that on notice, Senator.
Can you also table a copy of that email with the Senate committee?
Yes, Senator.
Thank you. My understanding is Ms Al-Salem sought to intervene in Tickle and Giggle to argue that women means biological female. Is that correct?
I would have to refresh my memory on the grounds or the submissions or the grounds on which the Special Rapporteur sought to intervene.
Can I just confirm, is your evidence, did you in any way seek to influence the reappointment of the UN Special Rapporteur?
No, Senator, I did not.
Okay, and that is your evidence?
That is my evidence.
Okay. And you are aware of UN Human Rights Council Resolution 5.2, which provides that mandate holders must carry out their functions free from undue influence or intimidation?
Yes, Senator, I am now.
Excellent, good. President, were you aware of the email that the Sex Discrimination Commissioner sent?
Not before it was sent.
Have you seen it?
I don't believe so.
No.
But it came up in the last round of estimates. There was questions about it.
So you weren't aware of it before then, though?
No.
Okay. And you will take it on notice to provide a copy of that to the committee?
Yes, Senator.
Thank you very much. Did you want to ask something?
Yeah, I've got
Yep, go.
Sorry, are we...
Oh, yes, sorry.
Just wants to share the call.
Chair, do you mind if I share?
Senator Henderson.
Chair, thank you. Good afternoon. Look, I just wanted to ask, first of all, about this International Women's Day for and by trans women event. So you've given evidence, Ms Cody, that this was an event for all women, including trans women.
The event was open to all women and also to men, to all people.
Well, I've just done a check. Are you, and you may not be aware of this, but Sal Grover enrolled to attend this event, and then she was excluded from this event. So given that she was excluded, and I understand that you're taking me in good faith in terms of what I'm conveying to you, would that be a prima facie case of discrimination?
It depends on the grounds on which they excluded Sal Grover.
Well, Sal Grover is a woman. So what other basis could they have excluded Sal Grover from attending this event?
You would have to ask the organisers of the event, but it does not, on its face, necessarily mean that she was discriminated against.
And what,
Senator Henderson, I feel like there's been a bit of a theme of asking the Commissioner for her view on a number of matters this afternoon, where she's indicated that decisions often require, or her response often requires, more information and consideration, and this is one of the ones that sound awfully similar to what Senator Cash was prosecuting earlier.
I appreciate the point you're raising, Chair, and I do appreciate that. And I'm very happy to furnish you, Ms Cody, with more information in relation to this matter that I've raised. Can I turn to the Lesbian Action Group action? And I haven't been in this committee for the whole time. So can I ask about the costs incurred by the Commission to prosecute the case?
This has been covered.
Oh, it has been covered.
Not for the Lesbian Action Group.
Sorry.
It was for the Giggle and
sorry.
Okay, so I'm asking about the Lesbian Action Group.
Sorry, Senator Henderson.
You have the Lesbian Action Group costs.
So this was an action where the Lesbian Action Group sought to have their own event to protect the right for lesbians to gather as women determined by their own biological sex, and the Australian Human Rights Commission was found to have made an improper decision.
That's not correct.
Well, I'm paraphrasing.
Could I clarify?
I'm paraphrasing. If I could just finish my question.
Sure.
What was the costs incurred by the Commission in this case?
For the federal court proceeding?
Well, no, for all of the proceedings, if you could take me through each one.
I only have the costs at the moment for the federal court proceeding, which was $11,332 for senior counsel, $5,500 for junior counsel. I will seek instructions about the Administrative Review Tribunal.
And Commissioner, you wanted to add something in relation to this?
I have the costs for the tribunal.
Sorry?
I've got the cost for the
Thank
tribunal
you.
proceeding, which was $7,700 for counsel fees and $3,000 for independent witnesses, expert witnesses. And I was just clarifying that the federal court was an appeal from the tribunal decision. So the federal court's decision was that the tribunal applied the wrong test in making its decision. So just to clarify that. And it's remitted to the tribunal.
And so the Commission also sought costs. Did you seek any costs against the Lesbian Action Group at all?
No, we have not sought costs because they won at the federal court and they are seeking costs from the Commission.
And have you reached an agreement in relation to those costs?
No, not yet. It's in negotiation.
Yeah. I mean, I just want to ask the broader question, why when a group of lesbian women wanted to hold their own event, in effect, was this opposed by the Commission? What about the human rights of lesbian women to gather together without biological men identifying as women as part of their group?
So we applied our guidelines that we use for deciding whether or not an exemption should be granted. We sought submissions from various members of the public and then made that decision.
But Ms Cody, what I don't understand is the rights of women and girls have been effectively expunged from the Sex Discrimination Act as a result of the full federal court decision and the stand of the Human Rights Commission. The rights of lesbian women seem to be of no interest to the Human Rights Commission, and yet I can sit here and say I identify as a man, even though I'm a woman, and in your world, you accept the fact that I'm a man. I mean, it is insane what is happening. And I think my own personal view is that the Australian Human Rights Commission has lost complete sight of the human rights of women and girls and men and boys in certain circumstances. And lesbian women and gay men, why are they not entitled to the same human rights? You fought tooth and nail against the Lesbian Action Group. It's wrong.
I would note, Senator, that I work day in and day out for the rights of women and girls and also for men to be able to participate in caring responsibilities. Currently, I have a project that I'm leading into military sexual trauma in the Defence Forces, which will specifically deal with the experience of violence against women and girls, particularly in the Defence Services. Additionally, I'm running a project on pregnancy and family responsibilities, looking at the experience of pregnancy and family responsibility discrimination and looking at some of the barriers that men face in dealing with their caring responsibilities and their willingness to and desire to take on some of those care responsibilities. I'm also active in prosecuting the positive duty on employers, looking at how workplace sexual harassment is a serious and ongoing issue for women and girls in our workforce. I am also involved in documenting the experience of workplace sexual harassment through the Speaking From Experience project. So I utterly reject your assertion that the Human Rights Commission is not advocating for the rights of women and girls.
Well, the situation now is your stand in the Tickle and Giggle case, I would put to you as appalling, because women and girls and men and women, as biological women and girls, we no longer have any rights. And I have no issue about gender identity being a protected attribute in the Act. I've no issue at all, because there are many circumstances where we do not want to see people, gender identity discrimination in certain circumstances. But where we now have a situation in this country where, prosecuted by the Australian Human Rights Commission, we no longer matter. And can I tell you what I'll tell you what the practical effect is, and I'd like you to answer this, because Senator Cash raised this issue about women's refuges. There is a women's refuge, a domestic violence refuge, and I'm not going to say where it is because I don't want to in any way identify them. Men are prohibited to enter the refuge after 10 o'clock for the safety of the women who are residing there with their children. So after 10 o'clock, men are prohibited. So what is happening at this refuge is men are turning up at 9:45, often perpetrators, and they are saying, I identify as a woman and you are compelled to let me in. And under the current state of the law, this refuge has no choice but to let these men in. With this absolute nonsense, which is putting at risk the safety of women who are fleeing family violence and their children. So what do you say to that? How can women have safety in a domestic violence refuge when men are fronting up and saying, I identify as a woman, let me in?
The safety of women and girls is absolutely vitally important in our society.
Well, you are
Senator
compromising
Henderson, no. Senator Henderson and Senator Cash. We've had a very orderly day today. We will not be changing how we've been working throughout the day, which is question, answers, and I have noticed a trend in very long opening remarks before getting to a question, which I would like to make very succinct.
Thanks, Chair.
I would ask you to refrain from making long opening statements before getting to your question. Commissioner Cody.
The safety of women and girls is of paramount importance. We know the widespread experience of domestic and family violence by women and girls. I would suggest in that situation that the logical thing to do would be to ring the police. If someone is trying to harm someone within the refuge, then the best response is to call the police. If there is grounds for someone to be arrested, then they will be removed from that refuge.
No, the issue I'm raising, Commissioner Cody, is that men are prohibited from entering this particular refuge after 10 o'clock. They're fronting up 9:45 at night and saying, I identify as a woman, you are bound to let me in. And the law is now such, compounded by the stance of the Australian Human Rights Commission, that women cannot even feel safe under those circumstances in a domestic violence refuge.
I disagree, Senator. I've made my response.
I was also just wondering if there was a question rather than a statement.
So I guess the question is, what do women do in those circumstances when men who effectively are lying, they're just concocting some convenient, I identify as a woman at 9:45 at night so they can get into a women's refuge. I mean, that is just completely insane, Commissioner Cody. And I would put to you that the stance of the Human Rights Commission, and I include you, Commissioner, in this, has compounded the safety issues that women and children are now facing in this country.
The focus is harmful behaviour, Senator. And when there is harmful behaviour, such as someone trying to come into a refuge where people are seeking safety, then the best response is to deal with the harmful behaviour, and that is ring the police. If it is a criminal offence, they will be charged.
But there's no legal basis. The problem, what's the criminal offence?
Because they are being excluded. They shouldn't, if they're not accepted after 10 p.m. at night, then that's the grounds on which they could be excluded.
In your definition of women, a man has to be included and allowed in. That is the absurdity of this law in this country, which is being prosecuted by the Human Rights Commission. And I've had confidential discussions with the CEO of this refuge. She is beside herself. She has no legal basis to exclude these men because of the way men have now been redefined in our law.
Senator, I was just going to offer to speak to that particular refuge if they would like our assistance to manage that situation.
Do you know what?
How do you assist them? A bloke turns up and says he's a woman.
Mr de Kretzer, I think you've done enormous harm to the progress for women and girls in this country by your stance.
Senator Henderson, I don't think...
So I don't believe
those reflections on the President or Commissioners sitting at the table is a fair reflection. I think you've heard from particularly Senator Henderson, I'm speaking, I'm not asking for your interjections, is an unfair reflection on people sitting at the table. I think they've articulated to you the work that is done. Now the President has offered to speak directly to the refuge if they have concerns in the ways that you've raised. I don't think that is an unreasonable offer from the President, given the serious nature of the concerns that you've raised. But I would ask you to refrain from making reflections on the people who are at the table. Senator Cash.
Can I just follow up? We're talking about the Lesbian Action Group. Just to confirm the sequence of events, they applied to the AHRC under Section 44 of the SDA for a temporary exclusion to hold a lesbian-born female event. My understanding was it for International Lesbian Day?
I believe that's correct,
Yep.
Senator.
So essentially seeking permission to exclude biological males who identify as women from a female-only lesbian gathering. You have the power under Section 44 to grant temporary exemptions from certain provisions of the Act for up to 5 years at a time. That is correct?
That is correct, Senator.
Okay. Subject to specified terms and conditions, and you might put those terms and conditions in. Now, my understanding also is that you have guidelines governing, and I think the Human Rights Commissioner referred to this, you have guidelines governing how you exercise that discretion. Is that correct?
That's correct.
Okay. The AHRC reviews the exemption. So your decision prohibited the group from staging the planned event. Did you conclude in rejecting the exemption or the application that sex is non-binary and changeable?
I would have to refer to the decision itself, Senator, to answer that
Well,
question.
I put to you that's what you did actually find. Sex is non-binary and changeable, which is the evidence that you've consistently given at estimates, including that Senator Henderson here could actually be a bloke as she sits there right now, which is fine. That's her decision. The Lesbian Action Group appealed to the Administrative Review Tribunal and lost, correct? They then took the matter to the Federal Court, is that correct?
That's correct.
Did you appear in the Federal Court? The Australian Human Rights Commission?
Yes,
you did.
Senator.
Okay. Was that by choice? No, you'd be a party to it.
Correct.
So you're a party, right. So my understanding is Justice Mashinsky declared that the AHRC guidelines are deficient. Is that correct?
That is correct. Right. He specifically referred to the need to take into account the indivisibility and universality of human rights in any decision relating to exemptions.
And the principle that every person is free and equal in dignity with rights?
Correct.
Was he saying that the Commission's guidelines for assessing the temporary exemption applications had been written and applied in a way that effectively transgender identity becomes a superior right and can't be balanced against or overridden by sex-based rights? So in other words, the guidelines did not properly account for the fact that sex-based rights and gender identity rights are both protected attributes under the Act and that neither should automatically trump the other?
No, that's not the decision as it was written, Senator.
Okay. What was your understanding? Because he told you to update the guidelines, did he?
To take into account the Australian Human Rights Commission Act and to include the indivisibility and universality of human rights within our decision.
Have they been updated?
I understand that they're in the process of being updated.
When was this decision handed down?
In April of this year.
Okay, and they are in the position of being updated. In terms of the decision being remitted back to the Administrative Review Tribunal, what's the process now?
The Administrative Review Tribunal will sit and make a decision about the exemption application.
Right, and do you participate in that? Or do they just now look at the papers?
I'm not sure of the answer of that, Senator. I think that we would appear, but I'd have to take that on notice, Senator.
Do you know, President, does the Commission appear?
The usual process is, as I understand it, there's you want a contradictor in those.
Yes.
Yes.
So you would have.
Yeah, my understanding is we would normally take that role.
Okay. Okay. Yeah, go for it.
Question. Just Thank you very much, Chair.
Senator Henderson.
Thanks, Chair. Just a clarifying question. Can I understand why did the Commission conclude that a temporary exemption sought by the Lesbian Action Group did not justify accommodation of sex-based association rights under the Sex Discrimination Act?
I would have to refresh myself on the decision in that matter, Senator, to come up with to refer to the reasons for why that was refused in that situation.
You don't recall?
It was a detailed decision. It was not just one line decision.
Well, could you just perhaps explain, based on principles, why the temporary exemption sought by the Lesbian Action Group?
I'd have to take that on notice, Senator.
And is that the stand of the Human Rights Commission going forward? So if another lesbian group was to make an application for an exemption, what would be the position of the Human Rights Commission?
Each exemption,
I'm just trying to understand why.
Each exemption application will be dealt with individually, case by case. There isn't a uniform position.
So what guidance would you give groups like the Lesbian Action Group, which is seeking to have their own events, to protect the right for them to gather based on biological sex, lesbian-born women? What advice would you give, or guidance does the Human Rights Commission provide to those sorts of organisations? Are you now, I mean, obviously your decision was overruled effectively. Have you now reconsidered your position in relation to lesbian women, for instance?
We don't have a position, as I referred to previously. We would consider each application on a case-by-case individual basis, and we would refer anyone who was coming to the Commission seeking an exemption to our guidelines, and as they will be updated.
Have you got any
Thank you,
applications?
Senator Henderson. Senator Cash.
Thank you. Have you got any applications? Are there any applications on foot for special exemptions for biological woman groups that you're considering?
I'm unaware of whether there are or there aren't. I'd have to take that on notice, Senator.
Okay. If I was to look at now what's actually happened in terms of what's being called the definition void, the Sex Discrimination Act does not define man or woman at this point in time, and that now appears to have caused problems. So if you go back to 2019, when the Gillard government amended the Act, it removed the biological definitions of man and woman from Section 4 and inserted gender identity as a new protected attribute. There are also other flow-on effects, as you know, so it changed references from opposite sex to different sex. The result now at law would appear to be that the Act no longer contains any definition of what a man or a woman actually is, because we removed the biological definitions of man and woman. You now have the word woman appearing throughout the legislation, and in fact you yourself in your submission in the Tickle and Giggle case, for example, in relation to the pregnancy provisions and the fact that transgender women, biological men, may wish to have the pregnancy provisions or the potential pregnancy provisions, protections extended to them, etc. So the case of Tickle and Giggle has now filled that vacuum in plain English by ruling that at law, I think we established this when we all sat down today.
I've just, I've been watching this online. I've been sitting here, and these long statements are not a substitute for a question and not a substitute for a question. You can tell it's a question because there's a rising inflection at the end of a fairly short statement. This is not a question. It's just like another lecture.
No. I'm
Thank you,
summing
Senator
up
Shoebridge.
what I believe the current status of the law is.
Thank you, Senator
That's
Shoebridge.
what I'm actually doing.
I have already made a comment to the committee about long preambles into questions. So I have already noted that that is not what I want to see continue. But Senator Cash, if you can please ask your question.
Thank you, Chair. Look at the Tickle and Giggle case. It's filled that vacuum by ruling that sex, and I think you said this up front, is changeable and not necessarily binary, meaning that a biological man with an amended birth certificate, for example, can legally be treated as a woman under the Act. Is that now where we literally are in terms of what your role is as the Sex Discrimination Commissioner in applying the law?
I'm sorry, Senator, I'm not sure which bit of that is the question. So could you please repeat the question itself?
Definitions of man and woman in 2013. It has now had flow-on consequences to the Act, and that has now become the crux of the problem.
The previous definition of woman did not include, before 2013, any reference to biology, so that is incorrect. And our current state of the law in relation to sex I referred to earlier. There are 3 characteristics that a court will look at to decide sex. That is biology, physical characteristics, how the person is perceived socially and how they perceive themselves.
And
Those
then you
are the
have
3
the gender identity.
Gender identity.
Which is the protected attribute within,
Correct.
is it Section 7B?
That's correct.
So the change didn't take biology out, it put it in as one of the characteristics, the exact opposite of what Senator Cash has been saying.
It removed the definitions of
Good
man
grief.
and woman.
Thank you,
from the
Senator
Act.
Shoebridge. If that concludes your questions, I'm very happy to move on.
I think we're an hour behind now.
Yeah, that would be
Understood.
We're about a century behind from what I heard.
unhelpful interjections, Senator Shoebridge. But that does mean that we are now in a position to release you, and thank you for your time here this afternoon and for the really important work that you do. We will now take a very short suspension while we welcome our next witnesses. Thank you. I will now resume with the National Anti-Corruption Commission. Commissioner, would you like to begin with an opening statement?
I've provided an opening statement to the committee and I'm content to incorporate it by tabling it, except for the last paragraph, which I do wish to express on the record.
Please.
And in that, I'd like to...
Sorry, we're just checking. I'm not sure if we've been provided a copy of that. The Secretariat's...
I'm told you have been.
It was emailed.
Okay, let's chase... do we have... maybe the Commissioner can read the opening statement while we're tracking a copy down.
Here if we want to...
If you want to read it into Hansard, that's fine.
Yeah, if we can table it.
The Secretary don't need it.
If there's anything worth saying, I'm happy for it to be said.
You might have to read it out. Yeah, if you can read the last paragraph, we'll get copies of it. I'm not sure what's happened in the back end, but we can have that tabled. If you want to read the last paragraph, that would be helpful.
What I did want to place on the record was my deep appreciation for the support and contribution of the Deputy Commissioners, the Chief Executive Officer, the General Managers and the committed and diligent staff of the Commission who work tirelessly in the interests of the Australian people.
Thank you very much, Commissioner. We will proceed to questions and we'll begin with Senator Shoebridge.
Thanks, Chair. Commissioner Brereton, you resigned yesterday, was that right? Or you gave your notice of resignation yesterday?
I submitted my resignation yesterday with effect from the 6th of July.
Yes. And can you explain to me how you did that? How did you submit your resignation?
I sent a letter to the Governor-General.
All right. And did you email it across?
I did.
Have you got a copy of your letter of resignation?
Not with me.
Can you provide a copy to the committee?
I'll take that on notice, but I presently think probably yes. I just want to see whether there are any confidentiality considerations.
Well, it's an important matter of record, the resignation of the first National Anti-Corruption Commission. I don't understand your reticence about providing your letter of resignation that you gave to the Governor-General to surrender your statutory position.
Because it's a communication by me to the Governor-General, and before I disclose a communication of that kind, I would like to consider whether there is any confidentiality about it. As I've said, I think there probably isn't.
How could your resignation to the Governor-General be confidential?
It probably isn't, but
You only sent it yesterday, so
yes.
Is it or is it not confidential?
Senator Shoebridge, I think the Commissioner has indicated that it sounds like he is going to be able to provide that, but he wants
That's not what I'm hearing.
He wants to have a look at it and see if there's any personal information there that he might not be happy sharing. So I think that it is fair and reasonable for the Commissioner to take things on notice. I think that is standard practice for the committee.
Of an email that he sent yesterday, of an important document, which is a letter of resignation to the Governor-General, which was only sent yesterday. If there is, this witness would surely know the contents of an important document like that he sent to an important officer like the Governor-General yesterday. And I'm exploring what, if any, possible reason there could be for resistance to produce that. I'm entitled to do that.
Yes, you are entitled to do that. I'm letting you know, reminding you that the Commissioner has taken the question on notice, which he is entitled to do.
Well, I recall your opening statement this morning about the circumstances in which officials are entitled to take questions on notice. Mm-hmm. It's when they're unable to answer it with the material or information they have before them today. Are you unable to tell us, Commissioner Brereton, whether or not your letter of resignation that you sent to the Governor-General yesterday contains personal information that you don't want to disclose? Are you unable to tell us that?
I do not have the letter with me. Before I produce it to the committee, which I am inclined to think I will be able to do, I simply want to check whether it contains personal information that should not be disclosed.
Senator Shoebridge, just before you go to your question, I just want to table the opening statement.
Did you send any other correspondence yesterday relevant to your resignation?
I did.
What was that?
I sent a letter to the Attorney-General.
Will you provide this committee a copy of the letter that you sent to the Attorney-General yesterday about your resignation?
I think I will be able to, but again, I know it contains some personal information and I want to consider whether that should be provided or not.
Does the personal information relate to the reasons you gave for resignation?
Marginally, yes.
Why did you resign?
I refer you to my statement.
Well, with all due respect, Commissioner, you have an obligation to answer the questions. And I'm going to ask you again, why did you resign?
I refer you to my statement.
Well, let's go to your statement. Is it where you say the ongoing focus on matters relating to me personally, rather than the Commission's work, is drawing attention away from the Commission's core purpose of strengthening integrity in the Commonwealth public sector, which has always been my primary focus as Commissioner? Is that the element of the statement you're referring to me to give the rationale for your resignation?
That and the following paragraph.
Well, what is it in the following paragraph that I should have regard to?
The whole of it.
I believe that the Commission's success is paramount and not due to any single person. While I will continue to resist any suggestion of impropriety, I've decided that it is time now that the Commission is established and functioning with quality staff and good processes to step aside and allow a new Commission to lead it into the next phase of its development into a key and respected component of the integrity architecture of the Commonwealth. Is that what you're referring to?
I said I was referring to the next paragraph. That is the next paragraph, which is followed by I have therefore, which demonstrates that that is my reason.
Well, if you have a document that has I therefore, would you provide it to the committee? Because I'm going off the documents you've published on the National Anti-Corruption Commission website, and it doesn't conclude in that way. So
well,
if you have
I'm going off my opening
to
statement to the committee.
I beg your pardon?
I'm reading from my opening statement to the committee.
Sorry, so are your reasons for resignation contained in the statement that was published yesterday, or is it contained in the statement that you've just given to the committee that obviously...
They are the same, except that the statement I have provided to the committee today is in I think, a slightly different sequence.
All right. When you say the ongoing focus on matters relating to me personally, what are you referencing there?
I'm referencing the ongoing interest in essentially my defence connections.
Well, that's not you personally. That's your professional career. It's the work that you've been doing with the elements of the defence establishment while holding your position as a NAC Commissioner. Is that what you're referring to?
Senator, what I am referring to is that I have become a distraction. Every time the Chief Executive Officer comes up here, he has to answer questions about me. The press attention is focused on me and my interests. That is, the need to defend that has become a distraction, and that is basically why I have decided that it is in the interests of the organisation that I remove that distraction.
Do you accept any responsibility for that?
I think everyone contributes to their own downfall, if you like, in some ways, and I'm sure I have contributed to this in some ways.
Well, do you accept that the fact that your Chief Executive Officer has had to come and give repeated corrections to evidence that he's given to this committee because of information you hadn't provided to him in a timely manner, do you accept responsibility for that?
I object to the question, Chair, because it misstates the position. I believe the Chief Executive Officer has made one material correction, not repeated.
Do you accept responsibility for that, Commissioner?
What happened in that situation was that when the issue about my ongoing assistance to the IGADF first arose in the press, I made a passing comment to the Chief Executive Officer to the effect, it's not as if I am doing or I'm taking time off from here to do that. When the matter arose here and the Chief Executive Officer did not know what questions would be asked and we had not discussed answers to them, he gave the perfectly reasonable answer that he did, to the effect that I wasn't doing it during NAC hours. Much later, when we dug into my defence, or when I accessed my defence account late last year, I think, and went through every email and ascertained exactly what time I had spent on it, I identified that something less than, I think, I don't have the precise figures with me, but less than 10 of the less than 30 hours that I have spent doing that over the last 3 years were done between the hours of 9 and 5 on a weekday, and that was almost entirely in the first 6 months of the NAC.
Do you accept responsibility for not telling your Chief Executive Officer that you'd done 10 hours of work for defence during work hours with the NAC?
No,
and do you
I
accept responsibility for not telling your Chief Executive Officer about the fact that you had that ongoing role and you were doing the ongoing work for defence? Because you didn't tell him either of those things, did you?
No.
Do you accept responsibility for that?
No.
Do you understand the need?
The Chief Executive Officer has no business to know what I was doing for defence on a voluntary, ongoing basis. He knew, because I disclosed to all of the statutory officers, that I had an ongoing affiliation with the IGADF, and he knew that I would not be involved in NAC matters involving the IGADF. Beyond that, he had no need to know exactly what I was doing for the IGADF for those less than 30 hours in 3 years.
Well, you see, Commissioner, this exchange is highlighting the problem, isn't it? The problem that you had about not being transparent, about not recognising the need to be transparent, particularly when you're performing work for the defence establishment when a significant customer of the National Anti-Corruption Commission that you're leading is defence. This exchange proves the problem about even now you can't accept the obligation to be transparent as the head of the NAC.
I have an absolute acceptance of the obligation to be transparent about things that are relevant to my functions. I was transparent about having an ongoing affiliation with the IGADF and that I would not be involved. Neither the Chief Executive Officer nor others needed to know more than that.
Yes.
Nor do they need to know whether I go to church on a Sunday, or if so, what church I go to, or whether I play cricket or rugby on a Saturday, and which brand of rugby it might be.
You see your false conflation that you just did then about whatever your religious activities might be, with your professional ongoing engagement, providing advice to entities inside the defence establishment. Your false conflation then does you no credit. You can't see the difference between going to church and performing professional work relevant to your professional capacity for the defence establishment. The fact you can't see this is just highlighting why the public has lost trust in you.
Have you finished?
Do you not accept that? That trust deficit that happens when you do this?
Senator Shoebridge is asking a question of the witness and not allowing Commissioner Barrington to even provide an answer, but keep ranting at him.
Do you not accept that trust deficit, Commissioner, because of statements like that?
Do I not accept what?
When you continue to say that there's nothing to see here, and you make false comparisons about your attendance at church with your professional work with the defence establishment, when you make a false comparison like that, treating apples with oranges, can you not see how that erodes trust in your decision making? If you can't determine the difference between a conflict of interest you might have going to church compared to a conflict of interest you have working for defence. You can't see the difference?
In circumstances where I have said that there is, and disclosed to everyone, that there is an ongoing affiliation, the precise nature of what I am doing is beside the point. What is relevant is that there is a relationship. I declared that there was a relationship. That was known to all the statutory office holders, and that's what was relevant. The precise content of that relationship is not.
All right. Well, we'll just have to agree to disagree. Could I ask you about the ongoing investigations being undertaken by the inspector of the NAC? What's your understanding of where those investigations are, noting that the inspector has advised us they relate to a number of matters pertaining to your conduct as the NAC Commissioner? What's your understanding of where they're up to?
I am aware that the investigation is ongoing and is incomplete, and it is inappropriate to comment further on the status of an ongoing investigation.
Have you been provided with a draft copy of the inspector's report for comment?
No, I have been provided with the inspector's draft report, which is quite a different thing to a draft copy of the final report for comment.
So you've been provided with a draft copy of the inspector's report for comment, is that right?
No, I've been provided with the inspector's draft report. The draft report is a standard and confidential part of an investigatory process, and the purpose of that is to test hypotheses, and it is provided before the other side has had a hearing. In response to that draft report, submissions are made. The final report might turn out to be very different from a draft report.
All right. Well, I don't want to get into some policing of language. We will call that document the inspector's draft report. You understand the document we're referring to, the one you just described?
I believe so.
Yes. When did you receive the inspector's draft report?
I think on the 19th of March.
The 19th of March. And when did you make, I assume you made submissions in response to the inspector's draft report?
The submissions were made on behalf of the Commission. But
did you have a role in drafting those submissions?
I had a role in, amongst others, in providing instructions for them.
Were they done by external lawyers or were they done by the internal staff inside the NAC?
They were done by external lawyers.
Which lawyers did you engage?
Mallison Stephen Jakes and counsel.
And maybe you know the answer to this, Chief Executive Officer. What is the cost of the legal retention of Mallison Stephen Jakes to respond to the inspector's draft report?
So as it appears on AusTender, the contract value for Mallison's was $204,000.
And is that for the purpose of responding, the brief that Mallison's have is to respond to the inspector's draft report, is that right?
Yes.
When were the submissions provided to the inspector, or submission, if there was only one?
The 21st of April.
Is there a further timetable for response? Did the inspector provide a timetable for response?
There have been a number of things that have happened since then, which it is inappropriate to discuss in the context of an ongoing investigation.
Well, have you been provided with any further iterations of the inspector's report?
Yes.
And when were you provided with the further iteration of the inspector's report?
On the 30th of April.
And is that the final iteration that you've been provided with?
I don't know.
What do you mean you don't know?
I don't know whether it will be the final report or not.
Has it been to date? Have you received any further iteration since the 30th of April?
Iteration.
That is the latest. Was the inspector's draft report either as at the 30th, was it still described as a draft report as at the 30th of April? Or was it in its final form?
It is inappropriate to discuss in this way the detail of the progress of the inspector's investigation because that may compromise the further or the finalisation of that investigation.
Well, you were able to tell us that the document provided to you on the 21st of April was a draft report. I'm now asking whether the document provided on the 30th of April was also a draft report. If you can describe it with comfort for the 21st of April, please explain why you can't do it for the 30th of April.
What I can say, Senator, is that further submissions have been made since that was provided, so I do not know.
How have the submissions, were they in response to alternate drafts or to amendments in the draft report?
I have tried to go into as much detail as I reasonably can and as to be as helpful as I can about an ongoing investigatory process. At this point, it is not appropriate to discuss further an investigatory process which is currently on foot.
Well, you see, Commissioner, the inspector has previously made a very damning report about your conduct, describing the officer misconduct, which led to an extreme amount of money that had to be spent by the public to refer out the robo-debt scandal. You remember that critical report that the inspector handed down in relation to your conduct?
I remember very well that the inspector reported that I had made an error of fact or law which meets the definition of officer misconduct, given the very wide definition that any error of fact or any error of law amounts to officer misconduct. We now have a commission in which staff are terrified of making any mistake of fact or law because they fear they will be visited with a finding of officer misconduct. I do not accept, I also do not accept the second part of your question, which is that it led to a vast amount of expenditure. Don't point at me, please.
I'm not pointing at
you. To a vast amount of public money. Had I not been involved in the robo-debt matter at all from the outset, we would have set up a very similar, if not identical, structure to conduct that investigation at a very similar, if not identical, cost.
You see, nowhere in your statement about your resignation or in your statement that you've provided to the committee today do you mention the existence of the ongoing investigation by the inspector or your knowledge of the inspector's draft report?
Commissioner, sorry, before you respond, I'll let Senator Shoebridge ask his question and then I will be rotating the call.
Yeah. Was the content of the inspector's draft report and the potential for adverse findings against you, was that material in your decision to resign?
No, the content of it was not at all material in my decision. What was material was that I have been under investigation in one way or another for the best part of the last 2 years, and when I sat back and reflected on where we were after 3 years, I also reflected on the fact that history is the best indicator of the future, and that if that was going to continue for another 2 years, that was not going to be in the Commission's interest. So the fact of having been under investigation and being distracted from doing the job that I wanted to do as Commissioner by the need to defend myself and by the NAC needing to defend myself, That's why I decided to resign.
It was
not
your
because-
repeated failure to
Senator
identify
Shoebridge.
conflicts
Senator
of interest.
Shoebridge, I'd
wasn't it?
indicated that I'm going to share the call. I'm going to do that now. Senator Henderson, you have the call until we go to the dinner break at 6:15.
Thank you very much, Chair. Look, I just want to firstly go to the Deputy Commissioner, Ms Rose. Ms Rose, you have also resigned and you didn't give much away in your statement of resignation. Have you resigned because you have lost faith in the Commissioner?
No, thank you, Senator. No, I resigned entirely because of an opportunity that my family has been given to move overseas, and that started to be something that we considered in January, and it was only confirmed in late April, which is when I resigned to the Governor-General on the 21st of April. So no, Senator, that's a long way of saying it was entirely a personal decision.
Okay. Thank you very much, Ms Rose. Commissioner, you have said that criticism of you was distracting from the Commission's mission. If the concerns were not serious, and I note you say that you will continue to resist any suggestion of impropriety, why was your resignation so necessary?
Because, as I have said, it is a distraction. I have had to spend personally an undue share of my time in defending myself. More importantly than that, the Commission has had to spend an undue share of its time in defending me, and that is preventing both of us from doing our work, regardless of the particular nature of the allegations.
Do you believe the government has lost confidence in you as the Commissioner?
No, I don't believe that for a moment.
Did the Attorney-General...
I've heard nothing but expressions of support and confidence from the government.
So the Attorney-General has not indicated any reservations, no other indication from any member of the government that they no longer have confidence in you?
None whatsoever, Senator.
Have you at any point accepted that your own conduct fell below the standards expected of the head of the Commonwealth's anti-corruption body?
No, I do not. I have said earlier that I accept that I have in some way contributed to this outcome, but I do not accept that my standards have in any way fallen below an appropriate standard.
Sorry, Senator Henderson, just before you continue with the questions, I will remind members in the gallery that it is not appropriate to take photos of this session, and you need to seek permission of the committee to do that. So I'd request you delete any photos that you've taken of proceedings without consent. Thank you, Senator Henderson.
And that includes recordings as well,
And
Chair.
that absolutely includes recordings. Anything that you've taken on your device without the express consent of this committee is not allowed. Thank you, Senator Henderson.
Commissioner, the NAC inspector has previously found officer misconduct, as you've just discussed, in relation to previous handling of conflict of interest matters. What lessons did you learn from that finding? Do you accept that you could have done things better?
I accept that with the benefit of hindsight, I should have it would have been better not to have anything to do with that matter. Now, I've given reasons previously to the Parliamentary Joint Committee and publicly why I took the course I did. I think views can differ over that, but I accept with the benefit of hindsight, obviously, it would have been better to have nothing to do with that matter.
You haven't disclosed all of your conflicts of interest in relation to your work with the IGADF.
What do you mean by that?
Including, well, I'm talking about to the Attorney-General. So do you, reflecting on the way in which you, and I have, as a member of the committee, raised concerns about these conflicts of interest, do you regret the way you've managed this particular issue? And with the benefit of hindsight, do you regret that you didn't properly disclose those conflicts of interest?
as you know, because I have previously given you this answer in a different place, I disclosed to the then attorney before my appointment, and the then attorney recorded in a letter the fact that I had disclosed my intention to continue to provide occasional, informal, voluntary assistance to the IGADF in connection with matters arising out of the Afghanistan inquiry report. I do not think that could have been handled any better or differently because it was laid on the table at the time and it was noted in my letter of appointment.
Except you have subsequently accepted that there was a conflict of interest and that it was appropriate.
I accepted that there was
Sorry, Commissioner, if I could just finish my question. You subsequently accepted that there was a conflict of interest and that was appropriate that you no longer participated in defence-related matters because there was an inherent conflict of interest. And I would put to you that the former Attorney-General was quite wrong in approving your work, your ongoing work with the IGADF, but more importantly, this was a conflict of interest that you should have recognised and never taken on that work in the first place.
Well, it's not for me to answer on behalf of the former attorney, but I would not accept the proposition you put in that respect. In any event, it was recognised from the very outset that there were going to be conflicts. I have a long history with the Defence Force. Of course there were going to be conflicts, and presumably this is for show because you've heard all of this before, but that long history meant that there were always going to be conflicts that had to be managed. This wasn't something that I've now realised. It was realised from day one, and they were managed by me stepping aside from matters in which persons who I knew through defence had an interest.
Commissioner, I know we've only got a very brief amount of time.
You've got 5 seconds to ask your question.
My
Senator
final question before we go to the dinner break is, given the inspector is now investigating further allegations of misconduct by you, and there's been the draft report handed to you, can I ask whether we can infer that she has made an adverse finding against you in her draft report?
It would be totally inappropriate to speculate about the contents of any draft report pending a procedural fairness process.
I'm not speculating, I'm just asking, is it reasonable for us to make that inference?
You're asking whether you can infer something. That is speculating, and it's inappropriate to do so.
Thank you, Senator Henderson. Thank you, Commissioner. It now being 6:15, we will take the scheduled dinner break and we will return at 6:45.
you.